4 PM ಯಾವ್ದದು? Let it come after vacation. Yes. Urgency ಏನಿಲ್ಲ. Tomorrow bench is, I don't know. Yes. Move the vacation bench. 2:30. 2:30. Right, tomorrow. Tomorrow after the bench, I don't know at what time. Yes. Pending matter. Don't give pending, sir. Give it. Yes. Don't give pending matters at all. Yes. ಅಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಕೊಡಿ. ಆಯ್ತು 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 ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ತಾನೆ? ಆಯ್ತು. ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. 2:30 ತಗೊಳ್ಳಿ. ಎಸ್. ಒಂದ್ ಸಾಕು. ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಏನ್ ಅರ್ಜೆನ್ಸಿ? ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ತೊಂದರೆ ಆಯ್ತು. 498 ಯಾರು ಬೇಕಾದ್ರೆ ಅಷ್ಟೇ ಕೊಡಿ. ಎಸ್ ಎಸ್. ವೈ 2:30? Okay, what's more the vacation months? Yes. ನಾಳೆ ಇದೆಯಾ ಕೋಕ್ಯೂಸ್? ಆಯ್ತು ಕೊಡಿ. More the vacation bench. Yes. So what? Yes. More the vacation bench. Yes. More the vacation bench. Framing of charges. ಯಾವತ್ತು? 2:30. Yes. ಎರಡೆರಡು ಬೇಡ, ಒಂದೇ. Which one you want? The two will not take. Which one you want? ಕೊಡಿ ಅದು. Yes. 2:30. ಮುದ್ದು ವೆಕೇಶನ್ ಬೆಂಚ್. ಏನ್ ಪರವಾಗಿಲ್ಲ. ಬೇಲ್ ತಗೊಳ್ಳಿ. ಬೇಲ್ ಇರೋದೇ ಅದಕ್ಕೆ. ಎಸ್ ಎಸ್. give it. Yes. Tomorrow I don't know because bench ಇದೆ. Yes. ಅದು ತಗೊಳ್ಳಿ 2:30ಗೆ. Yes. Move the vacation bench. Yes. So what, sir? Move the vacation bench. Yes. ಪರವಾಗಿಲ್ಲ ಸರ್. No problem. Yes. You will not have this problem after vacation. Don't worry. Yes. ಏನ್ ಬೇಡ, ಅದು move the vacation bench. ನಾಳೆ ನಾಳೆ ತಗೊಳ್ಳಿ. 2:30. Yes. Give that. 2:30. Framing of charge. When tomorrow, if no evidence to that effect is there, I'll adjourn it by 10 weeks. If both of you are telling her, 1 minute, madam, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರೆ ನೀವು ಹೇಳ್ತಾ ಇದ್ರೆ ಹೆಂಗೆ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಕೊಡಿ. 2:30. ಎಸ್. ಏನ್ ಹೇಳಿ ಈಗ? ಆಲ್ರೆಡಿ. ಆಲ್ ರೈಟ್. ಎಸ್. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ಅದು ಕೊಡಿ 2:30. ಎಸ್. ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು. ಲಿಮಿಟೆಡ್ ಸ್ಟೇ ಕೊಡೋದೇ ಇಲ್ವಲ್ಲ. ಯಾವ್ದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು? ಕೊಡಿಲ್ಲ ನೋಡಿ. 2:30ಗೆ ಹಾಕ್ಸಿ ಮೇಡಮ್. ವೆಯ್ಟ್ ಆಯ್ತಲ್ಲ ಈಗ? ಎಸ್. ಪರವಾಗಿಲ್ಲ. ಎಸ್. ವೈ? No problem. Move the vacation bench. Yes. Move the vacation bench. Yes. Husband and wife problem? ಮತ್ತೆ? Two 2:30. Yes. 2:30. Yes. 2:30. Move the vacation bench. Settlement ತಗೊಳ್ಳಿ. Yes.
ಎರಡುನಾ?
ಇಲ್ಲಿ ಬರಲ್ಲ ಸರ್ ಅದು. Yes. It won't come here. Yes.
4 weeks.
Move the vacation bench. ಅಲ್ಲ ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ? ನಾಳೆಗೆ ಹಾಕಿ. Yes. No. ನಾಳೆ. Yes. ಪರವಾಗಿಲ್ಲ, ಸಾಯಂಕಾಲದವ್ರು ಮ್ಯಾನೇಜ್ ಮಾಡಿ ಪೊಲೀಸ್. Yes. ನಾಳೆ. Yes. ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ. Yes. ಪೋಸ್ಕೋ ಅಂದ್ರೆ ನಾನು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ, ಪೋಕ್ಸೋ ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. ಹಾ, ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ಎಸ್, ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ, ಅವ್ರು ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರುತ್ತೆ. ಎಸ್, 2:30. ಎಸ್, ಇವತ್ತು ಬೇಕಾ? ಹಾ, ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ. ಗಿವ್ ಇಟ್. ಎಸ್. ವೈ, ವಾಟ್ಸ್ ದ ರೀಸನ್ ಟುಮಾರೋಗೆ? ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ನೋ ನೋ ನೋ, 1:38 ಎಮರ್ಜೆನ್ಸಿನೂ ಇಲ್ಲ. ಎಸ್, ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಹೂಸ್ ಮಿಸ್ಟೇಕ್? ಅವ್ರು ಕೇಳಿಸಲ್ಲ ಬಿಡಿ, ತಗೊಳ್ಳಿ ಮೇಡಮ್. ನಂದೇ ಮಿಸ್ಟೇಕ್ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ. ಸರ್ ಅದು ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ ಸರ್ ಪ್ಲೀಸ್. ಹಾ, ಮಂಡೇ 2:30. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ಗೆ ನೋ ಪ್ರಾಬ್ಲಮ್. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. Move the vacation bench. Yes. Next. So tomorrow. Move the vacation bench. Yes. No, Somana. Nothing. ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ. ಎಸ್, ಕೊಡಿ. ಹಾ, ಕೊಡಿ 2:30 ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ. ಹಾ, ಸರಿ, ನಾಳೆ. ನೋ ಸೋಮಣ್ಣ, ಮೂವ್ ದ ವೆಕೇಶನ್. ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ವಾಟ್ ವಿಲ್ ಬಿ ಫ್ರೇಮ್ಡ್? ಇಶ್ಯೂಸ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್. ಚಾರ್ಜಸ್ ಕೊಡಿ. 2:30. Tomorrow. Tomorrow I don't know, after the bench ಅಷ್ಟೇ. Yes, ಕೊಡಿ. ನೋ ಅರ್ಜೆನ್ಸಿ. ಎಸ್, 1:38 ಏನಾಗಲ್ಲ. ಎಸ್, 1:38. 1:38 ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ಯಾಕೆ ಹೋಗಿಲ್ಲ ಕೋರ್ಟ್ಗೆ? ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ನೋ ಸರ್, ಟುಮಾರೋ. ಎಸ್, ಕೊಟ್ಬಿಡಿ, ಮೆಮೊ ಇಲ್ಲ. ಇರೋದು ಒಂದಿನ ಸರ್, ಇನ್ನೇನಿಲ್ಲ, ಕೊಡಿ. ಈಗ ಏನ್ ಯಾವತ್ತಿಗೆ ಬೇಕು? ಕೊಡಿ, 2:30 ಕೊಡಿ. ಗಿವ್ ಇಟ್ 2:30. ಎಸ್, ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್ ಸರ್. ಆಯ್ತು, ಕೊಡಿ. ಓಕೆ, ಗಿವ್ ಇಟ್. ಎಸ್, ಟುಮಾರೋ. ಗಿವ್ ಇಟ್ ಮೇಡಮ್. ಎಲ್ಲ ನಾಳೆಗೆ ಬರ್ತು ಕೊಡಿ. ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ, ನಾಳೆ ಕೊಡಿ. ಆಯ್ತು, ಕೊಡಿ ಸರ್. ನಾಡಿದ್ದು ತಗೊಳಕ್ಕಾಗತ್ತಾ? ಇಲ್ಲ ತಾನೆ? ಸರಿ. ಎಸ್, ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ. 2:30 ತಗೊಳ್ಳಿ. ಅದು 498 2:30 ತಗೊಳ್ಳಿ. ಕೊಡಿ, 2:30. ಎಸ್, you finished all the courts and came here. I won't take it. Yes. ಕೊಡಿ ಸರ್ ಎಲ್ಲ. give the memo. Tomorrow ಇರೋದು only one day, give it. ನಾಳೆ ಕೊಡಿ ಎಲ್ಲ. Please give it for tomorrow, madam. Yes. ಇರೋದೇ tomorrow, sir. ಕೊಡಿ, ನೀವು ಕೊಡಿ sir. Where is that lady? She went away. Madam, give it. Yes. Why? Complainant? You are the complainant. Husband. She is dead. ಏನ್ 304 ಬಿನ 306 ಈಗ? ಬರೀ 498. ಆಯ್ತು, 230 ಫ್ಲವರ್ಡ್. ಈ ಕೊಟ್ರಲ್ಲ ಒಂದು, ನಾಳೆ ಕೊಡಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬೇಕಾ? ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬೇಕಾ, ನಾಳೆಗೆ ಬೇಕಾ? ಕೊಡಿ, ಕೊಟ್ಬಿಡಿ, ಮೆಮೊ ಕೊಟ್ಬಿಡಿ. ಎಸ್ ಕಾಲ್ ದ ಕೇಸಸ್. ಕೊಡಿ ಮೇಡಮ್, ತುಂಬಾ ಹರಾಸ್ಮೆಂಟಾ? ಕೊಡಿ. ಎಸ್ ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲಿಗೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲರೂ. ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ದಿ ಮೆಮೊ. ಎಸ್, ಫಸ್ಟ್ ಕೋರ್ಟ್ ಇದೆನಾ? ಏನ್ ಹಾಕ್ಬೇಕು? ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದೆ? 138 ಮತ್ತೆ ಎಲ್ಲ ಒಂದು ಮೋದಿ ವೆಕೇಶನ್. ಎಸ್, ಅದ್ರಲ್ಲಿ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ. ಎಸ್, ಟುಡೇ ಇಲ್ಲ, ಟುಮಾರೋ. ಎಸ್ ಗಿವ್ ಇಟ್. ಕೊಡಿ, ನೀವು ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ಬಿಡಿ ಸರ್.
With a kind leave. With the kind leave of your lordship.
ಮೇಡಮ್. ಎಸ್, ಧಾರವಾಡ ಬೆಂಚಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಕಲಬುರ್ಗಿ, ಇದು ಬೆಂಗಳೂರು ಬೆಂಚ್ ಸ್ವಾಮಿ.
Wait madam, adjournment when the matter is
My
called.
aunt
Call
is
the cases.
hospitalized ಅದಕ್ಕೆ.
All right, I will grant, but mention when it is called. Yes.
List 1, fresh matter still number 1.
No representation way of the petitioner. The petition appears to have been preferred on a mistaken ground that the cognizance has to be taken within the period of limitation as obtaining under section 468 of the CRPC. However, issue notice to the respondent. Next.
Number 2,
Yes.
Some time error records.
Anticipatory bail ತೀರ್ಮಾನ ಮಾಡೋಣ ಕೊಡಿ. ಯಾವ್ದು ಮುಗಿಸ್ಬಿಡ್ತೀವಿ? ಎಸ್, ಅದು ಯಾವುದು ಸರ್?
That is 9138 and
One nine-
9374.
9138 and
9374.
that is 2.1, 2.2 allowed anticipatory bail granted. ಎರಡರಲ್ಲಿ ಇನ್ನೆರಡು ಆಮೇಲೆ ಕೇಳೋಣ ಆಫ್ಟರ್ ವೆಕೇಶನ್. 9ಕ್ಕೆಲ್ಲ 16ಕ್ಕೆ ಹಾಕೋಣ ಸರ್.
ವಿಪರೀತ ಇದೆ 9
ಅದಕ್ಕೆ 16ಕ್ಕೆ ಹಾಕೋಣ.
ಅಥವಾ 16th
ಅದೇ 16ಕ್ಕೆ 16th ಹಾಕೋಣ. ಎಸ್.
Right.
number 3,
ಎಸ್, ಗವರ್ಮೆಂಟ್
ಇದರಲ್ಲಿ
ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ, ಟು ಹಿಯರ್ ಯು ಅಂತ ಅಷ್ಟೇ.
is the record, my lord.
354C.
Yes, my lord.
But it has happened 10 years ago.
Need some time, my lord, because I believe
For
that.
over 10 years ago.
Alala. They have appointed a special public prosecutor for all these cases.
ಯಾರು ನಿಮ್ಮನ್ನ?
Alala.
Huh.
Pradeep.
Oh.
AG.
All right, get him.
His name is, he said that his order is they have moved it to the.
But 2013.
I'll place the record, my lordship may see that record,
Okay.
my lord, then.
ಅಲ್ಲ, ಈ ತರ 10 ವರ್ಷದ ಬಿಟ್ಬಿಟ್ರೆ ಅಷ್ಟೇ.
Place
ಅಲ್ಲ,
the series and-
whether it is this man or that man,
That's correct.
10 years ಆದ್ಮೇಲೆ if you file a complaint for 354C,
But he speaks about the continuation of.
what continuation up to 2023?
That's
Early the
exactly.
continuation, it
In
speaks
fact, it
only of
says-
2013.
He says that, my lord, all these things he came to know only subsequently in 2024 when his own people who informed him that all these things he is the person behind it. That's-
Other allegations, charge sheet has already been filed.
ಯಾರು?
He is on bail, my
Patients.
lord, your lordship may have it on
That
January
has
1st
already
week, my
been-
lord.
That's all right. ಕೊಡಿ, records ಕೊಡಿ. List the matter on 9th. The respondents are restrained from taking any coercive steps in the matter. Pay the petitioner. Yes, records ಕೊಡಿ.
I place the record.
4,
Lords, in page 11 is the complaint. Lord, with the reference to withdrawal of the ration card, Lords, I have commented against the government. Lord, they have registered 192,353.
The petitioner is before this court calling in question registration of a crime and crime number so and so for offense punishable under section 192, 196 and 353(2) of the BNS, which is 153, 153A and 5052, sorry, of the BNS, which is 153, 153A and 5052 of the earlier regime, the IPC. A perusal at the complaint is indicative of the fact that the petitioner has only commented on the policy of the government qua the ration cards being pruned. Therefore, finding no ingredient of the offense that is alleged against these petitioners, there shall be this petitioner qua the, petition, there shall be an interim order of stay of further proceeding, further investigation. List the matter on 23rd January. Emergent, respondent error,
State.
both state. Additional SPP for both the respondents. Next.
Pray respond.
Huh?
Sumo.
Obrena, yes, ಆಯ್ತು.
Right.
ಯಾವ್ದಿದು? ಯಾವ್ದು ಮೇಡಮ್?
Serial number 3 ನಲ್ಲಿ madam.
ಅಲ್ಲಿ ಬರ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. The learned additional SPP has produced the original records and a sealed cover. The same is taken into the file.
Not original record, no, records.
Records and the sealed cover, the same is taken into the file.
CD.
ಆಮೇಲೆ ಒರಿಜಿನಲ್ ನಮ್ಮ ಹತ್ರ ಇದೆ ಅಂತ. Yes.
5,
Petition number. The only prayer, my lords, page 17.
Will direct the court to consider discharge and ಇದು 1 ವರ್ಷ ಆಗಿದೆ ಫೈಲ್ ಮಾಡಿ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Will dispose it. Yes.
Stay orders at page 25. You know,
What
that matter is listed at 25 today itself.
which one?
Page number 25, criminal
ಸ್ಟೇ
petition.
ಆಗಿದೆಯಾ?
Otherwise stay
ಸ್ಟೇ
ಆಗಿದೆ.
ಆಗಿದ್ರೆ ಮತ್ತೆ ಡಿಸ್ಚಾರ್ಜ್ ಕನ್ಸಿಡರಿಂಗ್ ಮಾಡ್ತಾರೆ.
In fact,
We'll take it
only,
along with 25 then.
uh,
We'll take it along with 25.
the order in that is, my lords, stay as far as A14 is concerned.
We'll take it along with
Please,
25. Yes.
Right.
I'll dispose this definitely. We'll take it along with 20. Two applications of yours are pending, 227 and 205.
Please.
Will direct, yes. Next.
6,
A petition number. Petition by accused number 16, my lords. Offenses are
Six, ನಿಮ್
16.
second list, sir. ಇದು first list ಅಲ್ಲಿ 6.
Apologies.
But after remind by your summons, my lords, annexed D.
ಅಲ್ಲ, ಈಗ ಮತ್ತೆ the
They are not,
detail order is not passed, nothing is appended.
Oh, my lords, please see the summons. Page annexed D,
This
page
court
28.
Had
Now.
in
they
between the
litigated-
same parties disposed the petition in criminal petition 7526 of 2024, directing action to be taken in accordance with law in terms of the observations made therein. The ಎಲ್ಲಿದೆ ಸಮನ್ಸ್ ಇದು annexure D.
Annexed D, page 28.
But
He
after
said,
the
I have filed a case against myself and I have been directed. to appear." Page 28.
order, the matter was remitted back to the hands of the concerned court to consider the observations and then pass necessary orders. Summons so issued pursuant to the order passed by this court reads as follows. It smacks blatant non-application of mind and deliberate contrary order being passed by the concerned court. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Emergent notice to the respondent. List the matter on 23rd. The petitioner is before this court calling in question proceeding registration of a crime for offense punishable under section 143 of the IPC and 103 of the Karnataka Police Act. Finding charge sheet ಆಗಿದೆಯಲ್ಲ?
ಅಲ್ಲ ಇದು pending before Supreme Court.
ಅದೇ ಗೊತ್ತಾಯ್ತು. Finding no allegations that would touch upon the offences so alleged against this petitioner, there shall be an interim order of stay of further proceedings qua this petitioner. The learned additional SPP submits that the order of the coordinate bench which was against the petitioner and the like is stayed by the apex court. Even otherwise, there are no allegations that would meet
Stayed
the
in their
ingredients of
favor.
the offences.
Stayed in their favor, madam. not
ಗೊತ್ತು,
in my-
stayed in their favor. ಸಿದ್ದರಾಮಯ್ಯ
Produced
ಅಂತಾನೆ
for
ಇದೆ.
us.
Yes.
140.
Chief Minister's order.
Please.
Dixit ಅವರು.
Please.
Even otherwise, what is there for 103 and 143 ಇದ್ರಲ್ಲಿ? Protest, sir. Already shown it. Yes, stayed. Next.
8,
Yes, it's last
The
week.
one HCG
Last
to
week.
emergent notice in the meantime. So Pradeep sir is back to the court. Yes, sir.
I just gave for some clarification.
ಗೊತ್ತಾಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ. He was now telling
Yes,
the appointed SPP for special public prosecutor for all these cases.
yes, yes.
Orders 9,
ಈಗ ಯಾವ್ದ್ರೆಲ್ಲ ರೆಡಿ ಇದ್ದೀರಾ?
Okay, ಒಂಬತ್ತಿಗೆ.
ಆಯ್ತಾಯ್ತು, ಒಂಬತ್ತು.
Ready.
Yes.
Sought for
Orders.
complete relaxation.
ಏನ್ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಮತ್ತೆ?
Because no,
ಯಾವ
complete
ದೇವಸ್ಥಾನಕ್ಕೆ
relaxation
ಹೋಗ್ಬೇಕು?
because all the accused, none of the
ಈಗ
accused.
ಯಾವ
have been-
ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ಬೇಕು?
ಇಲ್ಲ, ದೇವಸ್ಥಾನ ಇಲ್ಲ.
ಮತ್ತೆ?
There are two IAs. Earlier IA only for 10 days it was granted. Now
ಹಾ.
I sought for complete relaxation because for none of the accused this condition is there.
ಕಂಡೀಷನ್ ಇಂಪೋಸ್ಡ್ ಬೈ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್.
Please, that was at the investigation stage.
ಅದೇ ಅಲ್ಲೇ ಕೇಳ್ಬೇಕು ರಿಲ್ಯಾಕ್ಸೇಷನ್.
It was at the investigation stage.
ಏನೋ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ತೀರಾ ಅಂತ 10 days ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಸ್, ವಾಟ್ ಯು ಸೇ? ಲೆಟ್ ದಿ SPP ಕಮ್. ಇದ್ರಲ್ಲಿ ಅವರೇನಾ?
ನಾನು ಇದ್ದೀನಿ, ಅವರು ಇದ್ದಾರೆ.
ಸರಿ.
Can have it next week, my lord.
ಇದು ಒಬ್ರದೇ ಪ್ರಾಬ್ಲಮ್, ಇಬ್ರು ಬಂದು ನನ್ ಗತಿ ಏನಾಗುತ್ತೆ? Yes. 9.
ಆಗ್ಬೋದು.
ಈಗ ಎಲ್ಲಿಗೆ ರಿಲ್ಯಾಕ್ಸೇಷನ್, ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇಲ್ವಾ ನೀವು?
Around at least on 15
Mysore
days they
ಮತ್ತೆ-
could be given because during ರಜಾ ಎಲ್ಲ ಇರೋದ್ರಿಂದ she may go.
ವೆಕೇಶನ್.
Vacation ಅಂತ ಏನಿಲ್ಲ, but just on 15 days.
ನಾವು
Because for none of the accused this condition is.
ಅಲ್ಲ, now the
ಡಿಸ್ಕ್ರಿಷನ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಸರ್.
Please,
now the case has been the 376 has been committed to the sessions court.
376
One of, not in this case, this is the
sir,
kidnapping case.
that is in Prajwal Revanna's
Correct,
case,
the
not this.
original victim in this case.
This is the mother.
That's correct.
354 ಅಷ್ಟೇ.
Correct. Now case has been committed to special court.
Hmm.
Maybe the examination of that witness, my lord, will have a bearing impact on
We'll
this.
take it on 9th, we'll give you exemption. ಅವರೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ಲಿ.
10 days at least let it be there.
ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಹೇಳಿ?
ಎಲ್ಲೂ ಇಲ್ಲ, ಅವ್ರ ನೇಟಿವ್ at least ಹೋಗಿ ಬರೋದಕ್ಕೆ she is completely restricted. She from past 6 months it is there, and in fact this order, the stage was investigation stage ಅಲ್ಲಿ ಇದ್ದು.
Till 9th will permit. This court, answering an identical application on 28/10/2024, had passed the following order. The learned counsel of the petitioner has preferred an application seeking complete exemption, a complete relaxation of entry into the native district. That would be considered on the next date, i.e. the 9th of December, 9th of January 2025. In the meantime, the petitioner is granted relaxation of 15 days to be operational from tomorrow to enter the district and enter
Two districts.
enter in
Hassan
2
as-
districts, Mysore and Hassan.
Please,
Yes.
Let them not communicate with the victim.
that condition is always there. Other conditions are
Bail
there.
ಅಲ್ಲಿ ಇದೆ. It is made clear that if there is any violation of the conditions imposed while granting bail, the same would be viewed seriously.
Please.
Yes.
10,
Appear for the respondent.
ಹೇಳಿ sir.
That's cancellation of bail, my lords. We have engaged the services of the ASG.
Pass over.
Today is not available.
There's an inconvenience, my lords. Kindly have it.
ನಿಮಗುನ ಇವ್ರು ಇನ್ಕೂರೆನ್ಸ್ ಇದ್ದೇ ಇರುತ್ತೆ, ಯಾಕಂದ್ರೆ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Like, they have to file their reply.
Cancellation of bail can reply, sir.
They want to file
You
objection.
want to file?
I'll file objections.
The list on 16th, at the request of the council appearing for the petitioner, who petitioner as also the council for the respondent who would seek time to file statement of objections to the petition. List on 16th. Yes.
11,
Anticipatory bail, my lord. Similar matters are listed on the 9th of January.
9th, yes. List on 9th.
12,
Away post immediately after service of notice upon the second respondent. Enter ಮಾಡಿದ್ಯಾ?
Interim order.
Subsisting will continue to the next date of hearing.
9.
Criminal appeal.
Lord, this, your lordship, this and next matter, my lord.
Up to 19, same, huh?
My lord. 13 and 14, your lordship.
Huh.
In 14, my lord, it is the firm, we have not sought for suspension of sentence, my lord, and for bail. But by mistake, my lord,
ಬೇರೆ ಕಾಪಿ ಪೇಸ್ಟ್ ಆಗಿದೆ.
ಅದು copy paste ಆಗಿದೆ.
Yes.
And my lord, that order, my lord, to deposit fine, the entire order may be recalled, your lordship.
ನಿಮಿಷ, ಅದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Serial number 14, your lord.
13 or 14?
14, my lord. 13, my lord, we are seeking for modification, my lord.
Why?
For, my lord, a fine amount, my lord,
ಹಾ,
is huge, my lord. they are unable to because
That
all, my lord, we have produced-
it was argued, considered and then passed.
my lord,
We'll hear the
entire-
appeal, fine.
entire property, my lord, has been freezed by ED income tax authorities. They cannot able to accumulate, my lord, any fund for deposit of money.
Well,
Some concession, my lord, your lordship.
let him file his objections.
5%, my lord, instead of that, my lord,
Let him file his objection. The 14th matter will,
objection is filed, your lordship.
for this, IA for modification.
Yes, it's already. filed.
Modification?
Objection is filed.
Where is the IA, objections for IA for modification? Yes, ready? ಅಲ್ಲ modification IA objections ಹಾಕಿದ್ದೀರಾ?
No, I think I filed it.
IA 2 of 24 for relaxation of conditions.
Please,
ಅದಕ್ಕೆ objections ಹಾಕಿದ್ದೀರಾ? ಹೌದಾ?
maybe it is not put up.
2, 12, 11, 6, 12, ಇಲ್ಲ, I don't think so. I don't find it here.
We were served copy, my lord, last week itself.
I'll-
12 itself, my lord, they have served copy.
Then we'll consider it the next date.
Please,
Last date, my lord, 26th, my lord, 6
Sir,
weeks.
it was, all of you were heard
Yes.
and this order is
My lord,
passed.
we have produced documents, your lordship. Additional documents we have produced to show that all properties of even individual, entire family, sons, daughters, all properties are freeze,
not the
freeze by
ground.
ED authorities.
This ground
Not even
was very much available. and we made
available, but
sufficient
at
stand on
that
the IA for
That's why
suspension
I
of
said,
sentence.
all of you were heard
no,
and the order is
no
passed.
doubt, my lord.
Where is the question of
Sir,
relaxation now?
my lord, some modification, my lordship, concession, my lord.
If he accepts, then fine, otherwise,
This
No,
is, my lord,
This
the
ground that they have
position,
heard.
sorry,
all right, but ಎಲ್ಲಾರ್ನು ಕೇಳಿ ಮಾಡಿದ್ದಲ್ಲ
Sir,
start.
here, my lord, they were not
You
the
knew that-
exporters, your lordship.
No, you knew what was the condition of the
They-
petitioners then?
They were under loss. They had sold the iron ore material. They were not the exporters. They did not remove
ಈಗ
it.
they are released on bail or not?
My lord, yes, in the first matter, my lord, he is released, my lord, on bail. My lord,
Ninth
condition is.
Consider it on the next date.
Please,
The 6th, my lord, the 6 weeks, my lord, it's going to.
We'll
expire,
extend
my
it
lord.
by 2 more weeks, consider it on the 8th.
Please.
Yes. The petitioner has preferred an application seeking modification of the conditions so imposed while suspending the sentence and granting bail. The learned counsel for the respondent CBI submits that his serious objections to any modification. The time that was granted to deposit the amount is set to expire on the 26th of December 2024. In that light, I deem it appropriate to extend the time up to 15th of January 2025, list the matter on 9th of January to hear on the application.
I filed objections on 2nd December 20, 12th December.
12th.
ಇಲ್ಲಿದೆ, madam school, yes. On 9th.
Yes. Order to be ready, my lord, that we.
ಅದು
That's it.
ಕೊಡ್ತಾರೆ.
My
It
lord,
will be
Next
uploaded.
matter, my lord, order may be recalled.
That I will, ಅದು ಕಂಪನಿಗೆ ಸೇಮ್ ಬಂದ್ಬಿಟ್ಟಿದೆ,
Please,
ಪ್ರಸನ್ನ ಕುಮಾರ್.
ಅಲ್ಲ company, in fact,
14 ಅಲ್ಲಿ
Sanofi India Limited, very much on the same ground, but which was decided by the coordinate bench. Apex court, no, this court, not as said, not company needs to pay the fine, if not undergo sentence. I'll cite,
ಅಲ್ಲ,
this also will
sentence
take up
ಇರಲ್ಲ.
on 9th.
ಸೇಮ್ on the 9th, but
Suspension of sentence. and
Suspension-
bail.
ಅಲ್ಲ ಫೈನ್ ಇದ್ರೆ ಆ ಕಂಪನಿನೂ ಕೊಡ್ಬೇಕು ಅಂತಿದೆ. That's what not. This not
ಅದು ಇದೇನಾಗಿದೆ, this order, ಅದರದ್ದು ಕಾಪಿ ಪೇಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ.
ಫೈನ್
We'll
ಕೊಡಿ.
modify the order.
ಫೈನ್
We'll modify the order to,
My lord, in respect
fine
of,
they
my
need
lord,
to pay.
entire order may be recalled, my lord. We are not pressing for that IA itself, my lord.
the learned
Fine,
senior
my lord.
counsel submits that the application which led to passage of the order dated 13/11/2024 would be withdrawn as not pressed. In that light, the order dated 13/11/2024 stands recalled. List the matter on 9th. Yes. Learned senior counsel in that. Yes.
This is
And suspension of
conviction.
conviction, stay of conviction. But the Supreme Court says what is that, Afsal,
No, my lord, Supreme Court has said it has to be done.
has to be done now.
Yes, yes.
You want to attend the session andre,
ಇಲ್ಲ, ಇಲ್ಲ, my lord, may kindly go to, at times, my learned friend, my very good friend, Mr. Prasanna is fair. He himself would quote in the statement of objections, my lord, the judgment of Afzal Ansari. That is what my lord has
yes,
referred to. May I request you lordship to kindly tend to, my lord, it was a 3 judges bench two judges would concur and the third judge would differ. He is placing reliance on the
Oh, the dissenting judgment? All right.
But while quoting, my lord, the concurrent judgment in the statement of objections, you please grant it. May I request your lordship first for a second?
Page,
My lord, before I take your lordship to this judgment, my lord, let me submit to your lordship one thing. The conviction is for an offence under section 379 and 420. That is number one. Number two, it is not the case of the prosecution also that either by the user or by the misuser of the office I was holding as a legislator, I committed this offence. No, independently, my lord, as a businessman, I have committed the offence. Had it been by user or misuser, just like a public servant, my lord,
yes.
supposing
you're
it's a
right.
conviction is there, he may
So
go.
it is
out-
not misuse of the office.
Yes, office. That is probably my appeal to your lordship is kindly keep that in mind. Then let us go into it. Number one. Number two, my lord, under the RP Act, my lord, after the Supreme Court struck down 8(4), my lord, section 8(4). Now what remained under the statute is 8(3). Have a look at 8(3), my lord, for a second.
Representation of people.
RP Act. ಇದೇನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ 713 ವರ್ಷ ಏನು ಮಾಡೋ ಹಂಗೆ ಇಲ್ಲ. Not 6 years. 13 years. Have a look at section 8(3). Supposing the appeal is dismissed, my lord, I would be required to undergo the sentence as imposed by the trial court. A person convicted of any offence and sentenced to imprisonment for not less than 2 years other than an offence referred to in subsection 1 or subsection 2 shall be disqualified from the date of such conviction and shall continue to be disqualified
So 8(3).
for a period of 6 years.
8(3).
I'm sorry, 8(3).
One minute.
I'm sorry.
Subsection 3 of section 8.
Although a person convicted of an offence and sentenced to imprisonment for not less than 2 years other than any offence referred to in subsection 1 or subsection 2 shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years. Kindly note this, mark this, since his release.
The Representation of People Act.
RP Act. Nanda, shall I pass on my act?
Really, 8(3) is consolidation of subsection 1 and section 3.
In fact, that has been referred to in this judgment also.
(51), sorry. Yes.
ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಆಫ್ಟರ್ ಇಸ್ ರಿಲೀಸ್ 6 years after his release, first he has to undergo the sentence as imposed.
No, it is 1951. I am seeing 50. Yes. Yes, sir. Now I get it. Yes.
But at this point of time, we are certainly not on the merits of the matter. I'm sure your lordship would certainly agree with me.
Yes.
But now let me invite my lord's kind attention to Afzal Ansari.
Yes.
My honorable friend has referred to in his statement of objections as well. I would like to first draw my lord's kind attention to paragraph 9. Well, what are the submissions which came to be made in one paragraph that has been quoted in their lordships? Paragraph 9 means internal page 201 of the judgment. Dr. Abhishek so Lawrence Senior Counsel for the appellant argued that the High Court erred in not granting the suspension of the conviction, especially in the light of the fact that disqualification from membership of parliament leads to irreversible consequences such as, number one, the loss of the next 6 months as a member of the parliament in the Lok Sabha. Number two, disqualification from contesting elections for a total period of 10 years. Number three, he further contended that such a disqualification would not only result in the appellant losing his right to represent his constituency, but would also rob his constituency of its representation before the parliament. The learned Solicitor General also highlighted the infirmities in the impugned order. The High Court in denying stay of conviction along with the material contradictions in the prosecution case against the appellant. May I request your lordship to kindly turn to paragraph 12 now for a second.
Yes.
In our considered opinion, the questions that fall for deliberation are set out as follows. What are the parameters, in this case, even in the earlier two writ petitions which came to be filed by the certain pro bono publico, in the form of public interest litigation before the Supreme Court, they would say that there is no provision under the provisions of the Code of Criminal Procedure for staying the conviction. It is only sentence that could be stayed and bail could be granted. In our considered opinion, what are the parameters to be considered for the suspension of conviction under section 389(1) CRPC? Whether the appellant has made out a prima facie case for the suspension of conviction under section 389(1) of the CRPC. Kindly go to para 14. At the outset, it is imperative to delineate the essential parameters that must be meticulously examined to determine whether a case can be made out for suspension of conviction under section 389(1) CRPC. Section 389(1) enjoins upon the appellate court the power to issue an order for suspension of a sentence or an order of conviction during the pendency of an appeal. It may thus paramount importance to scrutinize the precise language of section 389(1) of CRPC, which is articulated as follows. Well, I shall skip, my lord. Their lordships would quote to section 308. Ultimately, they would say, my lord, not only under section 389, but also under section 489, the court has a jurisdiction, my lord, to order the stay of conviction. May I request your lordship to kindly go to paragraph 15 to 27 now.
15 to 27.
15 to 27. 28 guidelines. What needs to be done? It becomes manifestly evident from the plain language of the provision that the appellate court is unambiguously vested with the power to suspend implementation of the sentence or the order of conviction under appeal and grant bail to the incarcerated convict, for which it is imperative to assign the reasons in writing. The court has undertaken a comprehensive examination of this issue on multiple occasions, laying down the broad parameters to be apprised for the suspension of the conviction under section 389(1) CRPC. There is no gainsaying that in order to suspend the conviction of an individual, the primary factors that are to be looked into would be the peculiar facts and circumstances of that specific case, where the failure to stay a conviction would lead to injustice or irreversible consequences. The very notion of irreversible consequences is centered on factors including the individual's criminal antecedents, the gravity of the offense, and its wider social impact, with simultaneously considering the facts and circumstances of the case. Well, I shall skip this paragraph 16, 17, and 18. Now, my lord, kindly go to 21 straight away. Well, their lordships would, in those preceding paragraphs, would deal with section 389(1) and all that. Kindly go to paragraph 21. We say no, so primarily for the reason that the potential ramifications of declining to suspend such a conviction are multifaceted. On the one hand, it would deprive the appellant's constituency, my lord may kindly mark this. On the one hand, the appellant would deprive the appellant's constituency of its legitimate representation in the legislature, since a by-election may not be held given the remainder tenure of the current Lok Sabha. Well, that was the facts of that case. Conversely, it would also impede the appellant's ability to represent his constituency based on the allegations, the veracity whereof is to be scrutinized on a reappraisal of the entire evidence in the first criminal appeal pending before the High Court. This would potentially lead to the de facto incarceration of the appellant for a period of 4 years under the UP Gangsters Act and an additional 6-year disqualification period, even if he is eventually acquitted, which would effectively disqualify him from contesting the elections for a period of 10 years. But this is how I submitted to the lordship. After he is released means after this completion of the sentence, that is 7 years plus 6 years, 13 years, he can't even contest the election. It is essential to emphasize that while the appellant did not enumerate any material facts, but the court can so much to take cognizance of those. That is what the Supreme Court would say. Regarding irreversible consequences in his application, filed before the High Court seeking the suspension of conviction, this principle can be traced to the statutory provisions outlined in section 8 of the RPA. The High Court or this court, however, while exercising their appellate jurisdiction, are well empowered to take judicial notice of these consequences. Additionally, the respondent also does not contest the fact that if the conviction is not stayed, the appellant would not only face disqualification as a member of the 18th Lok Sabha, but would also incur disqualification to participate in future elections for parliamentary or state legislative seats. Taking into consideration the consistent legal position adopted in this regard, the severity of these outcomes underscores the urgency and gravity of the matter on hand. Now, may I request your lordship to kindly go to, ultimately this is what their lordships would say. Paragraph 27 and 28. It is therefore imperative to weigh the competing interests presented by both the appellant and the state. This case pertains to the appellant's disqualification as a member of the Lok Sabha under section 8(3) of the RPA, which disentitles a person who has been convicted and sentenced for a period exceeding 2 years from holding office or contesting the elections. The state's pursuit of a conviction under section 3(1), etc., that we are not concerned. Conclusion and directions, paragraph 28. This is what my learned friend would quote in his statement of objections. We thus deem it appropriate to partially allow this appeal and suspend the conviction awarded to the appellant in special sessions trial number so and so, subject to the following conditions and clarifications and directions. The Ghazipur parliamentary constituency shall not be notified for the by-election in terms of section 151 of the RPA till the decision of the appellant's criminal appeal by the High Court. The appellant shall, however, not be entitled to participate in the proceedings of the House. He shall also not have the right to cast his vote in the House or to draw any perks or monetary benefits. The continuance of MP law, welfare schemes in the Ghazipur parliamentary constituency without the appellant being associated for the release grants for such schemes is not an irrevocable consequence, as all such schemes can be given effect to even in the absence of the local parliamentary representative. The appellant shall not be disqualified to contest the future elections during the pendency of his criminal appeal before the High Court, and if he is elected, such election will be subject to the outcome of the first criminal appeal.
28.2.
28.2 minutes.
Hmm.
The appellant shall, however, not be entitled to participate in the proceedings in the House. He shall also not have the right to cast his vote in the House. Quite right, madam. That should be one of the conditions which needs to be imposed in the event.
The reason that you moved it for suspension of conviction,
Allah,
that he has to participate in the house.
ಅದಲ್ಲ ಎಲೆಕ್ಷನ್ ಮಾಡ್ಬಿಡ್ತಾರಲ್ಲ
ಅದು ಗೊತ್ತಾಯ್ತು. That
ಅಲ್ವೇ
means-
ಎಲೆಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಲ್ಲೂ ಎಷ್ಟು 13 ವರ್ಷ. If my lord is persuaded to accept my submissions, and if my lord were to ultimately say, yes, you are entitled for the stay of the order of or the judgment of conviction, kindly impose the very same conditions. I am not saying anything more or less.
The dissenting view of Justice Dipankar Datta is otherwise.
Yes, that is. My lord, I have several other judgments of the Supreme Court commencing from Sidhu's case also. That's what they. My lord, the latest judgment of the Supreme Court is following Afzal's case. This is what the Supreme Court would say. My lord, it is an unreported judgment and order of the Supreme Court in Ponmuni's case. My lord, that is Tamil Nadu's minister. Their lordship should follow Afzal's case and would say,
Bail.
paragraph 3, my lords.
Bail matter.
Yes.
Afzal Ansari suspension of
Yes, my lord.
conviction.
Therefore, in the facts of the case and in view of the law laid down by this court in etc., suspension of sentence.
Hmm.
Well, I think I need not trouble your lordship with other judgments. Number of judgments are there. in
ಇದ್ರೆ
the point.
ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
Same proposition.
ಒಂದು ಕಂಪೈಲೇಷನ್ ಎಸ್ ಸುನಿಲ್ ಕುಮಾರ್.
Lok Prahari and other, no. What my learned friend is telling me is,
ಹಾ.
my lord, public interest litigation in the form of a writ petition came to be filed, that there is no.
No, let us not go back into the root of this problem.
Please.
But what is the present problem, we'll address it.
My appeal to your lordship and request to your lordship is, if I am otherwise entitled for the benefit of an order of stay of conviction, impose the very same terms which the Supreme Court has said time and again in more than one judgment or order which came to be passed by the Supreme Court in a similar situation or similar circumstances.
My submission was that not this judgment, which my learned senior friend referred to para 28.
You are right on that day to say, because application was moved that he would wants to participate in the House proceedings. 28.2 relied on to say that yes, it is, Supreme Court has said he cannot. So that time is over now.
I continue to be a legislator.
Continue to be a
Para
legislator.
28,
Yes, I continue to be, I can go and sit there, that's all. Beyond that, my lord, I can't even open my lips there.
Allah, you shall not be
Again.
entitled to participate in the proceedings of the house.
You can't even
You
enter.
can't even enter.
That is,
Not my submission was, when I read this para 28, my senior friend
really?
said it is a dissenting opinion. It is not correct.
No, it is not
It
dissenting.
is not dissenting.
It is the majority.
It is
opinion.
majority opinion. Kindly have a look at.
Dissenting is Justice Dipankar
No, kindly have a
Datta,
look
which
at this,
dissenses from the.
Page 199, madam.
dissenting is the order.
No. Kindly have a look at page 199, madam, of that. 199.
Anyway, whatever it may be, my lord, the fact remains.
Allah, fact remains
there is
Allah.
Majority judgment is the dissenting judgment.
He has not read it wrongly.
I
Dissenting.
have not read
Allah.
it wrongly.
It's a concurring opinion, majority view.
Majority view. Not page.
And I remember 28.2 ನೇ ಓದಿದ್ದು ಅವ್ರು
ಅಷ್ಟೇ ನಾನು
last
ಅಷ್ಟೇ
time.
ಓದಿದ್ದು ಅಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ನೋಡಿ. ಐ ಓನ್ಲಿ ಬ್ರಾಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ ನೋಟಿಸ್ ದಟ್ ದಿಸ್ ಇಸ್ ದ ಜಜ್ಮೆಂಟ್, ಲೇಟೆಸ್ಟ್ ಜಜ್ಮೆಂಟ್, ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಾಲೋಡ್.
My lord, there,
So,
the dissenting, the
then-
Laren dissenting judge
then
would
even
say that I
ತಪ್ಪಿಲ್ಲ.
dissent, disagree.
No. The statement that fell is that he has quoted a dissenting opinion.
That is not correct.
No,
he has
I
quoted
didn't
him.
say,
That's
no,
what-
my lord, I
that-
didn't
that-
say that
that's
he has
what he
quoted
said.
No, no,
That's what you said,
Prasanna,
sir. ಇಲ್ಲ
Prasanna.
ಸರ್ ಅದೇ ಹೇಳಿದ್ದು.
I didn't say that he has quoted dissenting judgment.
ಇಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದ್ದಾವು ಸರ್ ರೆಕಾರ್ಡ್.
I'm sorry. What I said was, once a while he is very fair. He has
I'm
quoted the
always
judgment
fair.
which endures to my benefit. That is what I
I am
said.
always fair, not once.
That is what I said. The paragraph
As,
58, he has
uh,
quoted it.
No,
As a defense counsel,
all of you are always fair.
but as a defense counsel,
Correct, correct.
but they're entitled to not say the crow is white. But not as a prosecutor, I'm always and not. I have to assist the court and say, no, crow is black.
No,
This judgment not I cited.
I cannot
on the
say
other
black
day,
or white.
Your lordship will have to decide not based on the Milord law. Therefore,
Yes.
I brought to your lordship. These are not the condition that will
Sir,
not will
no,
have
no,
to be imposed. Not by
You have last time also read the majority view only,
Please, Milord.
and you have relied on that only. It's not the dissenting view.
Ask-
There must be some mistake while saying.
Yes, I'm-
All right.
I'm-
Yes. That's all.
I think same order, Milord.
Same order.
Same order.
Yes, ma'am.
We'll pass the same order.
Same order, my lord. Your lordship may pass the same order.
Yes.
Because I can't expect from your lordship my lord, an order which is contrary to or something different from what is
ಈಗ
Supreme Court has said.
ಯಾವ್ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಒಂದೇನಾ ಇದು?
My lord,
ಒಂದೇ ಕೇಸಲ್ಲಿ ಯಾವ
So in
case?
5 cases,
Milord,
not there
ಹಾಕಿದ್ದೀವಿ.
5.
ಎಲ್ಲ all 5
There are
cases
6
they are
cases.
limited?
ಹೌದು,
You know, there are
same.
6 cases. One is not listed.
FIR, one FIR.
ಒಂದ್ ನಿಮಿಷ ಸರ್. We'll take one by one.
15, 16, 17, 18, 19.
ಅಲ್ಲ,
Common
ಅದ್ರಲ್ಲಿ-
order Milord can be passed.
So ಒಂದ್ ನಿಮಿಷ ಸರ್.
15, 16, 17,
15,
18.
16, 17,
18,
18, 19.
ಎಲ್ಲದೂ
ಇದು-
ಹಾಕಿದ್ದೀವಿ.
ಎಲ್ಲದ್ರಲ್ಲೂ you are what?
I have made the appeal.
Accused number 2.
Yes.
Accused number
Different
6.
accused.
Not the accused number changes, special CC
Rank,
number
my lord,
changes.
rank is different.
The person is
That is
only
same.
one.
Person
Person
Rank
is the same.
different. Rank is
Yes.
different.
All right, sir. At same order will pass.
Please,
Same.
please.
Deeply
We'll
applied.
have it uploaded day after tomorrow
Please.
or on Monday because Saturday ಇರೋದು. Yes.
ಆಮೇಲೆ ಇದು 6 ಇದೆ ಒಟ್ಟು. Today I don't know why only 5 cases have been
ಅದು
listed.
ಇನ್ನೊಂದು ಬಂದಿಲ್ಲ.
ಇನ್ನೊಂದು ಬಂದಿಲ್ಲ.
2085
Same.
ಬಂದಿಲ್ಲ.
Same,
Same person
same
Person
person.
not
Then
2085 ಅದು ಮಾಡ್ಬೋದು.
will get that posted. Madam,
Yes.
ಅದು ಹಾಕ್ಸ್ಬಿಡಿ.
There's
same order.
2085 of 24.
Same one.
We'll pass a common order
Please.
referring to different accused in the sense number of the accused.
Number.
Same person, same Supreme Court.
Please.
Yes.
Deeply blessed.
The election notify ಮಾಡ್ಬಿಟ್ರೆ ಕಷ್ಟ ಅಂತ.
ಎಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ. Whatever not apex court says.
Yes.
Have-
Whatever apex
If I
court
have,
says.
my lord, wrong listed.
ಅಲ್ಲ
I'm
ಸಾಹೇಬ್
sorry.
ಫ್ಲೋ ನಲ್ಲಿ ಏನು?
We are good
So
friends.
whatever comes from
Of
it
course
is
not.
not.
We are very good
I
friends.
Yes.
highest respect not in regards to
Absolutely.
my-
I hear that.
By slip of tongue, if I have
I-
said something. my lord.
No, the court also shares that. Yes.
Please, bless.
Yes. Order nahi hai. Order nahi hai. Which number ನೋಡ್ಕೊಳ್ಳಿ madam.
ಅದರಲ್ಲಿ-
Your lordship said that we should be
ಅದರಲ್ಲಿ
here at 4 or
appeal
5
must be
o'clock.
heard expeditiously ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. Please, please.
Next time.
21 ಬಂದಿದೆ ಮಧ್ಯದಲ್ಲಿ.
Oh, agreed.
Yes. Next, sorry.
20,
ಯಾವುದು seal number?
20.
Petitioner expired.
106 delay in filing.
Petitioner expired on.
Expired ಆ? ಸರಿ, ಏನ್ ಮಾಡ್ತೀರಾ? Abated ಆ? Learned count.
Bringing the LRs.
Accused expire ಆದ್ಮೇಲೆ ನೀವೇನ್ ಎಲ್ಲರ್ಸ್ ತರದಲ್ಲಿ? Complainant ಅಲ್ಲ expire ಆಗಿರೋದು. The accused ತಾನೇ ನೀವು? The petitioner accused is said to have died on 15/12/2024. In that light, the proceedings where the accused is abated, the petition is disposed as having abated. Complainant ಆದ್ರೆ ಎಲ್ಲಾರ್ಸ್ ತಗೊಂಬನ್ನಿ. Accused ಅಲ್ಲಿ. Yes.
21.
ನೆನ್ನೆದಾ?
Your lordship has directed us to be here at 5 o'clock.
ಓ, ಇದು ಇಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದೆಯಾ ಈಗ? All right.
subject to the availability
Yeah,
of
if it
time.
was,
In fact,
could have
my
been-
lord has listed one special matter, 2:30.
At 2:30.
Oh, no.
Ravi Kumar sir idra, I could have started it.
If my lord doesn't have much time, your lordship may post it immediately.
Well, no.
I'll be
We
here at
finish it
5.
off. Alla, ಬೇಕಾದ್ರೆ 2:30, now I think,
2:30.
if you find him, you can get him, sir.
ಇಲ್ಲ ಅವ್ರು ಬಂದು ಸಿಕ್ಕಿದ್ರು ಮಿಸ್ಟರ್ ನಾಯಕ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ ಪ್ರಾಸಿಕ್ಯೂಟ್ರು ನಾನು
ಹೇಳ್ಬಿಟ್ಟು
ಕೇಳ್ಕೊಂಡು ಹೋದ್ರು ಕೋರ್ಟ್ ಆಫೀಸ್ ಎಷ್ಟು 5 o'clock ಅಂತ 5 o'clock ಬನ್ನಿ ಸರ್
All right.
No, we will take a chance.
All right, yes. No, we'll finish it today, sir, even if it is 6 o'clock.
We will do it. Sir.
Yes,
Your lordship has given us some food for thinking yesterday.
exactly.
I have already examined.
No
it.
problem. Yes, yes.
Admission 22.
After vacation,
Interim order in the.
that will continue. Yes. Madam Ella, list on 23rd, interim order subsisting will continue to the next date of hearing. Same 23 now then, ಎಲ್ಲದರಲ್ಲೂ interim order ಇದೆ.
Petitioner, my lord.
20?
Three.
Interim order ಇದೆಯಲ್ಲ?
ಹಾ,
ಎಲ್ಲ
maybe extended.
23rd. Urgency ಇದೆ.
ಇಲ್ಲ.
Yes.
Petitioner.
20,
24.
yes.
25.
Lords, 25. My lords, here is a retired gentleman
Ah.
for whom we have not taken the 19 permission, my lord, sanction.
Then it goes.
There is my lords, 197 is to be
90,
taken.
19 ಬೇಡ, 197 ಬೇಕು.
I am on that, my lords, but the main prayer sought here is the entire annulment of the entire criminal proceedings. That may not, only charge sheet I'll
Stage
consider.
to this charge
Charge
sheet
sheet.
goes. Cognizance and charge sheet would go. if-
And liberty for us to do it afresh from there on,
Punjab Warehousing Corporation.
please.
ಮಾಡ್ಬೋದು.
I'll concede for that outrightly, my lords.
Yes.
Because my lords have already given us the judgment in Srinivas law, which is thoroughly covered.
Yes.
I don't want to labor and waste my lord's time on that. Charge sheet, framing of
What is
taking
Amar
cognizance.
in this case?
I cannot survive them, my lords.
Huh?
The stay in serial number 25.
Oh, ಇದಕ್ಕೆ ಅದಕ್ಕೆ ಸಂಬಂಧ
operating
ಇದೆಯಾ?
against me as well, was
Entire
considered
proceedings.
against me by
So
interpretation.
this goes, that goes.
That
Then why do you want 205 or 227? Yes. You are a different accused in the same crime?
Number 3, 4 and 5, my lords.
ಇವರು?
But I am
A14.
A14.
You are accused number 14.
14.
But anyway, it goes. You take sanction and proceed.
Please, from
Yes.
that stage, if my lords will. Liberty be reserved for us,
That is.
please.
Anuj.
And 230. 230.
No, the one you appeared the other day,
Please, my lords,
connected matters.
please, my lords.
Nagarajappa appear ಆಗಿದ್ದು. Where sanction, I followed Srinivasulu and have granted liberty.
Please.
Yesterday I have signed that. I was telling that one.
Please, please,
Same thing here.
please, please.
To ease, to tag both 25 and Amar Korea ನಿಮ್ದು ಎಷ್ಟನೇದು?
I'm 5, my lords.
5 and 25. The petitioners in both these cases are different accused in special case 457 of 2016, registered for offense punishable under section 468, 471, 420, 120B and 13(1)(c) and 13(1)(d of the Prevention of Corruption Act. In serial number 5, number ಬರ್ಕೊಳ್ಳಿ, the accused are
Read with 13-2 as well.
13(2) ಹಾಕ್ಬೇಕು. 13(2) ಇಲ್ಲದೆ ಆಗದೇ ಇಲ್ಲ. 13(2), yes. This, you are accused
3, 4 and 5.
5 ಅಲ್ಲಿ 3, 4 and 5. Venkatesh
I'm
Dalwai
14.
ಸರ್ದು it is
14.
14, accused number
But I
14.
am charged with 13(1)(c) and 420.
I will not go into all that. Yes.
Please.
Whether you are charged under IPC or this 197 is necessary.
Please.
Yes.
Great.
The facts heard so and so. Facts in brief germane are as follows. A crime comes, the second respondent registers a private complaint in PCR 98 of 2012 against several accused, 14 of them, accused 1 to 14. The concerned court refers the matter for investigation on 1/3/2012. The investigation leads to filing of the charge sheet for the aforequoted offences. The respondent then files a supplementary charge sheet on 22/12/2021, and the concerned court on 11/10/2022 takes cognizance of the offence and issues process to the petitioners. It is at this stage the petitioners have knocked at the doors of this court in the subject petition. The learned counsel appearing for the petitioners, Venkatesh Dalwai and so on, would in unison contend that the order of taking of cognizance and issuance of process is bad in law for the reason that there is no sanction obtained from the hands of the competent authority as obtaining under section 197 of the CRPC to continue prosecution against these petitioners who are public servants. The learned counsel would submit that the offences alleged against these petitioners are the ones punishable inter alia on inter alia, the ones under section 13 so and so the hacking.
We are private individuals.
One nimisham.
Not public.
13 so and so. The offences alleged against the public servants are an amalgam of the offences under the Prevention of Corruption Act and the IPC, and the private individuals to which private individuals at serial number 5, a criminal petition so and so, the offences are under the IPC. Nonetheless, since they are facing the trial together, the learned counsel would submit that sanction is imperative to continue the prosecution against any of these accused. The learned counsel appearing for the respondent, B.B. Patil, would admit the fact that there is no sanction obtained and would submit that liberty be reserved to the respondent to secure sanction and proceed with the matter from the stage of filing of the charge sheet before the concerned court. Because before the charge sheet, cognizance irbekar, but file but charge sheet before the concerned court. I have given my anxious consideration to submissions made by the respective learned counsel and perused the material and record. The afore narrated facts, dates, link in the chain of events are all a matter of record. The only issue that falls for consideration at this juncture is whether proceedings against these petitioners should be permitted to be continued. It is not in dispute that the accused in the case at hand are both private persons and public servants. Against the public servants, what is required is a sanction under section 197 of the CRPC for continuation of prosecution pursuant to the filing of the charge sheet or taking of cognizance by the concerned court. The issue need not detain this court for long or delve deep into the matter. The apex court in the case of A. Srinivasalu versus so-and-so 2023 SSC Online SC page 900. Page 900 has held as follows. The first issue is, quote the complete first issue, para 27 to 57. Correct, Adu? Para 27 to 57, I guess. Yes,
30 onwards.
Huh?
30 onwards.
All right, Adana quote made. The aforesaid judgment is again reiterated by the apex court in the case of Gurmeet Singh, rendered on December the 10th, 2024. In the light of the issue standing answered of sanction being imperative to continue prosecution against a public servant, the petition deserves to succeed on a bare perusal at the order of cognizance. It is an admitted fact as observed herein above that the cognizance is taken and process is issued to these petitioners without a sanction being placed by the prosecution before the court at the time of taking of cognizance. Therefore, it would cut at the root of the matter insofar as taking of cognizance is concerned. This would not, however, obliterate the complaint or the investigation conducted. Therefore, the reserving liberty to the prosecution to obtain sanction and for the aforesaid reasons, the following word. The order dated so-and-so, which is that order?
Page,
Date.
date, I guess. I'm sorry.
Order dated so-and-so stands quashed. The concerned court shall continue the proceedings from the stage of taking of cognizance only
11th.
if sanctioned by the competent authority to prosecute these petitioners, the public servants is granted. In the event there is no sanction, the concerned court shall not proceed with the
Under section 197, my lords,
Ah,
because he is
and-
superannuated.
1 minute. Under section 197 of the CRPs. In the event there is no sanction, the concerned court cannot proceed with the matter. Order
Order
recorded.
dated 11/10/22.
11/10/22.
Lords, one indulgence. The germane fact of his superannuation may be noted somewhere because that,
No, on the- on the
that
line-
will
on
preclude
line
it from
ಹಾಕಿ.
19 and make come a
ಅಲ್ಲಿ
bring counter.
BB Patil submission ಇದೆಯಲ್ಲ, the learned counsel would submit that the petitioner, the public, which all the public
Come,
servants,
Lords, A14.
the learned counsel would submit that accused number 14, the petitioner in criminal petition 8717 of 2023 has since been superannuated. Therefore, a sanction obtaining under section 19 of the Prevention of Corruption Act need not be secured. ಅಷ್ಟು ಹೇಳಿದೆ ಸಾಕು. However, 197 is mandatory.
Please, please.
Prayer made in my petition does not survive consideration in that event.
Main prayer.
Main prayer.
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. In the light of the reasons so rendered to dispose 8717 of 2023, the prayer sought by the petitioner in Amar Korea case ಅಲ್ಲಿ would not survive for consideration. Yes.
Please.
Deeply obliged, deeply obliged.
Twenty-six.
Appeal for the petitions.
After vacation. 16,
Interim order. may be
23rd. List on 23rd. I vote till the next.
Twenty-seven.
Interim order may be extended.
ಇನ್ನೂ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಕೇಳ್ತಾನೆ ಇರ್ತೀನಿ. Yes.
Twenty-seven.
After vacation.
Interim order.
Yes, next. Of the kind ಇದರಲ್ಲಿ stay ಇಲ್ಲ, ಬರೀ protection ಇದೆ ಅಷ್ಟೇ. Yes.
28.
The two complaints are filed, my lord, two FIRs are registered,
Two interim orders are granted.
two interim orders are granted, my lord,
We'll
two
take-
petitions
we'll
needs
take-
to be
we'll
allowed.
Take the two ಈಗ, why?
Lord, only election offense, my lord, during the election, my lord, some tweets have been made. For which, my lord, 505
505
again and 125. Lord, RP Act.
Demonstrate month, there is menstruation and also attraction of still in.
Yes. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, two interim orders will give two dates. Yes. Yes, madam, next time?
Please.
Interim order may be extended.
Yes. They heard the learned counsel, senior counsel Arun Sham appearing for the petitioner. Counsel Srimati Lata Shetty submits that the offences in the case at hand are clearly made out and she would demonstrate and remonstrate on the next date. ಯಾಕಂದ್ರೆ ಎರಡಿದೆಯಲ್ಲ, ಎರಡು ಹೇಳ್ಬೇಕು. So on the next date that the petition should be dismissed. List the matter on 23rd at the request of the counsel for the second respondent. Interim order subsisting would continue till the next date of hearing.
Obliged.
Next time ಎರಡು ಮಾಡ್ಬಿಡ್ಬೇಕು. Demonstrate and remonstrate. Yes. Yes.
29.
Offense is 505, 153A, my lord, 298A. Neitherly, there is no prima facie.
ಎಲ್ಲ ಇದೆ.
Used
ಅದಕ್ಕೆ
slogans are
ಕೊಟ್ಟಿಲ್ಲ.
at page number 22, para number 2.
This you have spoken
I'm
bad
re-
of the chief
I am
minister.
relying upon the
You may
judgments
rely,
of this.
we'll see.
So there are,
You have spoken bad of the chief minister, sir. Yes.
no, my lord, there is no ingredients of section
ನೋಡು next time.
153A, my lord.
List on 23rd. Next.
30.
After vacation. 23 interim order. Next. Chintan,
31.
ಇದು ಅಷ್ಟೇ, ಸೇಮ್. 23.
32.
Seriously.
That's for the petition.
Respondent, appeal.
All appeals. 23.
20.
ಎಲ್ಲ appeals ಇರೋದು ಆಮೇಲೆ.
ಎಲ್ಲ appeal.
Up to 37. 38 ಕರೀರಿ.
30.
Yes, Naveen? This is also admitted.
Admit and
Matter admit. 23rd for final hearing.
interim order to continue. my lord. Obliged.
Admit ಆದ್ಮೇಲೆ interim order continue ಮಾಡಿದ್ದಾರೆ.
Obliged.
Yes.
39.
ಇದು admit ಆಗಿದೆ.
Admit again, final hearing.
23rd for final hearing.
40.
For 230, madam. ಅದು. Yes. So 40 ಈಗಲೇ ಕರೆದ.
Number 2. Being spoken to number 1.
Appeal for respondent number.
ಏನು
My lord,
being
There was a
spoken to
condition
ಯಾಕೆ?
order by this honorable court, my lord, to deposit 1 lakh
50,000.
50,000. ಅದು ಡೆಪಾಸಿಟ್ ಆಗಿದೆ, 13 ಡೆಪಾಸಿಟ್ ಆಗಿದೆ.
30th ಆಗಿದೆಯಾ?
13ನೇ ತಾರೀಕು,
ಯಾವತ್ತು ಆಗ್ಬೇಕಾಗಿತ್ತು?
12
ಅಷ್ಟೇ.
ಅಷ್ಟೇ. ಡಿಡಿನೂ ಇದೆ. ಬೇಕಾದ್ರೆ
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ಮಾಡಿದ್ವಿ.
Counsel for the petitioner is
ನಮಗೆ
ಅಕ್ಸೆಪ್ಟ್ ಆಫ್ ಡಿಡಿಗೆ ಹಾಕಿದ್ದೀವಿ. They can accept it.
ಕ್ಲೈಂಟ್ ಈಸ್ ಹಿಯರ್, ಅವ್ರು ಹೇಳ್ತಾರೆ ನಮ್ ಗಮನಕ್ಕೆ ಬಂದಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್
High court.
ಮಾಡಿದೆ?
ಇಲ್ಲಿದೆ.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ,
ಇಲ್ಲಿದೆ.
ಮೇ ಬಿ
ವಿಡ್ರಾ ಮಾಡ್ಲಿ ಅವ್ರು?
ವಿಡ್ರಾ ಮಾಡ್ಲಿ.
Yes. The petitioner, this court on 11/11/2024 had passed the following order. There is a day's delay in making the deposit in terms of the direction of the direction supra. Instead of 12th, it is deposited on 13th of December 2024. Before this court, in the light of the deposit, the registry is directed to transmit the amount to the hands of the respondent wife,
ಎಸ್ ಮೇಲ್,
to the respondent wife. DD ಇಲ್ಲ ಇದೆ.
ಎಸ್ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು
DD ಬೇಕಾ?
ಎಸ್ ಮೇಲ್.
DD ಬೇಕಾ? ಮನಿ ಬೇಕಾ? Yes.
ಆಮೇಲೆ ಒನ್ ಮೋರ್, ಎಸ್
Yes, so and so. And the registry shall transmit the amount to the account of the petition, account of the respondent wife after due verification without broking any delay. Yes.
My lord, due is more than 8 lakhs, my lord.
Next installment.
Next some January. last week
ಆಯ್ತು.
ಅಲ್ಲಿ.
Another 1.5, 4 weeks.
ಸ್ವಲ್ಪ ತುಂಬಾ ಕಷ್ಟ ಆಗುತ್ತೆ ಅವ್ರಿಗೆ. ಒಂದ್ ಮಗಳು ಮದುವೆ ಆಗಿದೆ, ಇನ್ನು ಬಟ್ he will pay. It's not that.
4
but
weeks.
January last week.
Having
ಅದೇ January last week.
1.5 lakh will pay.
ಒಂದೊಂದಾಗಿ ತಗೊಳ್ಳಿ, don't worry. Yes. The interim order subsisting shall continue subject to condition that the petitioner would deposit another 1,50,000 by the 31st of January 2024. Yes.
Right.
25. Sorry. Yes.
25 year in
25.
ಇದು ಕೋರ್ಟ್ ಹೆಸರಲ್ಲಿದೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ DD registry file
ಅದು ಡಿಡಿ ಅಕ್ಸೆಪ್ಟ್ ಆಗ್ಬೇಕು.
ಅಲ್ಲ, ರಿಜಿಸ್ಟ್ರಿ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಅದು ಒಂದ್ ಕಡೆ ಬರ್ಕೊಳ್ಳಿ. The registry is directed to accept the DD ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ the
Transfer.
registry is further directed to transmit the amount so and
Have
so
to give the account
to the
details.
account of the
They have to give the account
account of the
details.
wife.
You have to furnish the account details.
furnish.
After verification ಹೇಳಿದ್ದೀನಿ details. That registry will do. Yes.
Obviously.
And forthwith ಅಂತ ಮಾಡಿ, without delay ಬೇಡ, forthwith ಅಂತ. ನೀವು ಇವತ್ತೇ ಹಾಕಿ.
Matters number 2. Predicate offense, your lordships.
Predicate offense ಅಂತ ಆ ಕಡೆ ನೋಡಿದ್ರೆ,
Predicate offense.
what is the predicate? Look into the file.
It has already been stayed, your lordship, Annexure D, page number 160.
Why is Mahesh Chaudhary on VC?
Not audible.
Unmute, sir.
Annexure D, your lordship, page 160.
Annexure D, predicate offense is stayed.
Please, your lordship.
Where is Punnikrishnan? ಅವರು ಕೋರ್ಟ್ಗೆ ಬಂದು ಎಲ್ಲೋ ಹೋಗಿರ್ತಾರೆ, ಬಂದಿರಲ್ಲ. ನೆನ್ನೆ ಹೀಗೆ ಆಯ್ತು. Yes. Place the matter on 6th January for the hearing.
Stay.
Interim, in the light of the predicate offense being stayed at the hands of this court, the respondent enforcement directorate shall not precipitate the matter to the next date of hearing. Yes, list on 6th for further hearing.
Please.
Yes. Again, we don't know when we'll come.
Number 3.
Identical matters stay ಮಾಡಿದೀನಿ. The offenses are the ones punishable under 276B and 278B of the Income Tax Act. On the ground set out in the petition, there shall be an interim order of stay of further proceedings where the petitioners till the next date of hearing. As all identical matters, the court has granted an interim order of stay. Next.
4.
ಅವ್ರೇನೋ ಮದುವೆ ಆಗ್ಬೇಕಂತೆ ಸರ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ very interestingly, my lord,
The wife has sought for NOC.
No objection.
No objection of no criminal cases pending against you.
ಹೌದು.
ಅದಕ್ಕೆ ಇದು ಕ್ವಶನ್ ಕೇಳಿದೆ.
He is taking a shelter under section 29 and 30 of Buds Act. He says that all offences which wherever registered has to be informed to CBI. CBI has to investigate. That is his contention. Now, this case, my lord, further investigation is pending. ED has filed a case. ED investigation is happening. And by stating that the violation of section 29 and 30, the stay has been granted.
All right, yes. Sorry, list ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂದ್ರೆ ಈಗ ಬರ್ತಾರ ಅವರು ಬಂದಾಗ ನೋಡ ಪಾಸ್ ಓವರ್ ಎಸ್. ಯಾಕಂದ್ರೆ ಸುಮ್ಮನೆ ನನ್ನ ಮದುವೆ ಅಂತಾರ ಆಮೇಲೆ
ಅಲ್ಲ ಇದು ಕ್ಲಿಯರ್ ಆದ್ರೆ
ಇದು ಕ್ಲಿಯರ್ ಆದ್ಮೇಲೆ ಮದುವೆ ಆಗದಂತೆ. ಎಸ್ yesterday he was telling 2 proposals got cancelled because of the criminal case. Case and counter case, Manjunath.
The quarrel started. It concerns the falling of the rainwater from the top of
Gothai,
the house.
yes.
There is no intention, my lord, to insult the caste name.
Intention ಏನಿಲ್ಲ ಬರೀ tension. Yes.
No, my lord, because
Then
they have not used the word.
in the meantime, next, yes. State sir. ಅವರು ಬರ್ತಾರೆ, ಅವ್ರಿಗೂ ಸ್ಟೇ ಕೊಡೋಣ ಆಮೇಲೆ. ನಿಮಗೆ ಕೊಟ್ಟಾಯ್ತು. ಸ್ಟೇ ಬೇಡವಾ?
Please oblige.
Yes. Next.
Petitioner.
A16 ಕಷ್ಟ ಸರ್. ಶಂಕರ್, you are delayed.
But I am held up.
No. ಇರಿ ಸ್ವಲ್ಪ ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ಕರಿತೀನಿ. ಎಸ್ ಯು ಆಸ್ಕ್ ಜಗದೀಶ್ ಸರ್ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಕೌಂಟರ್ ಮಾಡಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 16, everything is at your behest, difficult sir.
My lord, he is the processing officer. My
Correct sir, you have processed everything that should not have been processed.
My lord, the approving officer is the deputy manager and the manager.
ಕಷ್ಟ.
My lord,
Will issue notice. 1 HCGP, 2 emergent notice.
similarly placed to
The
deputy manager.
interim order would be considered on the appearance of the complainant. Yes, next.
7.
Drugs and cosmetics.
You are Siddha and Unani.
Yes.
Why did you keep
Ayur-
allopathy?
Ayurveda.
Ayurveda, Siddha, Unani.
Yes,
All
an
right.
Ayurveda.
Why did you stock huge allopathic
That's a
drugs?
huge, that itself is a matter of contention. May
That
I-
itself is a matter of trial. Huge.
ಇಲ್ಲ, on the face of
See,
it,
ನೀವೇನ್ ಸ್ಟಾಕ್ ಮಾಡಕ್ಕೆ ಅದು ಪ್ಯಾಷನ್ ಇಲ್ಲ. For sale only you have kept. When you have no license under allopathy, why did you store so many drugs?
that's the factum of sale itself is a question. May I just trouble my lords with page
That's all
27
right, but why did you keep it?
for a moment? Page 27.
No, 1, 2, okay. Huge stock of allopathic drugs.
Huge ಇಲ್ಲ ತಾವು ಒಮ್ಮೆ
ಯಾಕಿಲ್ಲ ಬನ್ನಿ.
ಅಲ್ಲ, ಈಗ 30 ಐಟಮ್ಸ್ ಅಲ್ಲಿ 17
Come to page 27.
27
Yes, sir.
precisely.
Yes.
But out of 30 items, 17 items are creams and ointments which don't require any prescription. Only 13 minutes are portable medicines. That would I have
28, 29.
Yes, minutes. ಅದು 17
30 item ಇದೆ.
ಅದರಲ್ಲಿ 13 items, only 13 items are portable tablets.
No, sir.
ಅಲ್ಲ, I've counted it myself. 17 are creams and ointments.
Creams and ointments,
Yes.
many of them are derivatives of paracetamol and in anti-inflammatory.
But which may not require prescription. Which may not prescribe.
No, they may be over-the-counter tablets, but that does not mean Unani Ayurveda should stock all this.
No, there is one more lord's aspect to it. Lords, may I just draw my lord's kind attention to page 24. What the panchayat also says, the panchayat had rented out this premises to the doctor for free. But the panchayat certifies my lord that he was carrying on a pro bono practice. He was not even charging.
Pro bono?
How? Helter, if my lords were to see page 24. So the element of sale is absent here. But the element of sale is absent here. And then, my lords, there is one ruling of the Honorable Apex Court. Lords, there an occasion arose where, my lords, an amendment brought about to the rules in the state of Punjab.
Rules bitti sir, facts ಹೇಳಿ.
On facts alle. Now the Honorable Apex Court had an occasion, my lords, to examine as to whether, my lords, the non-existence of a qualification, my lords, would be an offense under the Drugs and Cosmetics Act. Otherly, my lords, what the Honorable Apex Court holds, that, my lords, the definition of medical practitioner under the Drugs and Cosmetics Act cannot be a deciding factor. And, my lords, the subject to a state
Yes,
enact-
Jagdish.
We should have noticed, my lord, once the search has been conducted, asking asking for explanation.
Explanation ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ನನ್ನ ಹತ್ರ ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಲ್ಲ
ಯಾವುದು ಇಲ್ಲ ಸೀಸ್ ಮಾಡಿದ್ರೆ.
He says, my lord, it is true when you visited there was a holding of stock of allopathic drugs which I don't have any license.
But may I just pass on this judgment, my lords? It may have
It's all
some.
right, we have said you have no license.
But I have no
Admitted.
license. I have no license. But
Admitted.
no, I have not. I cannot deny that fact. The only, my lords, issue that I would urge my lords to consider, what is the quantum of the medicine seized? Quantum, my lords, is, I would say, my lords, nowadays in any
even a common man's house, my lords, where there are 5 individuals, if my lords would check if these number of medicines. would
Then
be
you are
found.
saying like old patient is better than a new doctor. Yes.
13 my lords, only 13 are prescriptive drugs.
Mm.
And my lords, question is, my lords, whether that would, my lords, tantamount to an offense under the Drugs and Cosmetics Act. If my lords were to consider this judgment for a moment.
Mm.
And my lords, the element of sale is absent here. Complaint allu ellu illa, my lords, and the Panchayat also, my lords, they say that, my lords, I'm carrying on a pro bono practice.
Pro bono. The petitioner is before this court calling in question proceedings in CC 1929 of 2023 registered for offence so and so. The fulcrum of the allegation against the petitioner is storage of allopathic drugs, notwithstanding the fact that the petitioner has a license or is a Unani, Ayurveda and Siddha doctor. The search led to seizure of certain stock. The seizure is appended to the petition. The perusal at the items that are seized, i.e. the allopathic medicine, most of which are local applications. They are anti-inflammatory or identical to those that would not necessarily need a license, as they are over-the-counter ointments. A few of them are derivatives of paracetamol. It is these that were found in the The council, the petitioner himself has admitted that he has no license to store those drugs. Merely because of that storage or his admission, the offence under the Drugs and Cosmetics Act prima facie could not be laid against the petitioner unless the state would prove otherwise. There shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing, additional SPP, both. The learned counsel with the petitioner at this juncture would submit that he would not iterate the practice of storing allopathic drugs in his hospital, in his clinic. Yes, the undertaking
So
is
great.
placed on record.
So great.
Yes. Next.
Number 8.
Promise to marry.
Yes.
Yes, madam.
6 to file objection.
Seeks to file objection.
The respondent number interested to marry him, my lord.
Huh?
Petitioner na madve ಆಗೋಕ್ interest ಇದೆ.
Interest ಇದೆಯಾ?
ಹೌದು.
ಮದುವೆ ಆಗಿ
ಬೇರೆ ಜೊತೆ ಆಲ್ರೆಡಿ ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಫೈಲ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ
ನಿಮಗೆ ಮದುವೆ ಆಗಿದೆ ಈಗ?
ಇಲ್ಲ ಎಂಗೇಜ್ಮೆಂಟ್ ಆಲ್ರೆಡಿ ಫಿಕ್ಸ್ ಆಗಿ ಎಲ್ಲ
ನಿಮ್ದಾ?
ಹೌದು ಸರ್.
ಯಾವಾಗ ಮದುವೆ?
ಅದಾದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್
ಅದು
ಮಾಡಿಲ್ಲ.
ಎಂಗೇಜ್ಮೆಂಟ್ ಹೋಯ್ತು ತಾನೆ ಈಗ?
ಇನ್ನೂ ಇಲ್ಲ ಸ್ವಾಮಿ, ಪೆಂಡಿಂಗ್ ಹಂಗೆ ಇದೆ.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಕೇಸ್ ಕ್ಲಿಯರ್ ಆದ್ಮೇಲೆ ಮದುವೆ ಆಗ್ತೀನಿ.
ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಇನ್ನು? ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಬಿಕಾಸ್ ಅವರು ಶಿ ಇಸ್ ಅ ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ ಆಗಿರೋದ್ರಿಂದ ಈ ಮ್ಯಾರೇಜ್ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಿರೋದು. ಈ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಆಗಿರೋದು ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಶಿ ಇಸ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಟು ಮ್ಯಾರಿ ಹಿಮ್ ಅಂತ ಪಾರ್ಟಿ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಟು ಮೀ.
ಆಯ್ತಾಯ್ತು, ನೀವೇನು
8 years ರಿಲೇಶನ್.
8 years ಹಂಗಾರೆ ಮದುವೆ ಆಗ್ಲೇಬೇಕು. How can you leave her in the lurch?
But after that my lordship,
Hmm?
promise to marry is not
Promise to marry?
not attractive.
Not attractive.
And
ಯಾವ್ದು
my
ಬೇಕು
lordship,
ಮೇಡಮ್?
in expect of the atrocity, my
After
lordship, the incident has happened in the house, my lordship. Atrocity act to
ಆಯ್ತು,
attract.
ತೊಂದರೆ ಇಲ್ಲ. ಯಾವತ್ತು ಬೇಕು?
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮೈ ಲord.
ಕರೆಕ್ಟ್, ನಾಳೆ ಅಂತೂ ಆಗಲ್ಲ. ಎಸ್, ಲೆಸ್ ದ ಮ್ಯಾಟರ್. ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಆನ್ 16th, interim order subsisting will continue till the next date of hearing.
Great.
Fresh matter.
At the request of the learned counsel appearing for the respondent, less the matter. Yes.
Fresh list.
ಯಾರು ಗೊತ್ತು ನೆಕ್ಸ್ಟ್ ಯಾರು? My system may not be followed by others. Yes, next.
Petitioner in this case. Split charges.
Split,
Please. 399 and 402.
page.
26. Page number 20.
There is the order of acquittal. Yes, Rangaswamy.
Page number 26.
Page number 20. judgment.
26 paragraph.
Paragraph 10 and 11, madam. ಅಷ್ಟೇ ಇರೋದು.
ಅಷ್ಟೇ ಸಮಯ.
2.
10 and 11.
It's okay. Page 26,
10 and
paragraph 10
11.
and 11. The petitioner is before this court calling in, the petitioner accused number 6 is knocking at the doors of this court, calling in question continuation of proceedings in CC 30693 of 2014 for offences punishable under section 399 and 402 of the IPC. The petitioner along with the petitioner along with others gets embroiled in a crime number so and so 113 of 2013 for the aforesaid offences. At the relevant point in time, the petitioner was not available for trial. Therefore, the concerned court draws up a split charge sheet against the petitioner and tries the other accused. All the other accused have been acquitted of the offences by the order of the concerned court dated so and so. The concerned court, while acquitting others in CC 11404 of 2014, holds as follows. If the reason so rendered by the concerned court is perused, it would undoubtedly become applicable to the petitioner as well, as the offence is under section 399 and 402, which requires an act of being together. Since all the accused are alleged of the same offence, permitting further trial against this petitioner for eventual acquittal would be wastage of precious judicial time, the view of mine. Next. Adu same 10 ಅಷ್ಟೇ ಸೇಮ್ ಆರ್ಡರ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಅದ್ರಲ್ಲಿ ಯಾವ ಅಕ್ಯೂಸ್?
21. Page number 5.
5 and 6.
Page number 21.
ಅದರಲ್ಲಿ 21 ಪ್ಯಾರಾ ರಂಗಸ್ವಾಮಿ
Para number 13.
ಬರ್ಕೊಂಡ್ರಾ? ಎಸ್.
Serial number 86 same.
ಅಲ್ಲಿವರೆಗೂ ಕಾಯಕ್ಕಾಗಲ್ಲ.
11.
My lords, I appear for the petitioner. I apologize for appearing through video conference as I am not well,
Heard
my
the
lords.
learned counsel so and so. The issue is case and counter case. A perusal at the summary of charge sheet as obtaining in column number 17 would clearly indicate that the petitioners are the ones who have received the blows and the wound pursuant to the said blow. Therefore, there shall be an interim order of stay of further proceedings where the petitioners date of hearing. Next.
Grateful, please. my lords.
12.
Please.
38 proceeding.
ಪರವಾಗಿಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ 45 ಸಿಗ್ನೇಚರ್ ವೆರಿಫಿಕೇಶನ್ ಬೇಕಾಗಿಲ್ಲ.
P6 may kindly
No, sir.
bear mind it.
No, you have admitted the signature on the, you have admitted the signature in the postal receipt, that's enough. Check mail ಬೇಕಾಗಿಲ್ಲ. Next.
ಅಲ್ಲ ಚೆಕ್ ಅಲ್ಲ ಸಮ್ postal
Postal receipt ತಾನೆ? You have admitted that signature.
I am not admit, I am disputing that, my lord. That's why I make an application.
after
under
vacation.
section,
Next.
45, my lord.
List after vacation. Take chance. Non dismiss ಮಾಡೋದು ಬೇಡ. Next.
Any date after vacation. Because now
Move ಮಾಡಿ.
it is posted for arguments, my
Move
lord.
ಮಾಡಿ
Day
sir.
after
After
tomorrow.
vacation move ಮಾಡಿ.
ಅಲ್ಲ page number 74
ಅದು
may
move
kindly-
petitioner is liberty to move the vacation bench. Yes.
ಅಲ್ಲ
next.
74 may kindly peruse. my
No,
lord.
I have seen sir. Yes. Next.
13.
All the accused were acquitted, my lord.
Acquitted.
Acquitted.
2008 crime.
House
Okay,
SC number 54,
114.
2009 and.
ಒಂದ್ ನಿಮಿಷ
number
ನೀವು ರಂಗಸ್ವಾಮಿಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಅವರೆಲ್ಲ ಹೇಳ್ತಾರೆ. ಒಂದ್ ನಿಮಿಷ.
Page number 114. Para number 19, my lord.
Page number
114.
ಆಮೇಲೆ
114. Para number 19.
ಆಮೇಲೆ
19. Para number
19.
19.
ಬರ್ಕೊಂಡ್ರ? The petitioner along with others gets embroiled in a crime in so and so. In crime number 73 of 2008 for the offence punishable under section 395 of the IPC read with 86 of the Karnataka Forest Act. At the relevant point in time, the petitioner was not available for trial and therefore the other accused petitioners were not available for trial and the other accused were tried. The concerned court by the following order acquits all other accused except these
No.
petitioners.
No, my lord.
ಯಾರನ್ನ?
ಇದರಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, 3, 8, 2, 11, 15, 25, 26 ಒಂದರಲ್ಲಿ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಸೆಷನ್ಸ್ ಕೇಸಲ್ಲಿ ಆತರ ಬೇರೆ ಬೇರೆ ಇಲ್ಲೇ ಇದೆ 19 ಅಲ್ಲಿ ಇದೆ. ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 114 ಅಲ್ಲಿ.
So,
ಇನ್ ಕೆಲವ್ರಿಗೆ ಬಂದಿಲ್ಲ ಇನ್ನು.
the petition, most of the accused,
Yes.
most of the accused, the petitioners are accused 20, 21 and 22. At the relevant point in time, these petitioners were not available for trial and the other accused who were tried are all acquitted by the order of the concerned court. The concerned court in CC 862 of 2017 to acquit other accused has held as follows. In the light of so and so view of mine at the wastage. Next. Adu same.
ಅಲ್ಲది SC 53 ಮೇಲೆ 53
SC 53 of
2018.
ಅದು
Reject.
CC 86, SC 86,
ಬರ್ಕೊಂಡ್ರೆ ಚೆಕ್. SC 53 of 2008.
50. ಅಲ್ಲಿ.
Yes.
This is under the Forest Act. The provisions under which I've challenged.
Act, Forest Act, yes, sir.
Is
ಆಯ್ತಾ, sorry. ಸಮೇತ ಯಾವುದು?
Serial number 14, my lords.
ಇರೋ
If your
file
lordship
ಹಾಕ್ಕೊಂಡು.
sees, the provisions under which I've been charged are section 33 and 35. My lords may kindly turn to section
This would
33.
require his answer, sir.
Now, what has happened, my lords, the other important factual aspect, my lords, apart from the legal aspect itself, is that they also institute a land grabbing case against me in the year 2018.
What happened to that?
Now, the land grabbing case stands abated as against me because it does not fall within the notified limits for the
But does
purpose
not
of
mean
land
that
grabbing.
forest offenses
It
also
does not
should
mean,
go
my
away?
lords, it does not mean.
Yes.
Therefore, my lords, the only aspect, my lords, in the land grabbing case, they state that it is 9 acres, 8 guntas of encroachment. Whereas, my lords, the FIR says it is an attempted encroachment of 1 acre, 20 guntas. The charge sheet that is filed thereafter, after the land grabbing proceedings stand abated, my lords, in the year 2023, that also provides as 1 acre, 20 guntas. There is a delay of about 7 years, my lords, 2016 FIR. In the year 2023, they file an FIR. And continuous harassment, my lords, even as of 30th November, after the FIR is filed, I'm getting notices, my lords, day in, day out.
So notice
The
ಬರೋದು harassment, ah?
Allah, notice bandra Allah. They are coming to my house and every day they are harassing me. May I kindly pass on, my lords, even as of 30th November,
those are
I've got
64A proceedings.
64A
64A
proceedings ಅಲ್ಲಿ
proceeding.
participate ಮಾಡಕ್ಕೆ harassment ಏನಲ್ಲಿ?
Allah, now avagle proceedings participate ಮಾಡಿ. I've given a response in
It's
the
all
year
right. Don't
2023, my
become too
lords.
touchy about things. Yes.
64A proceedings, yeah, then if
Learned additional SP is directed to accept notice for the respondent. Don't take any coercive steps, sir.
we will not, but let him not take, by virtue of this order, my lord, 64A proceedings are pending.
Allah,
64A proceedings
kindly
ಇದಕ್ಕೂ
see, my
ಸಂಬಂಧ
lords,
ಇಲ್ಲ.
kindly see what has happened. I have already
The
responded to the
respondents
proceeding.
are restrained from taking any coercive steps in the matter till the next date of hearing, which would not mean that the respondents are restrained from continuing any other proceeding pending before any other fora under any other provision of law.
Now, my lords, what will happen in such a case, my lords? They will continue harassing me with these notices. Kindly see, my
ಇದನ್ನ
lords.
precipitate
ಅಲ್ಲ,
ಮಾಡಿ ಕೇಳಕ್ಕೆ ತಾನೆ?
detailed
ನೀವು
response ಮಾಡಿ.
ಇರೋ ಎಲ್ಲಾ ಎನ್ಕ್ವೈರಿಗಳನ್ನ ಇದ್ರಲ್ಲೇ stay ಕೇಳಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ,
I have said don't
inquiry-
precipitate
there's
in
only
this.
one inquiry, CC 1773 of
I have said don't
2024, my lords.
precipitate in this.
ಅದೊಂದು CC number ಒಂದು ಹಾಕ್ಬೋದು.
I have been
CC
told, my lord, that
1773 of
yesterday,
2024.
CC
1773 of
impugned
2024.
CC.
Impugned CC. my
ಅದು
lords.
ಅಷ್ಟು ಮಾತ್ರ. Yes.
Yesterday, my lord, under 64A, ACF has passed an order. It is on
ತೊಗೊಳ್ಳಿ.
64A proceeding.
GM ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ ತೊಗೊಳ್ಳಿ.
Anyway, he has an
Provided me a
appeal.
copy, my lords. This is
Copy.
after, this
We'll
came
get
up
it.
first on
Copy
Monday, my
ನಿಮ್ಗೆ
lords.
ಯಾಕೆ ಕೊಡ್ತಾರೆ? It should have gone to
Very
your
well.
client. Yes.
Alla, because this came up first on Monday. This is passed, my lords, only on the back of it.
Anyway, I have said don't take coercive steps in
Very
this.
well.
That should suffice.
Well,
Yes.
If the proceedings in the CC is also stayed, my lords, because they will precipitate the proceedings. The next date of hearing
Don't
is
precipitate ಅಂತಾನೆ ಹೇಳ್றது ಈಗ. Yes, next.
26/12, my lords. Adralli CC, if your lordship,
CC so and so.
CC
Yes.
1773 of 22. I'm grateful.
Yes, next. Why, sir? ಏನ್ ಒನ್ನೊಬ್ಬರ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರಂಗೆ ಫೈಲ್ ಅಲ್ಲಿ ಇಸ್ಕೊಳ್ಳಿ ಯಾರ್ದಾರು ಫೈಲ್ ಇಸ್ಕೊಳ್ಳಿ ಸರ್ ಯಾರ್ದಾರು ಕೊಡಿ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. Heard the learned counsel so and so. The petitioner is before this court calling in question registration of a crime in crime number 220 of 2024. A perusal at the complaint would clearly indicate that all events that froze in the year 2020 is sought to be exhumed in the year 2024 by registering the impugned crime in crime number 220 of 2024 without a speck of explanation for delay. Permitting further proceedings against this, further investigation against this petitioner would run foul of the judgment of the apex court in the case of Chanchalapati Das versus so and so, 2023 SCC online SC page 250. Therefore, there shall be next.
16.
Here for the respondent, madam.
See, PMLA case.
Animal trophy.
I'll just point out, just give me 2 minutes on the facts, my lords. My lords.
Section 3, sir.
Edwin, I'll just come.
ಪರವಾಗಿಲ್ಲ section 3 ಒಂದ್ಸರಿ ನೋಡ್ಬಿಡಿ.
ನೋಡಿದ್ದೀನಿ, my lords. Money laundering 21U. My lords, just the facts kindly notice, my lords. Edwin Vinegar, my lords, Vinegar He was a person who was aged about 101 years.
Vinegar?
Vinegar, my lords,
Got like-
vinegar.
Yes.
My lords, what he would do is, on the ground that his adopted son
Sir,
has.
fact, I'm fully aware of the facts because
minutes, my
I have
lords.
myself dealt with
How
this
the
matter.
2 minutes? Because, my lords, the allegation by him was his son tried to cheat him and breach of trust. My lords, FIR comes to be registered on 2/3/2023, my lords. Earlier in point of time, an FIR for cheating and breach of trust. Now, my lords, the elderly man falls sick, my lords. 8th, 9th, 10th, he comes to my hospital as an outpatient. He takes treatment. My lords, on 12th, at his house, he dies. My lords, I am to give a death certificate. I gave a death certificate. Time of death, my lords, we have shown is 5:30 a.m.
But he
1
had,
minute, my
he had
lords.
by then died.
I'm sorry. my lord.
He had by then died, I guess.
Morning he
11th
died.
He had died by then.
How do?
Or there is some divergence.
No,
with
my lords,
respect-
no divergence. They called me to the house. I examine him. He is dead. They requested a death certificate. Death certificate is given. Time of death was shown as 5:30 a.m. My lords, after 2 months, my lords, his son again comes to us asking for a death certificate. Now, when this death certificate was done, my lords, the time of death, instead of 5:30 a.m., is shown as 12:30 a.m. My lords, please notice this. Now, my lords,
because of that,
nothing happened.
No.
My lords, because of that, nothing happened. Please bear with me for a minute, my lord. My death certificate has resulted in nothing. My lords, please notice, my lords. After that, what the son would do is, he files a 482 petition in this court seeking for quashment of the cheating case.
Correct.
My lords, that 482 petition was allowed.
That was set aside by
My
the
lords,
apex
it
court.
went to the Supreme Court.
Came back.
When it came back, my lords,
I consider.
no, not that, my
Yes.
lords. No, before my lords heard, my lords, it came back. Investigation took place for this offense of 420 and 406. Charge sheet is filed, my lords, against his son that he has cheated. Now, in that charge sheet, my lords, I get arraigned as accused number 4 for the reason, my lords, according to them, I had issued a death certificate and I didn't have the OPD record. So why they bring me in is 201 is how they brought me into that charge sheet of 420. My lords, this is not a case of 302 or any other aspect.
No, I am not on that.
Wait, 420.
201. Yes.
So, my lords, when I was brought in on the ground of destruction of evidence, what the destruction of evidence, according to them in the predicate offenses, I did not have the OPD record. This is all there is to it, my lords. Now, my lords.
No, why did you vary the time?
My lords, in fact, my lords.
AM first death certificate.
My lords, in fact,
next
it was a,
death certificate at 12:30 AM.
my lords, it was a clear human error, my lords. But that 1 minute, my lords, our death certificate is not the subject matter of anything. My lords, death certificate is not the subject matter of the cheating case. Because, my lords, cheating according to the deceased was earlier, my lords.
Here, the death certificate has resulted in something because the entire, no.
That's where
The
I'm
property-
trying to point
the
out, my lords.
property was 750 acres.
Yes, my lords.
750 acres in Ooty, I guess.
Yes, my lords. Why he had a big
Ooty,
estate.
which this man, the old man of 100 years owned. And a real estate agent put him in the shed and stayed in the
Claimed
house.
to his adopted son.
Claimed to
He
be his
did
adopted
that.
son.
Yes,
He was
my
a real
lords.
estate agent.
Yes, my lords.
So he put him in the shed and
So father had
tied
given
him or whatever it is. Only he dies.
My lords, father.
When he dies there, at 12:30 AM is the death is
My
what
lords,
you gave first.
Allah.
Report of death was at that time.
My lords, that is not what their case is. Their case is one of cheating, which took place earlier in point of time where the son, my lords, he gets a gift deed and does a sale deed. That was what was questioned and subject matter of the predicate offense. It is nothing to do with the death certificate, cause of death, nothing, my lords. My lords, all right, in the predicate offense, now I'm shown as A4, my lords. For what? For destruction of evidence insofar as 201, nothing to do with 420, my lords. Anyway, let us take it as that, my lords. Now ED comes in. What ED does is, they say they have conducted an inquiry and they file a complaint. Now, in this complaint, my lords, when they say the money laundering has been done by the son.
Correct.
And how, my lords, how is it the doctor has been brought to the money laundering? Please notice their complaint, my lords. If it has an element of either money laundering or proceeds of the crime, then I have no legs to stand. Please notice the complaint itself. Not one element of 21U, not one element of 3. My lords, I will point it out from the complaint. All that they say is, my lords, the doctor had merely issued the certificate. That's all. Please notice that. If they have paid 1 rupee, my lords, if they paid 1 rupee as proceeds of the crime.
Free
then-
quota certificate.
Allah, my lords.
Certificate was free of cost.
My lords, certificate was free of cost. They don't even say I charge them. Complaint have nodi. Complaint.
Come to
ಅಲ್ಲಿ.
section 3, sir.
My lords, complaint have
Section
noted.
3, sir.
My lords, can I point out 2(1)(u) for a minute, my lords? I've got, my lords, I'll just point out money laundering a basic element, my lords, definitions, 2 definitions and 3. That's all that we need to see, my lords. Kindly notice the basic definition, my lords, 2(1)(u). And then I will show what the reverment is, my lords. Sorry, my lords. My lords, just prior to 2(1)(u), 2(1)(p) may be noticed, my lords. Money laundering, my lords would get that portion.
Yes, sir.
My lords, 2(1)(p), money laundering meaning assigned under 3. Now kindly notice proceeds of the crime, 2(1)(u). 2(1)(u). Proceeds of the crime means any property derived or obtained directly or indirectly by a person as a result of criminal activity. My lords, please notice this case for a minute now, my lords. What is a property or anything derived out of so-called proceeds of the crime? So far as the doctor is concerned, their whole case, my lords, doctor gave 2 certificates. Now, after this, with this, please notice 3, my lords. 3 will have a direct relevance on money laundering, proceeds of the crime. Because, my lords, my understanding of the scheme of this act is, my lords, you would have a predicate offense, you would have a proceeds of the crime in a predicate offense. Classical example is, my lords, in a case of cheating, 1 crore is a predicate offense. I have used it to purchase properties, is proceeds of the crime.
I know that.
Is proceeds, right?
Yes.
Just for my kid.
Yes.
And then, my lords, how the structuring of this PMLA happens is, as soon as you notice.
ಇಷ್ಟೆಲ್ಲ ಬದಲು knowingly assists and or knowingly is a party or actually involved in the process of activity connected.
Yes, my lords. With
Connected
proceeds of the crime.
proceeds of crime,
Ah, my lords,
including concealment, possession, acquisition, use and projecting. Amele, a person shall be guilty of the offense of money laundering if such person is found to have directly,
Yes, my lords.
indirectly attempted to indulge in one or more of the following process of activities.
Same, this
Concealment, possession,
Now, my
acquisition,
lords,
use,
please note-
knowingly, directly or indirect.
or proceeds of the crime. It all
That-
is relatable to proceeds of the crime.
Yes.
Now, my lords, please,
Proceeds of the crime need not be yours.
it can be anyone's, my lords. If I have assisted for proceeds of the crime, now in this case, it is not their case at all. My lords, according to them, proceeds of the crime is the cheating that was done by the adopted son who has sold the property and he has gained the money. If there was an element to say, I had any share in the proceeds of the crime, I have no legs to stand. That is not their case. Their entire case now, my lords. My lords, before I point the paragraph of my allegation, my lords, the structuring of PMLA as I see it is, my lords. My lords, as soon as you get a proceeds of crime, your first step will be how to ensure you're attaching the proceeds of the crime. That is where, my lords, 5 to 8. My lords should have noticed section 5 to 8, attachment and then confirmation. Then, my lords, if you still feel after issuing notices under 50, when I give my statement, if you feel I am also part of the laundering, then, my lords, section 3 and 4, where you go against me for a criminal action, you come with a complaint. This is how it's structured. Now, please notice the
One
complaint.
moment. Yes, Honorable Krishnan, sir.
My lord,
What is the doctor's role?
my lord, it is like this. I'll have to take, my lord. As far as the facts are concerned, my lord is very well aware. Kindly see page 88, the certificate issued by him.
Mike.
My lord, may kindly see the certificate at page 88 issued by the doctor. Initially, my lord, he would just issue the previous page, my lord, initially page 87. This is to certify that Mr. Edwin,
8:30 AM on 12/3/2020.
that is supposed to be the real, original, whatever it is.
All right.
After that, my lord, he says that he has lost all his OPD documents. He doesn't have anything. The computer disk.
Where is that?
My lord, it is said in the statement. It is also said in the petition. That is an admitted fact. He says that he has lost all his documents and he was,
Immediately after this.
he must have lost it. That is what he
Alright.
says. But then, my lord, after about 3 months, when the second respondent, the son, the person who's perpetrated all these crimes,
Yes.
approach him, my lord, this is what he gives on 1/5/2013.
Page.
It is the very next page, page 88. This is more of a report itself.
Detail
This is detail ಕೊಡ್ತಾರೆ. Instead of
This is to certify that Mr. Edwin Jobert so-and-so, aged about 101 years, male, admitted on 8/3 so-and-so, around 7:50 PM. Something generalized weakness, cough, fever, was treated so-and-so, IVs, etc. Patient was readmitted on 9/3/2013 at 3 PM and discharged at 9:30 PM, the same about treatment and so on. So then, my lord, on 11/3/2013 was admitted at 2:45 PM and discharged at 9:30 PM. Purposely, this is all timing.
1 minute.
And was
On
treated
what? On what date?
Same day.
on 11/3/2013
Yes.
was admitted at 2:45 and discharged at 9:30 PM.
All right.
That is to say, my lord, he could not have given the complaint. That's the reason. Was treated at, and the same above medications, the patient was semi-conscious, restless, and was not responding to oral commands from 8/3 till 11/3. Then, my lord, he was declared so and so and so. My lord, this particular certificate is given so as to show that he would not be in a position to have given a complaint at all. My lord, then what happens? It is not far to see. My lord, may kindly see this honorable court is initially quashed. In fact, it was quashed only on this ground.
That I know.
Only on this ground. Then the honorable Supreme Court would say, no, it requires. Now, my lord, coming to his role. My lord, he is now guilty of he's been accused of 201.
Yes.
My lord, could I take one judgment of the honorable Supreme Court, my lord, which is passed in
Then better.
Pavana Dibur. Adali, it clearly
Pavana
says,
Dibur gottaಯ್ತು.
even if he is not an accused, let
My
us
order is reversed by Supreme Court in Pavana Dibur. Yes.
my lord, my
120B is the offense.
120B, 420, and two other things which are schedule offenses.
No. Schedule offense, predicate offense 120B,
Oh, yes,
420,
yes.
201.
201 is not a predicate offense.
201 is not the offense.
201 is not.
Only 120B
Yes,
and
yes,
420.
Yes. So my submission is the petitioner need not be accused of a schedule offense.
120B,
As long as 120B and
Pavana
420B
Dibur,
of,
in Pavana Dibur's case, 120B was not the offense.
it was not the
I
offense.
had dismissed it.
My lord, what
but
happened
Supreme
there
Court-
in Pavana Dibu's case, 120B was the only schedule offense.
Yes, sir.
My lords,
So, my lord,
All right.
my lords, factual clarifications. Now, according to them, my lords, the death certificate was issued to show that the deceased could not have given the complaint and FIR. My lords, Annexure G.
This is
please-
why, Sandesh sir, I asked you, it is because of this certificate of 1/5/2013, it was held that he could not have registered the complaint
No,
at
my
all
lords.
because he was not
Thanks, within
responding to
5.5
anything.
No. It was not the reason for the
Right,
quashment. My lords,
yes.
on factual, let me just clarify. Please notice.
Yes, sir.
My lords, please have page 91 for a minute, my lords. Now, death took place on 12th, my lords. Now, no dispute so far as the death. Timing 5 hours here and there is what they say. And the reason they say is because of the death certificate, he could not have given the complaint. This is what they say. My lords has page 58. This is the information complaint which the deceased had given 58. My lords, now please notice, I'm sorry, it's not 58, it's 91. Please notice the date, my lords, at 94. Just notice the date, my lords. The complaint had been given by the deceased on 6/2/2013. 6/2/2013. My lords, the date assumes total importance. This 6/2/2013, my lords, endorsement given by the police is at page 95.
Sir, I
My
am
lords,
not
page-
going to split the hairs here
Don't
and
split the
consider
hair.
it. No, sir.
My lords, my certificate for proceeds
Any
of the-
other case, I would have definitely interfered. This case, we will not.
My lords, please notice,
You
if-
take chance after vacation.
my lords, can I point out one other aspect? If my lords would permit me, please notice the complaint.
Maybe.
Complaint only, if there's any element of saying there's proceeds of the crime, my lords, that I have, then I have no case. Now, if their own complaint is, I have nothing to do with the proceeds of the crime, how is it I'm an accused, my lords? How is it I'm an accused for a PMLA?
120B.
So I must have some proceeds of the crime. Zero.
Sir, not proceeds of the crime. Assisting someone who has the proceeds of crime, 120B,
My
sir.
lords, assisting someone in what manner?
That will be, yes.
holding.
My lords,
That I am
if it
completely
is a
aware of.
case of them telling that your death
Sir,
certificate,
this case I have heard in detail, and this I know the doctor did play a problem in this.
my lords, doctor's certificate has not been used anywhere.
No problem.
The 5 hours difference, a huge error, my lords, 5 hours.
No human error here.
Here,
Human error agidre, you would not have described a page purti the
my lords,
condition.
if it was a,
That's not the human error.
my lords, if
It is what you have given to the son and the son taking advantage of
didn't
that.
take advantage.
No problem.
It was not relied upon for the quashment.
750 acres, sir.
My lords, it was,
A real estate agent took away the life of this man and took away everything.
it is not a 302, my lords. It was ultimately 420, which was done earlier. And my death certificate is not used for quashment. I have not, no, it's not used.
No
My
problem.
lords has that order.
I am not on that.
And Supreme Court is,
120B, 3. That's all.
my lords, 120 for conspiracy pertaining to proceeds of the crime, my lords.
Take it.
Illi proceeds of the crime.
Immediately after vacation, not before. Any other bench you can. Because I've already dealt with this
Please.
matter. Yes.
Immediately after vacation.
Animal trophies, I clearly remember.
Adrima.
20
That's what the son has
2022.
done. What the son has done is totally unpardonable. But to say the doctor, a human error, my lords, when the second certificate was given, it was done by the staff.
Sir,
My
one
lords, a
minute, 1 minute.
50-bedded hospital, my
One
lords.
minute, 1 minute. If it's a human error, the second certificate would not be so descriptive.
My lords, staff prepares the death note, death certificate,
note.
death certificate gives it for signature. The doctor has merely signed it. My lords, in fact, my lords, this 12:30, 5:30, nothing, my lords.
It's
My-
worse then.
My lords, no, my lords, if it was a case of 302, then what my lords is asking me has relevance. But if it's a case of a cheating, which is purportedly done earlier, what is the relevance of the death note, death certificates?
We'll see it after vacation.
Please,
Date ಬೇಕಾ?
portray, my lords.
Okay. ಒಂದು ನಿಮಿಷ.
It may have to follow my lords, my lords. We will come, my lords. Let it be after vacation, my
I
lords.
thought you'd take chance.
ಒಂದು ತಾವು ಡೇಟ್ ಕೊಟ್ರೆ my lords,
It's,
because probably
this will
my
follow
lords,
me.
no, my lords, it'll follow my lords. It'll definitely follow my lords. And probably my lords, we'll keep troubling my lords, pointing out more aspects in the case. Because my lords, according to me, even 201 doesn't come. There's no destruction of an evidence. I will point it out when the challenge to the predicate
ಇವಾಗ
offense.
ಬೇಡ, time ಇಲ್ಲ.
Let it be.
6 January,
Please,
7
please.
January.
Please,
Yes.
please.
I thought it will come up before some
Illa,
other.
illa, it'll come before. So we'll trouble my lords in this case.
Yes.
17.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. The learned counsel for the petitioner submits that the petitioner, though is described as a director, is not involved in the day-to-day affairs of the day-to-day affairs. And therefore, this court on 9/12/2024 had passed the following order. Interim order subsisting will continue to the next date of hearing after vacation. Next.
18.
4 goats.
Yes.
Where is ready?
Interim order is given.
306, 4 goats. Illa, idu covered by so many judgments that I have written.
Plus, I'm relying
Yeah,
on
madam.
my lord's judgment only.
Idea. Judgments alla idea.
D. D'Souza and Singaravelu judgments, my lords.
David D'Souza.
Sorry, my lords.
David D'Souza.
David D'Souza and Singaravelu of this honorable court only.
ಇವರೆಲ್ಲಿ ಬರ್ಲಿ?
May I please give my case?
ಕೊಡಿ ಕೊಡಿ. We'll list it on 9 January for the hearing. Yes.
Lords.
Interim
Yeah.
order subsisting will continue to the
Can it
next date.
please
of
be
hearing. He's
treated
not
as
there.
part heard minutes?
For the hearing, yes. Next.
19.
Petitioner, my lords.
Ketan, only notice.
Please, my lords, here, my lords. Petitioner's younger brother filed criminal complaint before the respondent police saying that he has produced some rent agreements in the special CC case, my lords. Case, my lords, initially, respondent number 2 filed a partition suit in the year 2005. He is seeking a share in the self-acquired property of the petition number 1. Subsequent to that, my lords, he has filed complaint before Lokayukta. Lokayukta thereafter filed registered FIR.
Take chance immediately after vacation. List on 6th.
My lords,
In the
130.
fresh matters list.
Please,
Yes.
please.
Next.
20.
I'm for the petitioner, my lord.
In the meantime, yes. Today I've read the papers. 2:30 move ಮಾಡಬಾರದು ಅದಕ್ಕೆ. Yes, next.
Yes, my lord.
Stayed, madam. Stayed, madam.
Yes, my lord. Much of it.
21.
My lords had indicated that my lords
You're
will give me
taking-
liberty to file a discharge application on the next date.
ಯಾವ್ದ್ರಲ್ಲಿ?
My lords, this, my lords had heard the matter on
Oh,
last
this
discharge application on the opportunity. That's all I'm requesting.
discharge ಆಗ್ತೀರಾ?
ಆಗ್ತೀನಿ sir.
ಹಾಕಿ.
My lords, what has happened is that I've appeared in the matter, filed in, my lords may see page number 35 for a minute. What has happened?
ಅಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
My lords,
419, 420.
my lords, I'm only challenging, my lords, the difficulty is, kindly see page 35 for a minute.
Yes, sir.
My lords, so-and-so files NOC wakalat for the accused.
ಓ ಇದು ಡಿಸ್ಚಾರ್ಜ್ ಅಲೋ ಮಾಡ್ಬೇಕು ಅಂತ.
ಅಷ್ಟೇ. All my lords.
What stage frame ಆಗಿ ಚಾರ್ಜ್?
Charge frame ಆಗಿಲ್ಲ. Matters now on 7 January. My lords had indicated that my lords
Heard
will
the learned counsel. Petitioner is before this court. Petitioner, sir.
Only one
Petitioner is before this court. Calling in question the order dated 1/10/2024 in CC 7579 of 2024, whereby the concerned court denies the opportunity to the petitioner to file an application seeking his discharge from the area of accused. Heard so and so. The petitioner gets embroiled in a crime, in crime number 1400 of 2019 for offense punishable under section 66 CDE and 419 and 420 of the IPC. The learned counsel for the petitioner is at the doors of this court on an order that is passed by the concerned court, and the order reads as follows. Page
35, son, 30. The order dated 1/10.
110 matrana.
1/10/2024.
So and so. In terms of the said order, the counsel who had just then entered appearance on a no objection given by the earlier counsel pleaded that he be heard for seeking discharge from the area of accused. The court, without even adverting to any of his submissions made on the said date, has observed that no grounds made out for discharging the accused and posted the matter for framing of the charge. Not for nothing, the statutory provision, i.e. section 227 of the CRPC is in the statute book. When the petitioner accused has sought time to file an application seeking discharge or be heard on the said, the concerned court could not have, in the hottest haste, observe that no grounds are made out for discharging the accused when he has not even filed the same, or even submitted the same as he had just then on the said date entered appearance. In that light, the statutory opportunity of the petitioner has been lost by the sheer hurry by the concerned court to post the matter for framing of charges. In that light, I deem it appropriate to allow the petition, obliterate the order, and permit the petitioner to avail the remedy of filing a discharge as obtaining under section 227 of.
One more thing, my lords. They gave me the charge sheet. The complaint refers to CCTV footage.
ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅಲ್ಲಿ.
ಇಲ್ಲ, I went to file the application on 207. That application was not just on liberty to file any application.
So and so. The petitioner is at liberty to file any application before the concerned court, which shall be considered in accordance with law. With the aforesaid so and so. For the aforesaid reasons, the following order allowed, quashed. The matter is remitted. The petitioner is held at liberty to file an application for discharge if he so desires under section 227 of the CRPC, and the concerned court shall answer the same in accordance with law. The petitioner is also at liberty to file any application before the concerned court in accordance with undertaking. Nimdala, sir. Next. Yes. The petitioner, a student of the 11th standard, 18 years old, is now brought under the web of crime for that he had allegedly indulged in the offenses that would become punishable under section 354, 75 and 70, 75(2) and 75(3) of the BNS, which is 354A of the earlier regime, the IPC. The complaint crux of the complaint reads as follows, page 17, marked portion. The complaint itself is that it is generalizing accusations and does not specify by name any person in particular as a victim or accused. Therefore, the complaint is vague as vagueness could be. The order, the coordinate bench grants an order of interim bail to the petitioner. While so granting, the observation is as follows, page 24. In that light, a boy of 18 years should not be hauled into these proceedings and be permitted to continue his studies unhindered. However, on an undertaking that he would not indulge in such activities in future, the affidavit of undertaking reads as follows. On all the aforesaid circumstances that the petitioner has some psychiatric problem as observed by the court granting bail, as also the complaint being vague, I deem it appropriate to grant further stay of investigation till the disposal of the petition.
May I seek the indulgence, my lord. Can the complaint be quashed at this stage? Nothing survives. The college has no
Complaint leave, na?
difficulty.
No, we have no difficulty in that, so long as our role of compliance under section 19 is noted. It is between the prosecution and the accused.
What 19?
Section 19 of the POCSO Act mandating that if any information is there, our role is
They have
only to
done.
communicate it to the police, and that we have done.
Please, your lordship.
Huduga madli.
Grateful.
Boyful times lead to this. Undertaking will record. Adanne heard senior counsel anta ಮಾಡಿ ಅದನ್ನ format ಮಾಡಿ. ಅಷ್ಟೇ.
That one point may be noted.
Last request. Can the name be masked?
That will be.
Great.
And my
But
point
there is no private complaint. Bere complainant yarilva?
Illa, bari or. Page 17 is the only complaint.
we have forwarded
17.
along with the original complaint.
That's okay. But complaint itself is when nothing is said.
Yeah, that's what, just a request is that our compliance has been done, my lord. That may be
That I will
noted.
observe.
Please.
Madam, ಅದು JY, ಇದು complaint ಪೂರ್ತಿ extract ಮಾಡ್ಕೊಂಬಿಡಿ. Page 17. Letting
Great.
of the boy
Yes, I met him.
with the
in fact.
undertaking. If it is repeated, then it will be viewed serious.
I too have warned. Grateful.
No, ಓದ್ಲಿ ಪರವಾಗಿಲ್ಲ. Yes.
23.
Warrant is stayed anyway, after vacation. The order dated so and so shall continue till the next date of hearing. Yes.
24.
Heard the learned senior counsel Sandesh Chota appearing for the petitioner. The crime is set in motion despite the fact that an original suit in OS
number.
is pending consideration.
They withdrew that. They filed and they withdraw.
OS had been preferred by the very complainants in OS number
26198 of 2021.
26198 of so and so, and a writ petition in WP
WP number, my lords. 21636.
is pending consideration at the hands of the coordinate bench of this court. In that light, there shall be an interim order of stay of
There's also a legal bar. Sub-registrar
for
can't
the
give it.
proceedings.
Yes.
Yes, next.
Right.
25.
This is a case where I had submitted. Name is
A
an issue.
typical case of mistaken identity.
No, I have one request, your lordship, my lord. He has contested election in 2013 and 2019. Let him place this affidavits, madam.
Which affidavit?
To election, at the time of election,
Hmm.
they have to disclose whether they have criminal antecedents or not.
It's there. You have
ಎಲ್ಲಿದೆ
produced
ಕೊಡಿ.
it. It's on record only.
Page
They produced.
13-19 ಇದೆಯಾ?
Lords, they have themselves given me a clarity, my lords, if your lordship kindly come. I'll just. point
Clarity.
out. Lords, I'll just show.
Hmm.
98, your lordship may kindly come. Police verification.
Affidavit ಕೇಳಿದ್ದು.
Police ಪರಿಶೀಲನ ಪತ್ರ.
ಪರಿಶೀಲನೆ ಪತ್ರ ಬಿಡಿ.
ಅದರಲ್ಲಿ
ನಿಮ್ಮ ಪ್ರಮಾಣ ಪತ್ರ ಎಲ್ಲಿದೆ ಹೇಳಿ?
ಅಲ್ಲ ಪ್ರಮಾಣ ಪತ್ರ I have said, that is why my lord, my election petition is not an issue here, my lord.
ಅಲ್ಲ ಅದು ನಾಟ್ ಎನ್ ಇಶ್ಯೂ ಅಲ್ಲ. ಅವಾಗ ಏನ್ ಹೇಳಿದ್ರಿ ಅಂತ?
ಅಲ್ಲ ಅಲ್ಲಿ ಬನ್ನಿ 99 ಅಲ್ಲಿ ಇದೆ.
ಇವಾಗ ಯು ಪ್ರೊಜೆಕ್ಟ್ ಎ ಕೇಸ್ ಟು ಬಿ
Lords,
ಮಿಸ್ಟೇಕನ್ ಐಡೆಂಟಿಟಿ.
even then, my lords, please come to page 99, my lords.
ಅಫಿಡವಿಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡಿ.
No, they themselves, based on
ಅದು
this, I have said.
ಪರಿಶೀಲನೆ ಬೇರೆ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ, please.
We'll take it tomorrow. Get the affidavit.
Election affidavit. Based on this is the part of my election affidavit.
That is the police confirmation.
based on which I file an affidavit.
ಸರಿ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Very well, my lords, I'll have to find out on
ಲಿಸ್ಟ್
that.
ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಅದು ಸಾಯಂಕಾಲಕ್ಕೆ ಸಿಗುತ್ತೆ.
Even otherwise, my lords, I will only submit this.
It's available online. They can download it.
ನಾಳೆ
Online
ನಾಳೆ.
ಅವರೇ download ಮಾಡ್ಬೋದು if it's available online.
No, I have it.
They themselves say case number so and so ಅಂತ.
Madam.
Trial is, he was acquitted ಅಂತ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
Madam.
He wants to know something. ಕಲ್ ಆಜ್ ಅವ್ರ ಕಲ್.
EP judgment I have produced, my lords.
ಇದೇನು?
Even on
ಇದೆ
merit.
ಅಂತ ಹೇಳಿದಾರಾ?
ಆಗ್ಲಿ ತೋರಿಸ್ಲಿ. My lords, if the main judgment itself, if my learned friend sees,
Then there is no question of mistaken identity.
my lords, according to us, it is. Our police verification ಅಲ್ಲಿ ಹಂಗೆ ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ, ಪೊಲೀಸ್ ವೆರಿಫಿಕೇಶನ್ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ ಅಂತ ನಿಮಗೂ ಗೊತ್ತು.
My lords,
ಅಫಿಡವಿಟ್, ಪ್ರಮಾಣ ಪತ್ರ.
my lords, I am sure in that also we would have said there is, we have been acquitted in that case based on the police verification. That's why I said this will form the basis.
ಲಿಸ್ಟ್ ಟುಮಾರೋ ತಂದ್ಬಿಡಿ ಇದನ್ನ.
And otherwise, may I just point out one thing.
ನಾಳೆ heard the learned senior counsel K.N. Panindra appearing for the
ಅದು
petition.
ಕೊಟ್ಬಿಟ್ರೆ ಆಯ್ತು.
List tomorrow in the
ಅಲ್ಲ,
fresh
ನಾವು
matter.
ಕೊಟ್ಟರೆ mistaken identity ಆಗಲ್ಲ ಅಂತ.
On the
Because you projected it to be a typical
Because
case of mistaken identity. in
everywhere,
the
that's
last
how they
occasion.
have projected me. My lords, it can't be like that. That they are
But you have yourself projected something else.
based on the police verification report which they have given.
Tomorrow in the fresh matters list, yes.
On the main judgment, my lord, the main accused is acquitted. All of them are acquitted.
Yes.
Complaint is there.
Next.
26.
Take a copy of that.
26 same after vacation. Warrant.
27.
27 is same. In the meantime, next.
29.
State, sir. Allow ಮಾಡ್ಬೇಕಾ?
Well,
Stay ಮಾಡಿ. Yes, I have.
this is the conflict between the drug consumers and drug peddlers.
We'll file our statement of objection.
File, sir. Union of India.
ಅಲ್ಲ, ನಮಗೇನು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ.
We will file ಅಂದಿದ್ದು.
We will, okay. ದೊಡ್ಡ
ಮಾಡಕ್ ಮುಂಚೆ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಡಕ್ಕಾಗ.
ಅಲ್ಲ, ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ
Prepare ಮಾಡಕ್ ಮುಂಚೆ.
ಆಲ್ರೆಡಿ.
Heard the learned counsel appearing to the petitioner.
ಅಲ್ಲ, ಸ್ಟೇ ಇದೆ ಸ್ವಾಮಿ. This is
ಗೊತ್ತು ಇದೆ. We list the matter on 16th for the hearing. Entry models. ಇದೆ hydroganja.
ಅದೇ 35 grams importing.
Hydroganja.
ಅದೇ ಕೇಸ್ ಆಫ್ ಯುಫೋರಿಯಾ ವರ್ಸಸ್ ಪ್ರಾಫಿಟ್ಸ್.
ಗೊತ್ತಾಯ್ತು. Yes.
Grateful. Entry model may be extended.
Yes, sir. List on 16th FH. Yes, next.
30.
My lord, I appear for respondent number 3 in this matter.
3.
Vacating.
Counsel for petitioner, my lord. My senior engaged KSAT matter, my lord. Tomorrow, my lord, urgent.
Senior engaged in KSLT matter.
My lord, this is the issue with respect to the supply of shrimp, my lord. They had filed a memo on the last date of hearing to say a similar FIR has been lodged. On review of the FIR, it appears that our end customer.
ದುಡ್ಡು ಇಲ್ಲ, ಶ್ರಿಂಪ್ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ, my lord.
ಸೊ ಅದಕ್ಕೆ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ.
No, my lord. Tomorrow, my lord.
Tomorrow, no tomorrows. Yes. Interim order vacated.
Password, my lord.
KSLT is important. High Court important.
Tomorrow, my lord.
Passover. Yes. Passover.
Okay.
Next.
31.
We have paid 2 lakhs, 40. 2 lakhs is paid already.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
2 lakhs.
2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ನು ನೆಕ್ಸ್ಟ್
Next January.
ಯಾವಾಗ?
20 days.
ಆಯ್ತು. ಲಿಸ್ಟ್ ಆನ್ 16 January. ನೆಕ್ಸ್ಟ್ 2 lakhs.
ಇಲ್ಲ sir, more than 40 lakhs ಇದೆ.
ಅಯ್ಯೋ, ಅದು ಕ್ಲೈಮ್ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ತೊಂದರೆ ಇಲ್ಲ. The list on 16 January, interim order standing granted earlier stands extended, subject to the condition that the petitioner would pay 2 more lakhs by the next date. Yes, next.
ಇಲ್ಲ, amount mention ಮಾಡೋದು. ಇಲ್ಲ, they said they want to settle it before. ಜಾಸ್ತಿನೇ ಕೊಡ್ತೀವಿ.
This is 2 lakhs to the minimum. It can vary. ಅಂತ ಬರೀರಿ ಅಷ್ಟೇ. Next.
32.
Complainant Sunil Kumar ಏನಿದೆ? Why? CBI.
Yes, madam. The father.
Tarwan Prasann Kumar.
It's already served twice. Lordship has listed.
Where is he?
Already standing outside, my lord.
Standing, outstanding counsel. Get him inside. Yes. ಅಲ್ಲ ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಔಟ್ ಅಂದ್ರು ಅದಕ್ಕೆ ಬರಕ್ಕೆ. ಎಸ್. ಏನು CBI
32, sir.
Three
But
not
now,
two and,
the father of the victim has filed the petition, my lord. The offense under 376, 302.
It can't be decided today. We'll have it immediately after vacation. Yes, by 7th you get your objections or whatever you want.
Any date now.
7th, list on 7th January.
Please,
Next.
petition copy.
ಇದು ಅಷ್ಟೇ. Tahir, after vacation, list on 7th January.
88 also may be posted.
About 30?
88 lord.
88, tag along with 88, all after vacation. Yes, after vacation.
87.
ಅದ್ ನೋಡೋಣ ಆಮೇಲೆ ಮಾಡೋಣ.
7th lordship.
7th.
34.
PNDT, my lord.
PCPNDT.
No,
Jagdish.
no, my lord, there is no authorization to file the complaint. They have produced one document, my lords, styled as official memorandum, authorization, delegation of the powers, my lords. It's only to search and seize, to file, not to file the complaint, which is a important statutory power, my lord. That's not at all mentioned there in that.
Last line only says, my lord, if there any reason to believe that it may
Well
furnish
said.
evidence.
Pass over. Yes. Next.
35.
Your lordship, I will kindly be pardoned for appearing through VC, your
No
lordship.
problem.
Due
After
to-
vacation. Yes, next.
A specific date may kindly be given, your lordship. please.
8 January. Yes, next.
Highly obliged, highly obliged.
Appearing for the petitioners in this matter.
After vacation.
My lord, one submission, my lord. My lord, this is a resultant of a PCR filed, my lord. This is the counter complaint
No
for my
problem.
PCR,
List-
and my
list
lords
on-
have, my
list on-
lords have stated that
List on
PCR, my
7th
lord.
January. Yes, next.
A memo can,
File it in the registry. Yes, next.
37.
Yes, I am for.
ಇದು ಅಷ್ಟೇ. After vacation.
Before this honorable court, my lord.
ಅದು correct. After vacation.
ಅಲ್ಲ, stay ಆದ್ರೆ ಇರ್ಲಿ.
Stayನಾ?
Stay.
ಏನ್ stay ಬೇಕು?
Because they already issued notice. ನಮ್ಗೆ ಏನು notice ಕೊಡ್ತಾರೆ, they filed a charge sheet. Yesterday matter and day first matter.
Still charge sheet has been filed.
Alla, when I filed the petition, after that they filed additional charge sheet. They're not called upon to file any witnesses.
List tomorrow in the fresh matters.
ಅಲ್ಲ, ನಾಳೆ ಇರಲ್ಲ sir.
List after vacation. List on 7th. Yes, next.
Stay once.
ಏನ್ ಪರವಾಗಿಲ್ಲ.
In the meantime,
ಅವತ್ ನೋಡುವ. Yes, yes, no. Next.
38.
Chips, AVIO, I'll do the needful.
After vacation. Yes.
Entry board mix.
AVIO. Next.
39.
Post immediately after service if notice upon
Not
the
to be
respondent.
extended.
Interim order subsisting will continue. Next.
Yeah, wait, sir.
Post immediately after service if notice upon the respondent. Next. The 41A notice.
41 states undertake.
ಆಯ್ತು. Yes.
Tax my lord circular.
Circular issue ಮಾಡಿದಾರಾ?
Notice ಮಾಡಿದ್ದಾರೆ. All confusion, my lord, there was also subsequently circular has been issued with respect to following of Aranesh Kumar. So there are some confusion between these two. In fact, tomorrow, my lord, we have a meeting.
ಆಯ್ತು.
And
We'll
we'll rectify those.
for
corrections.
further hearing on 8th. ಹೆಂಗು ಬಿಟ್ಟಿದಾರಲ್ಲ ನಿಮ್ಗೆ.
Please, please.
Yes, next.
42.
for the petitioner.
For respondent number 2, my lord.
304B 498A.
Yes, yes.
Sir.
Yes, please. 498, 304.
304B.
Yes, 304.
Yes, husband.
Husband, not husband. Husband is not the petitioner. He is not before this court, my lordships. Accused number 2 is mother-in-law.
Correct.
Accused number 3 is elder sister-in-law.
Sorry.
Accused number 4 is younger sister-in-law.
Ah.
Accused number 5 is father-in-law's brother.
Ah.
Accused number 6 is mother-in-law's brother.
Ah.
Accused number 7 is my lord's father-in-law's brother's wife. All the family members, my lords, have been roped in.
Mother-in-law ಬಿಟ್ಟು ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಸ್ಟೇ ಮಾಡು. Yes.
Lord, the undertaking as well as objection.
ಬೇರೆಯವ್ರಿಗೂ ಇದೆಯಾ?
ಇಲ್ಲ, R2.
R2 ಬಿಟ್ಟು ಬೇರೆ. Yes. R2 ನೀವು
Then
mother-in-law
R2.
ಬಿಟ್ಟು ಎಲ್ಲರಿಗೂ ಸ್ಟೇ ಮಾಡ್ತೆ.
No, my lords, even to,
No, sir.
my lords, please
Yes.
permit me to.
If you want mother-in-law, you will lose other-in-laws. What do you want?
All the petitioners,
You
my
want
lords,
mother-in-law or other-in-law?
100 kilometers ದೂರ ವಾಸ ಇದ್ದಾರೆ ಎಲ್ರು.
ಅದಕ್ಕೆ ಅವ್ರನ್ನೆಲ್ಲ ಸ್ಟೇ ಮಾಡ್ತೀನಿ.
Including mother-in-law, she was also residing in Kalburgi. my
No
lords.
problem. Yes.
His sister and husband, my lords, were residing in Bangalore.
ಪರವಾಗಿಲ್ಲ. Influence of mother-in-law is more.
Not even on that allegation.
One HCGP, 2 learned counsel so and so undertakes to enter appearance for the second respondent. Perusal at the charge sheet filed for offense punishable under so and so would not indicate any offense against all the accused, except the accused number 2. All the members of the family are roped in the criminal case, so in CC so and so. Therefore, there shall be an interim order of stay qua accused number 3, 2, 6. Insofar as the accused number 2 is concerned, the same would be considered on the appearance of the complainant. Yes.
Please.
Take notice. I will.
43.
I'm filing for the respondent, your comparative table for, this is about the exoneration in the department inquiry and parallel quashment of parallel proceedings. I'm filing
ಕೊಡಿ.
identical.
ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ?
ಅಲ್ಲಿ 4 ವಿಟ್ನೆಸ್ PW4 ಎಕ್ಸಾಮ್
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ನಾನು ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. ಎಸ್, ವಿಲ್ ಡಿಸೈಡ್ ಇಟ್ ಫೈನಲಿ.
ಎಸ್,
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ನೋ ಇಂಟರ್ಫಿಯರೆನ್ಸ್.
ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Complainant party ಇಲ್ವಾ? ಮಾಡಿ. Learned counsel of the petition is directed to implead the complainant as a party respondent to these proceedings. ಈಗಲೇ ಮಾಡಿ. So and so. Let's ಅದು ಟ್ಯಾಗ್ ಮಾಡಿ ಮೇಡಮ್ along with other case. Next. ಈ 7 ಅಲ್ಲ 30 ಇದು ಡಿ exoneration.
44.
In the meantime, next.
55.
44. There is interim order of stay.
I have list after vacation. I vote till the next date.
There is another matter.
Heard the learned tag ಮಾಡಿ. Heard the learned counsel Bipin Hegde appearing for the petitioner. One notice ಆಗಿದೆಯಾ? One.
Last time, your lordship, remember, my lord, that because their contention was that they sought for a permission was not granted.
ಇದ್ಯಾವುದು?
44, my.
44 ಬಿಡಿ. ಇಲ್ಲ, permission was not granted. It is clarified permission was
Correct.
sought.
And
ಅದಕ್ಕೆ
permission
anyway
was-
ಎರಡು ಸಾರಿ ಮುಗಿಸ್ಬೋಣ. Yes, so and so. ನಿಮ್ದ್ರಲ್ಲ?
Observation in the connected matter, please, my lord.
ಎಲ್ಲಿದೆ connected matter observation ಗೆ?
ಅದು ನೆನ್ನೆ ಇತ್ತು, ಅದರಲ್ಲಿ my lord, the court had directed to
ಆಯ್ತು,
secure
ಎಲ್ಲಿ?
instructions. ಅದೊಂದು
ನೆನ್ನೆ ಇತ್ತ ಅದು?
ನೆನ್ನೆ ಇತ್ತು, ಅದು your lordship directed to list it today, but my lord,
Anyway, will expunge those observations.
so ಅದಾದ
ನೆನ್ನೆಗೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಅದು. ಇನ್ನೂ ಸೈನ್ ಮಾಡಿಲ್ಲ ಅದು ಮಾಡ್ತೀನಿ.
please.
ಇಬ್ಬರ ಮೇಲೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡೋಣ, ಸರಿ ಹೋಗುತ್ತೆ. ಎಸ್ ಎಸ್ ದಿ heard the learned counsel Bipin Hegde appearing for the petitioner. The petitioner is before this court so and so. A reference is made by the learned magistrate under section 156(3) on a private complaint so registered without the private complaint being in compliance with the judgment of the apex court in the case of Babu Venkatesh versus so and so, 2022 SEC online essay 200. Therefore, there shall be an interim order of stay. Yes, sir.
46.
My lord,
AVIO.
my
Interim
lord,
order ಇದೆಯಲ್ಲ?
SPP
Not,
not in
I
state.
request my lords, despite my lords now directing the SPPP to be present today is not here. But may
ನೆನ್ನೆ
say that
ಹೇಳಿದ್ದೆ.
fact-
ಅದೇ ಮಾಡಿದ್ದೀನಲ್ಲ.
ನಾಳೆ
Yeah, no, my lords have not stated. My lords have only directed no coercive action.
SPP ಇಲ್ಲ ಇವತ್ತು, ನೆನ್ನೆನೇ ಹೇಳಿದ್ರು ಅವ್ರು. Tomorrow. Fresh matters. Yes, next.
My interim order may be extended.
Same order, whatever is there. Prasanna Kumar, home buyers, huh?
Home buyer
In the meantime, next.
is 49
Same, 48, 49 ಎಲ್ಲ same.
and not 69.
ಎಲ್ಲ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
Please, all,
50 is 7A,
please, 50 ಅಲ್ಲ 7 13.
13 ಸರಿ 13 ಟ್ಯಾಗ್ ಮಾಡಿ ಮೇಡಮ್. ಸೇಮ್
That interim order not island.
ಸೇಮ್ ಸೇಮ್.
Similar.
ಏನು ಸಸ್ಪೆನ್ಷನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಾ? ಎಲ್ಲದ್ರಲ್ಲೂ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗೆ ಹಾಕಿ ಸರ್. ಎಸ್.
Please.
51.
Home buyer. Earlier they filed a PCR.
ವೆದರ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್ has gone wrong. ಓಝೋನ್ ಎಲ್ಲ ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಿ.
Your lordship, my lord, this the registration of this case, my lord, travels against your lordship's judgment. Your lordship said that, my lord, the RERA registrations have to be revived. Earlier, they come, my lord, file a PCR alleging offences under KPID Act. That was quashed by this honorable court. Direction was issued to my lord to restore the complaint. My lord, the court process is still pending. They will, my lord, walk into the office of the Commissioner of Police. Commissioner of Police, my lord, would now endorse, register KPID FIR. My lord, KPID Act.
You have walked into the doors of this court.
What to do, my lord? The sheer misuse of, my lord, police powers. There's a reference made is still pending. This honorable court, my lord, put it back to the court below. That is pending. Commissioner, my lord, they participated in the proceedings. Commissioner of Police, my lord, does, my lord, this forum justice.
Forum justice.
Yes, something like that, my lord. The police have become, my lord,
SPP is directed to act. Copy kodi.
movement I say, my lord, something.
Tomorrow in the fresh matters list. Copy kodi ivatte.
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅದು KPID ಇದೆ.
KPID ನಲ್ಲಿ only one thing, my lord, which I will show to your lordship. Kindly, my lord, see the operative portion of the previous order of, my lord, this honorable court. 141, my lord. 141. This is the previous order. The reference order under so and so. Registering FIR dated is hereby set aside. Complaint is restored to principal city civilians. This has to happen. My lord, independently, my lord, surpassing this.
Second complaint like this. Yes, sir.
Third complaint, my lord, two complaints. Soon after this, they file one complaint, which lies in the office of the Commissioner of Police. Now, my lord, that, my lord, passes its time. In, my lord, October, my lord, once again another complaint is given. In November, my lord, December, my lord, the police commissioner says, register case. Lord, KPID Act, my lord, I am baffled to know how, my lord, the police can straight away register. There has to be competent authorities report.
No.
And, my lord, classifying a builder as, my lord, deposit taker, my lord, is something which is unknown to law. How can builders become deposit holders?
You build on deposits.
Yeah, I do agree, my lord. It has to be a financial institution. My lord, a law which is meant for financial institutions is being used against
KPID
builders.
cannot be invoked. ಸುಮ್ಮನೆ ಸಿಕ್ಕಿದ್ದು invoke ಮಾಡ್ತಾರೆ.
I'll have
ಅಲ್ಲ, it is meant only for financial institutions. There should be, how can Ozone Urbana be declared to be a financial institution? Loan ಮಾಡಿದಾರಾ? Loan ತಗೊಂಡಿದಾರಾ? They are builders. They may be horrible. That's a different thing. But KPID cannot be invoked against them. KPID invoke ಮಾಡೋದು ಯಾಕೆ ಅಂದ್ರೆ to project that yes, there is something big. Nothing. Financial establishment ಏನೂ ಇಲ್ಲ.
ಬೇಕಾದಷ್ಟು ಕಾನೂನುಗಳಿದಾವೆ ನಮ್ಮನ್ನ, my lord, they have already, my lord, crushed us like anything. Why, my lord, one more KPID?
You have crushed so many, sir.
ಇಲ್ಲ. In fact, NCLT has observed that my buildings are complete and, my lord, possessions are being given. This is what NCLT observes. My lord, RERA, NCLT, ED, Consumer Court, CBI.
ಲಿಸ್ಟ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ.
ಅಲ್ಲ, ಹೌದ್ರಿ, ಎಲ್ಲ ಇದೆ.
ಅದು ಎಲ್ಲರಲ್ಲೂ ಅವರೇ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
ಎಲ್ಲ ಇದೆ. This kind of. ಅಲ್ಲ, it's counterproductive also. Because
That's why I said, ಇದರಲ್ಲಿ ಓಝೋನ್ ಏನಿಲ್ಲ, ಬರೀ ಕಾರ್ಬನ್ ಡೈಆಕ್ಸೈಡ್.
ಅಲ್ಲ,
ಏನು ಇಲ್ಲ.
my lord, at least we are keeping Prasanna Kumar busy.
Only,
we are
Allah.
keeping Jagdish busy.
No O2, only CO2. Yes. Yes, sir. ನಾಳೆ.
Allah, in fact, Jagdish has it, my lord. That's the reason. He has already gone for that.
KPID ಬರಲ್ಲ.
I'll have it. Look at it.
But Shyam Sundar sir, it's pleasure to hear him. ನಾಳೆ ಮತ್ತೆ hear.
Allah, my lord, tomorrow
It's a
we don't
pleasure.
want to, my lord, suffocate your lordship's court. My lord, today it was a rarity for me to say, my lord, the honorable court. Lord is, my lord, at
Your
least.
lordship have it in January, my lord, further hearing it.
All right, list on 9th January.
Again, ನಾಳೆ ನಮ್ಮ busy engagement.
List on 9th January. The learned senior counsel, M.S. Shyam Sundar, appearing for the petitioner, would contend that the offence under the KPID cannot be laid against these petitioners who are developers. They are not a financial institution as obtaining under section 9
Yes.
of the KPID Act for laying an offence under the KPID. In that light, there shall be an interim order stay of further proceedings qua these petitioners, further investigation.
Yes.
Qua this
further-
petitioner, ಅದಕ್ಕೆ ಮುಂಚೆ, apart from plethora of grounds projected by the learned senior counsel, 16 January. 16
So great. So great. It's a rarity to see, my lords, your lordship's court is not clogged today.
Early.
That may be by option of your lordship's, my lord, not taking too many memos.
Not taking
Because
too
I
many
don't know
memos.
where I'll be next.
It is like, my lord, getting Tirumala Tirupati Darshanam, my lord, in
It's ಜಾಸ್ತಿ. ಎಲ್ಲ ಓಕೆ, ಇದ್ಯಾಕೆ?
Allah, my lord, that darshan, my lord, is easily available sometimes.
ಆರ್ಡರ್, ಈಗ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದಿದ್ರೆ ಇದು ರಶ್ ಇದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ ಅಂತ.
So great.
More than 6,000 memos and still.
ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ.
ಇನ್ನೂ ಬೇಕು.
In fact, my lord, we have great, my lord, empathy for Mr. Jagdish also. As the memos are keeping my lords busy, it's same with my lord, Mr. Jagdish also, my lord. We are forgetting, my lord, Mr. Jagdish is also, my lord.
Are you saying you have empathy there and sympathy here?
In fact, my lord, we have all added to the torture on your lordships, my lord. That we conceded the
Interim order vacated.
So great.
Yes.
We will continue investigation, my lord, since your lordship is vacated.
Vacate. Sir, investigation will go on. Yes. He wants to continue investigation.
They'll be doing a mockery of my lord KPID if they do.
Right,
So
yes,
great.
sir.
Orders 52.
ಇದು 7 ಇರ್ಬೇಕು after vacation. ಆಯ್ತು. Yes.
53.
53.
For the petition in this case, my lord, yesterday matter was listed, my lord, your lordship is to file an affidavit. The petition is going to abroad, my lord, for job, for searching job, my lord.
I'll take it in the afternoon.
My lord,
I'll take it. There's one meeting at 1:15. So yes.
may I file an affidavit?
File ಮಾಡಿ.
Affidavit along with the visa as well as the air ticket.
I will take it tomorrow then. File the affidavit.
Tomorrow is journey date, my lord.
Journey date. Wait then. Sankal. Pass over. Yes.
54.
After vacation. Yes.
55.
54, I'm appearing for respondent number 2, my lord.
List after vacation.
For vacating
Yes.
stay, my lord.
ಇವತ್ತು ಮಾಡ್ತೀರಾ argument?
Please.
Seriously? After vacation. Next.
Any date, my lord?
No.
55.
Post immediately after service of notice upon the respondent. Interim order ಇದ್ರೆ continue ಮಾಡಿ.
55.
2 weeks to do the needful. Next.
7.
57. Office objections.
B report has been filed, my lord, by the
50
police against them.
But respondent yaru?
Respondent party in person.
All right.
Who has
Yes.
filed 32 cases.
That's all right. List tomorrow. Tomorrow you have another case.
My lord, today only, my lord.
No, tomorrow you have another case.
My lord, today itself, other cases are
Serial
listed in
number
the same.
61.
ಇದ್ದೇ ಇದೆಯಾ?
Serial number 61 ಇದೆ sir.
Okay, pass over.
70 and 71.
Pass over. Next.
58.
20th ಅಂತ ಹಾಕಿದ್ 19th ಯಾಕೆ ಹಾಕಿದ್ರಿ ಅದನ್ನ?
Please, my lord, office objection is in respect of non-submission of the transcription.
Overruled tomorrow.
And that, please, my lord, the interim order is.
Tomorrow ಇದೆಯಾ? Interim order ಇದೆಯಾ?
No, no.
Overruled tomorrow. Yes.
59.
Needful has been done today. Interim order.
Council submits, needful has been done. Office to verify, interim order. Next.
Interim order is done.
Continues. Yes. Next.
For petitioner, my lords.
Hmm.
My lords, there is no marriage between the petitioner and the first
Interim order
respondent,
ilva?
my lords. No, my lords. It's coming up for the first time, my lords. And
List
there is no
tomorrow. Yes.
There is no marriage between the petitioner
List
and the
tomorrow in the
respondent.
fresh matters list.
Please.
61.
ಓ ಇವ್ರದೇನಾ? Pass over. Yes.
ಇದರಲ್ಲಿ I undertake to file ಕಾಲ.
ಆಯ್ತು, ಎರಡು ಸಾಯಂಕಾಲ ತಗೊಳ್ಳೋಣ. Yes, next.
ಸಾಯಂಕಾಲ.
ನಾಳೆ ತಗೊಳ್ಳೋಣ. Tomorrow, both tomorrow. Yes, next.
62.
My lord, humble submission.
Tomorrow,
Tomorrow ಮಗು ಸ್ಕೂಲಲ್ಲಿ ಹೋಗ್ಬೇಕು.
ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ಬೇಕು.
ದಯವಿಟ್ಟು ಇವತ್ತೇ.
ಆಯ್ತು, ಸಾಯಂಕಾಲ after you come at 4 o'clock. Yes.
My lord, serial number 70 and 71 also connected.
How many cases are?
Suppose just for clip.
ಆಯ್ತು, fine. Yes, next. Next.
62.
The objection copy ಹಾಕ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ, that is, they have not filed any objection, that is the
Agency ಇದೆಯಾ?
ಅದೇ ಅದರಲ್ಲಿ the order of acquittal amounting to acquittal has been set aside in the revision petition, appeal ಹಾಕ್ಬೇಕಿತ್ತು, that is squarely covered by
Office objections overruled.
decision
Interim order ಇದೆಯಾ?
page 26.
Stay ಕೇಳಿದ್ದೀರಾ?
ಹೌದೌದು, already this court has.
In the meantime, next.
63.
In the main prayer, there is a second prayer has. to
Office
be-
objections overruled. Urgency ಇದೆಯಾ?
Pardon?
Urgency ಇದೆಯಾ?
Yes, sir.
Tomorrow. Yes, next.
Your lordship, IA is there.
ನಾಳೆ.
Lord, for the petitioners in this case, my lord. Lord, office objections ಇದೆ.
Overruled. Yes.
Lord, ಇದರಲ್ಲಿ 1 to 8 to 3 ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ನೀವೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದೀರಾ?
Page. Number. Tag. So and so, same, next.
Lord, in meantime, it could be granted. my lord. Page number 107.
65.
55.
Amazon, yesterday,
Amazon,
Yes, directors, my lord, with regard to contribution of the employees' provident fund, 7,000 and 26,000, that they themselves had said that it should be deposited in their respective account. And that has already come back. They have given it.
Heard the
also.
learned senior counsel, Gurdas Kannur appearing for the petitioner. The office objections overruled. The offences alleged against this petitioner is 415, 418 and 420. The allegation is non-deposit of the provident fund amount to a particular account. The learned senior counsel taking this court through the documents appended to the petition would seek to demonstrate that the provident fund amount is deposited into a wrong account according to what the authorities had indicated to them. Therefore, according to what the authorities had indicated to them, therefore, there is no violation of the provisions of the Provident Fund Act per se. Therefore, there shall be an interim order stay of further proceedings by the petitioner to the next date. Yes, next.
66.
Same as 24, my lord. Renaissance, remaining accused.
Stay ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ?
ಹೌದು, stay ಕೊಟ್ಟಿದೆ, 24.
Tag along with so and so office objections overruled, interim order. Next.
57.
For the petitioner, my lords will recall, this is where the party in person appears and it's a second FIR.
ಯಾವ್ದು sir ಇದು?
Second FIR, Mr. Holla appears in this matter. Shares of.
After vacation.
May I just request one thing, my lords? 4 times the party in person has somehow avoided hearing. This matter was taken up on 15th October at 4 PM and heard at
Interim
length.
order ಇದೆ ತಾನೆ?
Please,
After vacation.
may I just request it
Interim order
before for
extended. Yes, next.
further hearing on that?
No. Yes, ಸುಮ್ನೆ ಇರಿ sir.
My lords had heard it on 15th
ಪರವಾಗಿಲ್ಲ,
October at
yes.
4 PM.
Let others also hear it. Yes, next.
Please. Office objections may be overruled.
Office objections overruled.
Lies.
Next. Arjun,
58.
ಮನ್ಮೋಹನ್ ಏನಿದು?
Please, Lord.
Hear ಮಾಡ್ಬೇಕಾ?
Out from has to be, interim order may kindly be
After
considered
vacation.
after vacation. But,
AVIO, interim order ಇದೆಯಲ್ಲ?
Illa, that's the
ಇಲ್ವಾ?
only, illa, that
Case never
Can I
appeared,
just-
Lord.
Can I just
FIR
take
is not of, after, FIR is, this petition is filed not after 13 years.
our
Yes.
petition, if my learned
I-
friend
I-
could give me
I-
one
books, please.
quick opportunity, I know the court is short of time. But short point is, there is a development agreement has gone bad. The
But
company,
why
went-
have you come to the court so early?
but what had happened was I was under arrest in some other proceeding. In some other unconnected proceeding, I was in detention. This is a fact of the matter. I've said so also. It is what it is. I mean, I don't want him to be the guest of state of Karnataka also. He's been state of ED, otherly
We'll
guest
hear
of
it immediately after vacation.
Please.
Heard the learned senior counsel C.K. Nandakumar, list on 7th January.
Can I just one short point if I can? There is an NCLT order holding in my favor. Point is, I paid them 35 crores. That money is not been returned. NCLAT now holds, they go and appeal to NCLAT and they lose now. So therefore, petition,
ಇದಕ್ಕೆ
criminal proceeding may not.
7th January.
Great, please.
Next.
59.
Same. ಪ್ರಸನ್ನ ಕುಮಾರ್, ಇದು 3 ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ, 48. ಸೇಮ್ 49 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ. ಡಿ ಅಲ್ಲ, 49 ಬೇರೆ. 47, 40 home buyers, 47, 48, 49 and 69. Same tag, same order. Office objections overruled. Yes, next. 70, 71 pass over. 15th, yes, fine.
Great.
70, 71 pass over.
72.
Vacating the interim order.
Please, my lord.
Placed immediately after vacation.
Your lordship, if I may submit for a moment, my lord. In this
Sir,
case,
ಇವಾಗ ಎಲ್ಲಿ ಕೇಳಕ್ಕಾಗತ್ತೆ?
responding number 2 has been suffering from cancer, my lord. I've been.
Oh, wait, then pass over. Yes.
My lord, petitioner counsel, my lord, he prays for time.
He's suffering from cancer.
ಅವ್ರಿಗೂ ಮೆಡಿಕಲ್ ಎಮರ್ಜೆನ್ಸಿ ಅಂತ ನಾನು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ.
ಆಯ್ತು, tomorrow, let's tomorrow in the fresh matters.
6th or 7th, my lord.
Fresh matters, let's tomorrow, next.
6th or 7th.
No, sir. Yes.
ಅವ್ರಿಗೂ ಮೆಡಿಕಲ್
ಅವ್ರು
ಎಮರ್ಜೆನ್ಸಿ.
ಕ್ಯಾನ್ಸರ್ ಇನ್ ಸಫರ್ ಆಗ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. What's your problem?
ಅವರು ನನಗೆ ಏನು ಮೆಡಿಕಲ್
All right,
ಎಮರ್ಜೆನ್ಸಿ.
list the matter on 7th, interim order stands vacated. Next.
ಟುಮಾರೋ ನಾನು ಹೇಳ್ತೀನಿ ಅವ್ರು.
Tomorrow.
Please,
Tomorrow,
please.
next.
73.
Early hearing. Alla, early hearing. Suspended?
Without notice. My license is valid up to 26, sir.
Yaru, Ashok Kumar Shetty.
Yes, my lord, my colleague.
Early hearing again, madam. Post the matter on 7th January.
Stay. My
Early
IAF
hearing hakidira.
Yes, sir, because I'm involved in politics and I need to travel.
Politics, interim order already, the interim order subsisting will continue till the next date of hearing. Next,
Date may be fixed, my lord.
7th January.
7th Jan. Okay.
Yes, madam.
54 minutes. Appear for the petition.
Admission?
That's the private.
Interim order idea?
Yes.
After vacation. Yes, next.
Appear for respond.
Abhinay,
Appear for the-
after
So-
vacation.
Matter was heard on couple of occasions where Mr. Amar Korea was appearing on the other side. where the
ಅದೇ
interim
ಓ
order-
ಇದು ಒಂದನ್ನ
ಒಂದು
dismiss
pass
ಮಾಡಿದ್ವಲ್ಲ.
ಮಾಡಿದೆ.
ಅಷ್ಟೇ.
After vacation.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ?
I have
My interim order is the final order.
That is.
But even on that itself, my lords, interim order captures one important fact.
But some
which
ignore
civil-
some fact.
civil- which lead towards civil litigations with
All
which
right,
my lords
sir.
have observed.
List on 16th for the hearing. Yes, next.
Obligement.
76?
My lord, I have entered
Interim order
appearance.
ಇದೆಯಾ?
Huh?
Interim
Interim order ಇಲ್ಲ, due to non-appearance on the last occasion, please, my lord, it was not heard.
Puneet, you are not here?
My lord, I have entered appearance now.
Learned Counsel Puneet, so you're Puneet, right?
Puneet C, please.
Puneet CP submits that he has entered appearance for the petitioner after vacation.
ಅಲ್ಲ, charge ಗೆ 4ನೇ ತಾರೀಕಿಗಿದೆ, next month.
ಏನು offense
Destruction
offense
of
ಏನು?
public property, please, my lord. It is only
See,
this much.
List the matter on 15th January till the concerned court shall defer its proceedings till the next date.
Please.
Yes, next. One notice ಆಗಿದೆಯಲ್ಲ ಇದು?
Notice.
ಆಗಿಲ್ವಾ? One HCGP to emergent notice.
Please.
Yes, Suyog,
27?
My lord,
interim order ಇದೆಯಾ?
interim order operating, I filed an application for vacating.
Immediately after vacation ಕೇಳೋಣ.
My lord, your lordship has also suggested for a payment of money, my lord, 1,300 bags cements ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ತಾವೇ.
ಆಯ್ತು, immediately after vacation.
I'm not.
ನೀವಲ್ಲ, ಸುಯೋಗ್, list immediately after, list on 7th January. Yes, next.
78?
78 again, my lords, this is the same travel permission. Last time your lordship said.
ಈಗಲೂ travel permission ಬೇಕಾ? ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ ಈಗ?
As of now, Dubai and back, my lords. And we have, as per the last undertaking, every itinerary, we will inform the.
Affidavit.
It's there, my kindly see, my lords, along with our IA with affidavit is filed. Para
Permitted to
20
travel?
Your lordship, two submissions in this regard. One submission is that let them furnish a detailed itinerary and
Give it before we leave, just like the last date, we will give it. This is some 5th or 6th time. I don't think there's any difficulty.
Yes, last I heard the order, you have date and
15th July.
same order, Jai.
subject to furnishing the itinerary details.
ಅದರಲ್ಲೂ ಅದೇ ಹೇಳಿರೋದು.
Grateful,
Yes,
grateful.
same. Bishkar will not-
ಎಲ್ಲರಿಗೂ.
And if my lords could record that the respondent number 2 has objected,
Seriously object on para ಹಾಕಿ. The learned counsel so and so seriously objected to grant of any permission to travel of the kind that is earlier granted. Saka, madam? Yes.
grateful.
All right.
The respondents will actually worship a small accommodation. Some income.
Interim order ಇದೆಯಾ?
Interim order ಬೇಡ ಅಂತ ಹೇಳಿದೆ.
After vacation. Yes, next.
8.
ಬೇಡ. After interim order continues. Next.
80?
80. 7A.
Respondent out by judgment.
Tag. ಯಾವ ಕವರ್ಡ್ ಇಲ್ಲ ಅಲ್ಲಿ. Tag. Yes.
Interim order.
ಇದೆ. That will continues. Yes, ಇದು ಅಷ್ಟೇ 7A ನಾ?
7A.
Same.
82?
Appear for the petitioner.
Ah.
My lord, all these documents, my lord, which I relied, it was a subject matter of the earlier writ petition and writ petition was allowed. My lord, I may be permitted to produce, my lord, all those documents.
ಆಯ್ತು
and
ಮಾಡಿ.
all.
7th ತಗೊಳ್ಳ?
After vacation, my lord.
7th after vacation January. ಇನ್ನೂ ಲೇಟ್ ಬೇಕಾ?
ಅಲ್ಲ ಹಾಗಲ್ಲ 20ನೇ ತಾರೀಕಿನವರೆಗೆ ನನಗೇನು ತೊಂದರೆ ಇದೆ.
ಆಯ್ತು. ನಿಮಗೆ ತೊಂದರೆ ಉಂಟು ಅಂದ್ರೆ ನಮಗೇನಿಲ್ಲ. 27ಕ್ಕೆ ತಗೊಳ್ಳುವ.
ಆಗ್ಬೋದು ಸರ್.
List on 27th at the request of the counsel of the petitioner.
Not
My lord,
disclosing the first wife name is something.
Interim order may kindly be extended. my lord.
ಅಷ್ಟೇ ತಾನೇ offense. You are married again ಅಲ್ವಾ?
My lord, I have married, she has, my lord, everything was subject matter of the earlier writ petition.
Sir, if he gives the name of the first wife, second wife will become a problem. If he leaves the name of the second wife, it will become a problem. So yes,
Living the first wife name, he's landed here.
that is true. Second wife jothe problem ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ. That is why he has played safe.
Allah, it is all settled, my lord. It was subject matter of the earlier writ petition.
That's all right. He has played safe like every other husband. List on 27th.
Interim order may
Yes,
kindly be
sir.
extended.
Continue.
Much.
83?
Interim order ulta.
ಇಲ್ಲ sir.
ಏನು offense?
392.
Huh?
390.
Sir, yes. 1 HCGP 2 emergent notice. 392 ಬೇಡ.
Date
Yes, no. Date ಕೊಡೋಣ.
Please.
8th, yes.
Please. Lord 84, my lord.
ಅಲ್ಲ, returnable by 18th ಮಾಡಿ ಮೇಡಮ್. 8th ಬೇಡ. Yes, next.
Lord 84.
Huh.
It's a split
Huh?
charge sheet, my lord. Covered by your lordship judgment. Page
Yes,
number
tomorrow in the
61.
fresh matters list. Yes, next.
85?
84. The POCSO case.
84 ಆಯ್ತು.
Settlement.
Settled.
List.
Totally.
ಯಾವತ್ತು
As on-
ಹಾಕಿದ್ವಿ? 15th ಅಲ್ಲ?
As on the date of the
ಎಷ್ಟು ವಯಸ್ಸು?
17 years, 3 months.
ಆಯ್ತು 15th. Yes. ಎಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ ಎಲ್ಲ 15th ಹಾಕಿದ್ವಿ. Yes, next.
86?
Petitioner in this case.
Split ಆ? ನಾಳೆ.
And public.
87?
ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. Yes.
Please, my lords. My
Entry
lords,
order ಇದೆಯಾ?
ಇಲ್ಲ entry order ಇಲ್ಲ. Directed to them to produce the records. It's purely a civil dispute which has happened in Mumbai. Complaint is lodged in earlier in Mumbai.
ಮತ್ತೆ?
Why they have released the complaint in Bangalore, my lords? Everything is in Mumbai. And earlier one police complaint is filed in Mumbai. At the our instance, the certain money is due. Page 42, my lords. That's on 1/3/2024. And there afterwards, my lords, 1/3 is our complaint. Then complaint is filed in Bengaluru on 7/3/2024. Impugned annexure A.
ಆಯ್ತು. Yes, madam. Records
Not at the risk.
tomorrow. Please tomorrow. Fresh
Please.
matters. Next.
Fresh.
Fresh matters.
Please.
ನಾಳೆ ಬರೀ fresh matters. Yes.
Great.
Judgment?
ಮಧ್ಯಾಹ್ನ ತಗೋ. ಬೇರೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಎಷ್ಟು?
Follow.
ಅಲರ್ಟ್ ಬೇಡ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಫಿಕ್ಸ್ ಸಮ್ ಡೇಟ್ಸ್.
Reporting settlement, my lord.
ಯಾರಿದ್ದಾರೆ?
Parties are ready, my lord.
ವಿಚ್ ಮ್ಯಾಟರ್?
97 and
90
7 and 90.
offense?
My lord, 354.
364.
354, my lord.
Both the parties are present?
In 97, my lord, it is 447 and 31
Yes.
R and S, my
Settlement
lord.
ಎಲ್ಲಿದೆ?
My lord, I have filed in my petition, my lord. In the 97, my lord, I have
ಆಯ್ತು.
annexed the petition
ಜಯಭಾಯ್ ಅದ್ ನೋಡ್ಕೊಂಬಿಡಿ. Yes.
in both the petition.
Yes, yes.
And they are filing wakalat along with the joint memo in their
Accounts. Yes, next. ಯಾರು ಇದಾರ ಬೇರೆ settlement? And I'll come back at 2:30. Madam, meeting ಇದೆ.
Submission, my lord. Yesterday I filed the memo, my lord. Today the date fixed, my lord. Doctors, my lord. Charges Monday ಇದೆ, my lord. Kindly to post it tomorrow, my lord.
Lordship, serial number 78, kindly be hand delivered order because 25th is the travel and passport has to be released. Obliged. Grateful. Madam, 78.
ఏమైంది? ఒక నిమిషం ఇవ్వమ్మా.
And from the FIR was raised by ACB. It has now been reassigned to COD, my lords. We enclosed the notification of transfer of investigation along with the memo, and my lords were pleased to direct the petitioner to arraign the concerned as respondent. Incidentally, there is no order that is passed there, my lords.
Long back.
Please, my lords. And the memo is dated the 29th July 2024. My lords are even pleased to dictate an order directing them to arraign.
Right. What has happened now?
The order is come.
Same, ಇದೆ order ಅಲ್ವಾ?
COD transfer ಆಗಿದೆ ಅಂತ order memo ಹಾಕಿದ್ದೆ ನಾನು.
ಈಗ wing spoken to ಬೇಕಾದ್ರೆ.
Please, my lord, so that it could be at least effected as such.
Petitioner ಯಾರು?
My lords, the petitioner is.
ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ?
That is why I am doing a memo, my lords. It may be taken up tomorrow. Tomorrow being spoken to the first one. Oblige me, deeply obliged.
2:30 minutes.
Number 1.
Number.
Number 40.
Appear for the petitioner, my lord.
Yes, sir.
My lord, in pursuant to your lordship's direction on the last occasion, all the respondents have been served, my lord, and they have entered appearance is what I am given to understand.
All right. Yes, sir.
We have also filed an additional affidavit, my lord.
What is
in
that?
support of the petition.
Lords, we would seek your lordship's leave to file our objections to the petition. I'm for R11, who has been served about 2 days ago.
It's very shocking that it took 35 days to serve the opposite building. Yes. Anyway.
I'm not in the opposite building.
R11.
R11.
Family. Yes.
R10. I take note.
R10. Not served till date. Learned yaru Belli.
Not sort of belief.
Learned counsel Srimati Belli accepts notice for the 10th respondent. Registry to print the name of so and so is appearing for the 10th respondent. Thus gets complete the service of notice. Will permit you. Yes, sir.
Respondent number 12, my lord, has filed objections to the impleading application.
All right. For impleading the enforcement directorate.
Respectfully, my lord.
All right. Yes.
Nobody else has filed any objections till date.
So nobody has any objection for impleading?
We have objections, serious objections about impleading the IPD. We'll file our objections. We'll file our objections.
Fellas, I will also do likewise, fellas. I will file objections.
File your objections not only to the application but to the main petition itself.
Yes, yes.
By the next
We'll
date.
file
by the next
objections.
date, and we will close this the next date. Yes. Shall we take it on the 9th?
It's a little longer. I want to give a little later.
Not later, sir. Yes. 9th is whole lot, 3 weeks. Not after 25th at all.
Following week. Have it on the following week.
9th or the 13th. Not 13th, 15th. 14th is a holiday, 15th max. Yes.
Very well.
15th.
Yes. 15th. Yes, 15th.
15th, my lord. 15th, I am not in town, my lord. So can it be
online,
can it be on
sir.
13th?
No.
My lord, I am committed, my lord, in
13th
some
is
other
a
matter.
sandwiched Monday between 2 holidays. So we'll have it on the 15th.
Please.
Very well.
Yes. Heard
Very
the,
well, fellas. Very well.
Heard the learned so and so ellardu haki hakbittu. The respondents are all now served and are represented. Objections shall be filed to the main petition or to the applications, if any, will be filed by the next date. It is made clear no further adjournment would be granted on the score of filing of statement of objections to the main petition or to the applications as the case would be. Let's the matter on 15th. 15th, we'll take it at 10:30 itself so that it gets over. list the matter on 15th at 10:30 AM. The understanding is that the matter would be heard finally.
My lord, I have
Yes.
some difficulty on 15th. Can it be some other date, my lord? I'm in the Supreme Court on
We'll-
15th.
We'll see, sir, on that day. You can appear online, that's all right.
No, my lord, I'm held up in the Supreme Court, my lord, with one matter. So 10:30.
We'll see, sir.
My
We'll
lord, I'm sorry, my lord.
consider on that. We'll consider on that date.
Please.
Let me only say in the order that the matter will be heard on 15th, instead of saying it's the understanding that we are.
All right, not the understanding.
Otherwise they will say that
Not
we
the
are-
understanding. Yes, you're right, sir. Not the understanding. It is made clear that the matter would be heard on the said date.
That's fine.
Yes. Let it not be a mutual understanding. Yes. So the records are there here.
Records
And
are there.
what is the last date given to submit the report there?
24th.
Yes. Since the matter is being heard before this court as to whether the issue should be referred to investigation / reinvestigation / further investigation to the hands of the Central Bureau of Investigation. The order passed by the concerned court, which had directed the investigation to be taken up by the Lokayukta, has a direction in it to file their final report before the concerned court on or before
24th.
the 24th of December 2024. Therefore, further investigation by the Lokayukta till the matter is heard shall remain stayed.
That I may kindly be heard. So far as
No, I see.
interjecting.
When this
I
court
very
is hearing the
respectfully
matter, this
No,
proceeding should not get frustrated.
With due respect, there is no challenge to the
So it's
order.
all right. This is the order
There
of the
is no
court.
challenge to the order under 156(3).
No, that's all, sir.
No, I
Really?
request the court to kindly hear me. on
Yes,
this.
sir. Really, sir.
Kindly.
Yes, sir.
Now kindly permit me to show.
Yes.
That a notice was issued to the 10th respondent.
Who's R10?
Attend, not the wife of accused number.
All right.
Yes, a notice was issued
Hmm.
only on 5/11. Now, after issuing notice, this honorable court has stated that the Lokayukta records be placed before this court.
That is one.
ಇಲ್ಲ 5/11 after issuing notice ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಿ.
Aden records ಕೊಟ್ಟಿರೋದು day before.
No, I request the court to kindly take.
I know that.
The matter
Yes.
comes up.
I have 5/11/2024.
Yes, 5/11/20.
Yes, sir.
There afterwards, the matter comes up on 26/11.
Yes.
On that day, 26/11, the court records a finding. The understanding is that the matter would be heard on the said day. Sir, I am not even served. This
That's all
court
right.
is already passing an order
I
to
did
hear
not
the
hear
matter.
it anyway.
No, with great respect. I don't understand this kind of a haste in
There
proceeding.
is no
with the
haste, sir.
Sir,
I am even
no
now
record.
adjourning the matter. There
26,
is no
20
haste at all.
26/11, kindly take the order.
I know, I have passed that order.
Yes.
Yes.
The understanding is that the matter would be heard on the said date. Lokayukta is again directed to place the record of investigation till date. Now, how can after a notice is issued, before the notice is served, behind my back, all these orders are
No
being passed?
behind back, sir.
Yes, sir. It is behind my back.
I will pass this order now. I will consider your submission and pass the
Yes,
order.
yes, kindly
Yes.
do so.
Yes, sir.
Thereafterwards, the matter comes up for hearing before this honorable court on 10/12.
Yes, sir.
On 10/12, kindly take the order sheet for a minute. The learned senior counsel so and so would make his preliminary submissions. Learned senior counsel would submit that the matter cannot be taken up for the reason that the prayer is sought for reference of investigation at the hands of the Central Bureau, and respondents 9 to 11 against whom the said direction is sought are yet to be served, and therefore service of notice should be effected at the outset. of any submission to be even considered, albeit preliminary. Therefore, this is when the learned senior counsel appearing for the state has raised an objection to hearing the matter. Now kindly thereafter you kindly notice. Therefore, I deem it proper to direct the petitioner to serve respondents 9 to 11 by way of hand summons. At this juncture, Sri so-and-so would submit against the order dated 5/11/2024, a writ appeal is presented, and he would request that the counsel representing the respondents therein can be served upon. Advocate General on record for the petitioner is submit. Advocate on record for the is permitted to serve on the learned counsel, Sri so-and-so, who is said to have accepted notice for respondents 9 to 11. Sir, I am not even a party to the writ appeal. How
It's
can
alright.
such orders be made?
That is what was said. If any.
Sir,
to
this
be
court is
served.
being misled and such orders are being obtained.
Not
I am not
obtained,
a
sir.
party to the writ appeal.
That is why if they are not a party, serve by hand summons. Now you are served.
Yes, I am served. That is why I am making this submission.
Yes, sir.
And thereafterwards, now I am not even served on that day. Kindly see the end of the day. What is the order made by this court? List this matter for further hearing. Sir, how will it become further hearing?
All right, we will release it from parted. Don't worry.
No. I just want to know what is happening in this court.
Nothing is happening, sir.
Yes, sir,
Hearing is
everything
going
is
on.
happening.
Sir,
I take strong exception.
arguments in terrorism will not help.
It's not
if
terrorism, sir.
you have any objection for further hearing, we'll release it from parted. Absolutely. Let it be listed before the bench.
I would like to know how such an order
No
came to be
problem.
made even before I am served.
No problem.
Sir, under what
No
provision?
problem, sir. I will release it from parted. If you want it to be released, I will release it. No qualm about it at all. If there is an objection that I have posted it for further hearing without hearing you,
Of
definitely
course,
will
yes.
release
I
it.
have very serious objection.
I will
in
release
getting the
it,
matter
sir.
listed.
No problem.
Very
What serious objection
Very-
can be there for that? But yes, the order that I have passed, the proceedings pending before this court cannot be frustrated by an order of the district court.
Sir, with great respect,
the
there
reason.
is no prayer, there is no application.
This is
No.
what I am trying to protect, what is being considered by this court.
No, even after supposing the investigation is completed, the hands of this court are not stayed.
No, that is
It
true.
can always. Why
why-
is it being interjected?
What is, no, not.
The
see,
investigation by the Lokayukta is being interjected at
No
every stage.
no
Sir,
interjection,
this is the
sir.
third intervention that is happening at
No,
the hands
that's
of
all
this court.
right, but
I
the
take exception.
the
to
matter
this.
is, maybe, sir, the matter is being heard here.
Sir,
By
please-
the High Court, the matter is heard. The concerned court cannot proceed further if the final report is filed there.
Why not?
No,
This honorable court can always hand it over to CPI if the court finds
No,
any.
it should, see, these
there-
proceedings, I for one will never permit a district court to frustrate the proceedings before the High
Sir,
Court.
that is not
I
under
guess
challenge.
you
With
also
great
should not
respect-
say that.
With
Yes.
great respect, that is not under challenge. We are not put on notice as to what is the relief. This court is so moto passing the orders.
Right, yes. They only to protect the
I have
proceedings
strong
before this
objection.
court.
I have objection for this kind of an interjection with any proceeding which is an investigation which is taking place pursuant to an order of this honorable court, then the trial court. Please don't stay the investigation. Let it go on as it has happened, and let the law take its course, and this honorable court will take a decision thereafterwards.
Yes, sir. Raghavan, sir.
My lord, I think that contention that is being urged by my learned friend is not tenable, my lord, for this reason. The protection is now being given by this honorable court because of the plea that has been made seeking for adjournment. This is a protection that the court is giving. I believe, my lord, that the court has a right and in fact duty bound to give every protection in order that the delay in the proceedings of the court does not in any manner injure the rights or frustrate the proceedings before the court. So, my lord, it does not require an application. It doesn't require any such thing. It is a condition that your lordships are imposing for adjourning the matter. And this is a submission I made last time also, my lord, before your lordships. And I reiterate the submission, my lord, respectfully before your lordships today. So the contention that's being urged by the other side, that an application is required, suo motu orders are being passed, my lord, I would respect to submit, is totally unwarranted and uncalled for.
All right. Shall I pass the order?
Please proceed.
The petition is preferred with the following prayer. This court, from time to time, has, right from the beginning, has passed for certain orders. On 5/11/2024, the following order. Again, on 26/11/2024, the following order. Again, on 10/12/2024, the following order. In the order dated 10/12/2024, the respondents 9 to 11 were not served despite the process being paid for 35 days. Therefore, this court was constrained to observe that either if they are parties before the division bench, they be served through the counsels who are representing them before the division bench, or by way of hand summons as the case would be. The matter was directed to be listed today. The matter is, the service of notice is complete. When the matter was to be taken up, the learned counsel appearing for the respondents, all the respondents, would in unison submit that they need time to file statement of objections to the main petition or the applications as the case would be. Simultaneously, it cannot be ignored by this court that pursuant to a direction of this court, that the court of the Lokayukta court, by its order dated, what date is that? 25/9/2024, directed investigation to the hands of the Lokayukta, and also directed that the report be filed before the concerned court of completion of investigation within 3 months, which would come to an end on 24/12/2024. The present petition, though was preferred the very next day, is moved for its hearing and comes up for the first time on 5/11/2024, and the aforequoted orders are passed. In the interregnum, the respondents herein have preferred 2 writ appeals. One writ appeal, in writ appeal number so and so far, main writ appeal yavadu?
3 writ appeals.
3 writ appeals. Give the numbers. Two writ appeals against the main order. 2 writ appeals against the order dated 24/9/2024, and 1 writ appeal against the order dated 5/11/2024. Those writ appeals are pending consideration, and the request made by the respondents herein before the division bench to stay the hands of this court in the subject petition is not entertained, is an admitted fact, or this is submission made by the parties to the list. Therefore, this court directed the matter to be listed on today, date 19/12/2024. In the interregnum, as observed herein above, the court of session, which had directed the report of the investigation by the Lokayukta, i.e. the final report to be placed before the concerned court, will have to be complied with within 24/12/2024. Therefore, there is a quagmire with all the proceedings pending. The investigation, if would get complete and place it before the court, it is not that the hands of this court would get tied to even then refer the matter further, but the proceedings pending before this court in the considered view of the court would get frustrated. This court would not permit a district court to secure the report, pass orders upon the report when the matter is being heard before this court, to frustrate those proceedings before this court. Therefore, to protect the proceedings pending before this court, I I deem it appropriate to defer, I deem it appropriate to direct, sorry, I deem it appropriate to extend the time that is granted by the concerned court for filing of the report, which is said to be on 24/12/2024 to 28/1/2025. Yes. List this matter on, the councils list this matter on 15/1/2025 at 10:30 a.m. Yes.
Submissions. Petition or additional affidavit file.
Registry file ಮಾಡಿ sir ಏನಿದ್ರು. Yes. Serve a copy on the other
My lord,
side,
instead of-
file it in the registry.
My lord, instead of 15, can I
served on
make,
me, my lord.
Yes, madam.
repeat
One
my
minute.
request to have it on 10th?
1
my
minute,
lord?
sir.
Applications are not served on me, my lord.
Why I have not served the applications? The counsel for the petitioner shall serve all the applications that are filed before this court or to be filed by the next date of hearing to the counsel for the respondents today or in advance. Yes. Next.
My lord, can I reiterate my request to have it on 10th instead of 15th, my lord?
No, sir. Yes. Next. Sorry, on 15th we will see. Yes.
Very well.
Correct.
Number 2, reporting settlement, 89.
ಮೇಡಮ್ ಬೆಳ್ಳಿ ಮೇಡಮ್ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆಯಲ್ಲ, ನಿನ್ನೆ ಹಿಯರಿಂಗ್ ಆಗಿರೋದು. ಸರ್ ರೆಡಿ ಇದ್ರೆ ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್. ಸಿ ವಿ ನಾಗೇಶ್ ಸರ್ಗೂ ಹೇಳಬೇಕು.
ಎಲ್ರು 4 ಗಂಟೆ ಮೇಲೆ ಇರ್ಬೇಕಂತ.
ಅಲ್ಲ ಹೇಳಿ, ಬಂದರೆ ಮುಗಿಸ್ಕೊಂಡು.
Reporting settlement, still number 90, 91.
My lord, appearing on behalf of the petitioner, my lord. My lord, yesterday we had moved a memo before your lordship, my lord. There is some exchange of articles that has still not been completed between the parties, my lord. Hence, we are seeking
After
one short
vacation
adjournment. Agbod Swami.
After vacation. Yes.
Thank you, my lord.
91. 92.
92, my lord.
Petitioner, my lord.
Connected. my lord.
Offense.
Lords, now, my lords, what happened? We even brought DD, my lords, to settle the disputed amount. Now, my lords, it's only a time period. They are seeking 5 months, but they are
ಸರ್ ಇಟ್ ಈಸ್ ಸೆಟಲ್ಮೆಂಟ್. ನೀವೇನು ಹೇಳ್ತೀರಾ ಅದು ಸೆಟಲ್ ಮಾಡಿ.
5 ತಿಂಗಳು ಕೇಳಿದ್ವಿ, ಅವ್ರು 1 ತಿಂಗಳು ಅಂತ ಇದ್ದಾರೆ.
ಅದಕ್ಕೆ ಕೇಳಿ ಅವ್ರಿಗೆ. 1 ತಿಂಗಳಲ್ಲಿ ಬೇಕಾ?
ಅಲ್ಲ ಏನಾಗಿದೆ not in fact not my part is not ready for them. As far as the payment is concerned, not she is agreeable. As for the duration is concerned, they say not 5 months. My party would say that not 2 months. Within 2 months, not she wants the money back. So that is only my lord. If they are ready for 2 months, not we are agreeable. Since my lord,
timing
undertaking was given.
We'll once again will
No, undertaking was given to make the payment on 28/10. We are in December. Already 2 months is over. So therefore, my lord,
50 lakhs DD ಇದೆ ಈಗಲೇ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ.
ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಟೋಟಲ್?
Not 1
2
crore.
crores.
Not 1 crore 25 was the amount through bank, but now we negotiated for 2 crores.
Lord, in fact, my lord, they undertake before this court that not they'll pay the entire amount. That is the undertaken given to before this court. Only
It's
duration,
only,
not if
it's
they
only a
agree.
duration, my lords. We'll just once again we will have sit and we will discuss. We will try to convince them, my lords.
ಯಾವತ್ತು ಹೇಳಿ?
Immediately after vacation, my lords.
6 January.
Tomorrow, my lord,
Tomorrow.
ನಾಳೆ ಬೆಂಚ್ ಇದೆ. I don't know. Yes.
6/1, my lords. Immediately after vacation.
6/1.
6/1.
List on 6/1 at 2:30 PM to report settlement.
Intermodal maybe.
Intermodal. Yes.
But it could
next.
be taken as further hearing notes.
It cannot.
Settlement ಅಲ್ಲಿ ಯಾವ further hearing sir?
ಮಾತಾಡಿದೀವಿ ಬರೀ.
ಅದು ಯಾರ್ ಮುಂದ್ ಬಂದ್ರು ಸೆಟಲ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ. Yes.
93.
Complainant and ಇದ.
End of the list and then police custody was.
ಇದದು. Oh, ಸರಿ. Yes.
My lord, the petitioner complaint has some inconvenience, my lord.
After vacation.
My lord, the stay may be granted to this petitioner, my lord. In terms of
Settlement
the-
ತಾನೆ?
Yes, my lord.
Offense ಏನು?
498 A, my lord.
Husband
Husband.
after vacation.
My lord, 15 day may be dated.
After vacation. ಯಾವತ್ ಬೇಕು? 15ಕ್ಕೆ ಬೇಕಾ?
15.
List on 15th to report settlement.
Yes.
Yes. Comma if any.
Interim order in the connected matter may be extended.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಹಸ್ಬೆಂಡ್ಗೆಲ್ಲ ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ.
94. It has been settled. And also along with this, there is one more matter which has been moved at 2:30 for end of the list. Kindly, the matter may be taken up together, my lordship. 94
ಆಯ್ತು sir.
for in-laws, because the present petition is for husband.
ಆಯ್ತು. ಪಾಸ್ ಓವರ್.
Much of- 95.
Lots 95, 96 may it be taken up on 20th of January because the.
20th to report settlement. Yes.
First
Next.
20th, okay. Both 95 and 96. ma'am.
ಆಯ್ತು ಸರ್.
99.
For respond number 2, my lord. Filing vocal
457, 380, your lordship that. 380 theft is the 24 bag of onion, your lordship that.
ಆನ್ಲೈನ್ ಬ್ಯಾಗ.
Onion bag.
ಆನಿಯನ್ ಥೆಫ್ಟ್.
ಅದು ಫೈನಾನ್ಷಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ.
ಆನಿಯನ್ ಬಿಟ್ಟಿಲ್ವಾ?
ಹಾಗೆಲ್ಲ ಅದು 70,000 ರೂಪಾಯಿ ಸಾಲ ತಗೊಂಡಿದ್ರಿ ಆರೋಪಿ.
ಯಾಕೆ?
ಕಂಪ್ಲೇಂಟ್.
ಆನಿಯನ್ ರೇಟ್ ಜಾಸ್ತಿ ಆಗಿತ್ತು.
ಹಾಗೆಲ್ಲ 40,000 ರೂಪಾಯಿ ವಾಪಸ್ ಕೊಡ್ರಿ, 30,000 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ there is a dispute. That's why the theft was fixed, your lord.
Please, ma'am. Respond number 2.
Now the matter was settled, your.
ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The petitioner is before this court calling in question so and so. Stealing of onion has led the petitioner into tears. Therefore, the petitioner is before this court calling in question the crime registered and also the charge sheet filed for stealing 65 kgs of onion and which costs about 80,000 rupees. ವಾಪಸ್ ಕೊಟ್ರ ಈಗ? ಆನಿಯನ್ ಕೊಟ್ರ ದುಡ್ಡು ಕೊಟ್ರ?
ಆನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವರು ದುಡ್ಡು ಕೊಡ್ಬೇಕು. ಕಂಪ್ಲೇಂಟ್ ಇವರಿಗೆ ಕೊಟ್ಟಬೇಕು, ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು.
ಯಾವಾಗ ಆನಿಯನ್ 1/11/2023 ಆಗಿರೋದು?
ಸೀಸ್ ಆಗ್ಬಿಟ್ಟು ಅದು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನಾಗಿ?
ಸೀಸ್ ಆಗ್ಬಿಟ್ಟು ಪೊಲೀಸರು ಬಂದು ಸೀಸ್ ಆಗ್ಬಿಟ್ಟು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು ದುಡ್ಡಿನ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಬೇಕು, ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು.
ಆನಿಯನ್ ಎಲ್ಲಿರುತ್ತೆ? 1 ವರ್ಷ
ಇಲ್ಲ, 1 ವರ್ಷ ಅಲ್ಲ, ಸೇಮ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಸೀಸ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಸರಿ, ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ, ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಲ್ಲ. Therefore, the parties have come before the court for onion settlement. ಅದೆಲ್ಲ ಬರ್ಕೊಂಡ್ಬಿಡು. So and so. Yes, next.
Please, ma'am.
ಮತ್ತೆ ಯಾವಾಗ ಬೆಳೀತಾ ಇದ್ದೀರಾ ಆನಿಯನ್? ಅವ್ರಿಗೆ ತಿಳಿಸ್ಬಿಡಿ. Yes.
100. For respondent number 2 in this matter.
Waiting for petitioner, my lord. To set the verge of settlement, my lord.
ಯಾವಾಗ ವರ್ಜ್ ಬರೋದು?
ನಿನ್ನೆಯಿಂದನೂ ಅದೇ ಹೇಳ್ತಾ
ಅದೇ ವರ್ಜ್ ಆಫ್ ಸೆಟಲ್. ನೆನ್ನೆ ನೀವೇನ ವಿಸಿಲ್ ಬಂದಿದ್ದು? ಅದಕ್ಕೆ ಅಷ್ಟು ಗಲಾಟೆ ಮಾಡ್ತೀರಾ?
Settlement ಆಗ್ತಾ ಇದೆ ಸರ್. ಸಿವಿಲ್ ಕೋರ್ಟ್
ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Civil suit already disposed.
ಸರಿ, ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ ಸಾಕು, ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ. ಎಕೋ ಆಗ್ತಾ ಇದೆ. ಏನು? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕರ್ಕೊಂಡ್ ಬಂದಿರಾ?
We are seeking for a stay, at least stay, my lord.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ, ಸೆಕೆಂಡ್ ಪೆಟಿಷನರ್.
Second petitioner, first and third petitioner is stay.
ಕೊಡಲ್ಲ, ಸ್ಟೂಡೆಂಟ್ ಅಂತ ಕೊಟ್ಟಿರೋದಷ್ಟೇ. ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಆಗ್ತಾ ಇದೆ. Almost two, it will be done by vacation minutes during there.
Use the vacation for.
But your lordships can record, we are in the process of settlement. I'm sure the other side also will not object. It is being done.
So ನೆನ್ನೆ ಅಷ್ಟು ಗಲಾಟೆ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಪ್ರೊಸೆಸ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ.
Process ಅಲ್ಲಿ ಇದೆ.
ಸ್ವಲ್ಪ.
Accused number 11 and 13 ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, 1 to 10 ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ಅವ್ರು ಇನ್ನೂ ನಮ್ಮ ಹತ್ರ ಏನು ಅಪ್ರೋಚ್ ಕೂಡ ಮಾಡಿಲ್ಲ.
But what I have suggested is vendors, your vendor ನಮಗ್ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ. I said, ಆಯ್ತು ಇವ್ರ ವೆಂಡರ್ ಇವ್ರಿಗೆ ಮೋಸ ಮಾಡಿದ್ರೆ
ಆಯ್ತು
ಇವ್ರು ಬಂದಿರೋದು ಇವ್ರಿಗೆ
ಮೆರಿಟ್ಸ್
ಕೊಟ್ಬಿಡಿ
ಮೇಲೆ
ಅಷ್ಟೇ
ಕೇಳೋಣ
ವಾಪಸ್.
ಬಿಡಿ. We'll hear it on merits.
Otherwise, I am sure it will be
9th
after
ಹಾಕಿ
vacation, it will be done.
9th ಹಾಕಿ. We'll hear it on merits.
Not sir, 9th ಬದಲು 2 days after that.
9th 2 days after that ಅಂದ್ರೆ 13th or 13th is a Monday, ಅದು sandwich day, so ಬೇಡ. 16th ತಗೋಣ.
ಆಯ್ತು.
Yes. 16th January is a Thursday.
ನಮ್ಮ millards only 9th I have an issue.
That's all right. 16th January is a Thursday. Correct, Thursday ತಾನೆ ಮೇಡಮ್? We'll merits ಮೇಲೆ we'll post it for further hearing. Yes.
Further.
Not on settlement.
ಇಲ್ಲ.
Merits ಮೇಲೆ. Yes.
So, remaining petitioners, we are appearing, my lords. Whether your lordships consider stay of those also, because they are also in talks.
ಆಯ್ತು ಸರಿ.
In the process, still limited.
The respondent state shall not precipitate the matter till the next date.
Please, please. Further hearing, your lordships are. ನಿಮ್ ಕೋರ್ಟ್ ದೊಡ್ಡದು ಜಾಗ, ಈ ಚಿಕ್ಕದಾಯ್ತು ಹಾಲ್ ಎಂಟ್ರಿ.
ಇಲ್ಲ ಇವತ್ತೇನು ತೊಂದರೆ ಇಲ್ಲ.
101.
Here for petition. The matter has been settled before the trial court.
Powers, power.
498 506.
ಪವರ್ ಕೊಡಿ ಮೇಡಮ್. ಎಸ್. ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ. Hmm, 498.
498.
ಎರಡು ಪಿಟಿಷನ್ ಇದೆಯಲ್ಲ, ಒಂದೇ ಅಲ್ಲ?
ಒಂದೇ.
All the parties are present?
Present.
All right. Learned counsel so and so enters appearance. Next. ಎಷ್ಟಿದೆ? ಯಾಕೆ? ಒಂದೇ ನಿಮಿಷ, ಪಾಸ್ ಓವರ್ ಇದೆ, ತಗೊಂಡ್ಬಿಡ್ತೀನಿ. ತಗೊಂತೀನಿ ಇರಿ, ತಗೊಂತೀನಿ. ಇಲ್ಲಲ್ಲ, ಬೇರೆ ಒಂದು 6 ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದು ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಂಡು.
Passed or matter. List number 2, serial number 4.
Petition. Section 39 and 29, 30 of the birth act not complained. I argued that my lord, now they are placing records. Lordship, I will answer and submit lordship, taken and parted.
Serious allegations are made.
Lordship, I will convince you, lordship. ಅದರಲ್ಲಿ ಇದುವರೆಗೂ ನನಗೆ ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ.
You are not able to convince on your marriage. What will you convince?
Please, my lord, I will convince you, lordship. Matter may be taken.
Contention is there is no communication.
ಅಲ್ಲ, ಕಾಪಿ ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ, ನಾನು ನೋಡ್ಬೇಕಲ್ಲ.
Anchor.
And ED is investigating. Now, virtue of this same allowed, everything has been put to.
9. List on 9th.
Taken a part.
ಆಯ್ತು ಸರ್, 9.
ಅದ್ರಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ನನಗೆ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಕಲೆಕ್ಟ್ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು.
ಒಬ್ಲೇಜ್
Notification ಆಗಿದೆ land acquisition.
ಆಯ್ತು.
ಅಲ್ಲ, ನಾನು ನೋಡ್ತೀನಿ.
30.
For respond number 3, my lord.
Where is the shrimp?
Passover, my lord. Just
No
20 minutes.
passover, sir. We will vacate the interim order now.
No, my lord. Just 20 minutes, my lord.
20 minutes, ಅದೇನು ರಾಹುಕಾಲನ ಈಗ?
ಇಲ್ಲ, my lord.
ಮತ್ತೆ?
On the way, my lord.
On the way? KSLT ಇಂದ on the way.
No, my lord. 20 minutes.
ಇವತ್ತು ಎಷ್ಟೊತ್ತರ ಅಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು ಆರ್ಗ್ಯುಮೆಂಟ್? ಶ್ರಿಂಪ್ ಇಲ್ಲ ಈ ಕಡೆ ಇರಬೇಕು, ಇಲ್ಲ ಈ ಕಡೆ ಇರಬೇಕು. ಎಸ್, ಮುಗೀತಾ? ಪಾಸ್ವರ್ಡ್
34. Really pass over, man. Senior's on his legs before division.
ಎಲ್ಲರೂ ಆನ್ ದಿ ವೇ. ವೈ?
He's on his legs before division.
ಲೆಗ್ಸ್ ಪಾಸ್ವರ್ಡ್ ಏನಿದು? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗುತ್ತಾ? ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Then after vacation, AVIO, next. ಅವ್ರಿಗೆ ಹೇಳು ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನೋ ಡೇಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
53.
In this case, my lord, the petition is going to abroad, my lord, hence I am filing a fit affidavit along with the.
Going abroad, which Thailand?
USA, my lord.
US.
Yes, my lord. And your lordship quashed the proceedings against section number 2 in this case, my lord. I placed
ಈಗ
the
ನೀವು
order.
ಅಬ್ರಾಡ್ಗೆ ಹೋಗ್ಬೇಕಾ ಕ್ವಾಶಿಂಗ್ ಬೇಕಾ?
Washing him.
Already
8.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು ಸರ್?
Complaint is.
Who is the complainant? It's a private party.
Yes, my lord.
No, you want to go abroad, you can go. No quashing.
Permit.
Yes, government.
Permit to travel, my lord.
ಯಾರು ಅಡ್ಡ ಬಂದಿದ್ದಾರೆ ಈಗ?
Lord?
ಕ್ರೈಮ್ ಅಡ್ಡ ಬರ್ತಾ ಇದೆಯಾ?
Copy not served.
ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್. You should serve also on ಶಾಂತಿ ಭೂಷಣ್. ಅವರಿದ್ರೇನೆ ಸಾಧ್ಯ. ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. List tomorrow in the fresh matters list.
Tomorrow is the hearing date.
Postpone ಮಾಡಿ. Ticket postpone ಮಾಡಿ. Criminal case pending ಇದ್ದಾಗ you should always buy an open ticket. Refundable. Yes.
Not already. I served the
Password. Get ಶಾಂತಿ ಭೂಷಣ್ also. DSJ ಶಾಂತಿ ಭೂಷಣ್ ಗೊತ್ತಿಲ್ವಾ? ಶಾಂತಿ ಭೂಷಣ್ ಗೊತ್ತಿಲ್ವಾ? ಕರ್ಕೊಂಬನ್ನಿ. Yes. After vacation. Urgency ಇದೆಯಾ? ಅದು ಯಾವುದು ಕರಿಬೇಡಿ ಮೇಡಮ್ ಈಗ. ಒಂದು 4 ಗಂಟೆ ಮೇಲೆ ಬರಕ್ಕೆ ಚೇಂಬರ್ಗೆ ಹೋಗು. ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಲ್ಲ? ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಒಂದ್ಸರಿ ಕರೆದ್ಬಿಡಿ.
Further hearing. 102.
completed.
ಎಸ್ ಅವ್ರದ್ದಾಗಿದೆ, ನೀವೇ ಹೇಳ್ಬೇಕು. ಅವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ನಂದಾಗಿದೆ, ಅವ್ರದ್ದಾಗಬೇಕು.
ಇಲ್ಲ ಅವ್ರದ್ದಾಗಿದೆ, ನೀವು ಹೇಳಿ. ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ, ಅಷ್ಟದ ಟೈಮ್ ಆಯ್ತು, ಹೇಳಿ.
ಮೈ ಲಾರ್ಡ್, in this case.
ಮೈಕ್ ಹತ್ರ ತಗೊಂಡ್ಬಿಡಿ. ಆನ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
My lord, this case, there is a forgery, there is a cheating, there is a inducement. And misappropriation of profit and falsification of accounts and showing genuine documents as a
Forged
documents as a genuine document.
471.
IPC 471, my lord. 403 is there, 406 is there, 409 is there, 410, 420, 468 and 120B. It's all there, my lord. First, the agreement, page number 2, you can take out my lord. In my objection statement, additional documents I have submitted. Page number 2, bottom, there is a serial number 4 scheme. Shall I read it? The lender shall enter into an agreement with the approved intermediary for depositing. How do we see it?
Objections are memo for documents.
My lord,
Objections are memo for documents. ಏನು ಓದ್ತಾ ಇದ್ದೀರಾ?
ಇದು ಸ್ಕೀಮ್ ಓದ್ತಾ ಇದ್ದೀನಿ.
ಸ್ಕೀಮ್ ಕರೆಕ್ಟ್, ಹೇಳಿ.
The lender shall enter into an agreement with the approved intermediary. Here, the lender is Anand Rathi Global Finance and intermediary is Anand Rathi Shares and Stock Brokers. I am the trader and borrower. So, depositing of securities for the purpose of lending through approved intermediary as per the scheme. And the borrower shall enter into an agreement with the approved intermediary. Borrower has to enter an agreement with the intermediary for the purpose of borrowing of funds, and as such, there shall be no direct agreement between the lender and the borrower of borrowing securities. So financer has nothing to do with me, my lord. Here directly of the financier, they have made an agreement. The cheating started, the motive of cheating, conspiracy, all started in the beginning itself. That is the loan agreement. And loan agreement and POA they have taken. And they, clause number 4.7, my lord, 125 of the petitioner's copy, 125 page, my lord. There they said, clause number 3.70 says, the account has to be opened in the name of borrower, trader, or jointly with the company. And do all shares related transactions, my purchases, my sales, my payment, their payment, interest, dividend, both, all transactions should take place. But here what they have done, my lord, they have opened an account. Initially they had taken signatures and they have opened an account. 13 crore transactions they have done. Morning they are depositing 158 transaction, my lord. Morning they are depositing, evening they are taking out. End of the day, zero balance. And it is to my surprise, all transactions they internally they have got transferred. From one Anandrati account is money coming and another Anandrati it is going. 4 accounts they have only distributed. Not even a rupee has come to my account, my lord. So tomorrow income tax department, if they ask, I am unanswerable, my lord. This is the second crime. The third is, my lord, the scheme they explained was 50 rupees they will give loan and 50 rupees I have to contribute. 100 rupees if I buy a share today. Market is always volatile. Morning one stage will be there and evening another stage. If the share value comes to 90 rupees next day, so if I want to trade 10 rupees, I have to contribute trade. And if I don't want to trade, I can keep quiet. But if the value comes down to 75 rupees and below, without notice, they can sell it, fine. But if market goes up 120 or 130 rupees, that 30 rupees is your profit, either you can encash or reinvest by purchasing shares. Here what they have done, my lord, wherever I have purchased 120 rupees, 30 rupees, this thing, they have treated me as a loan with fictitious document, forged documents. All the forged documents I wrote to their chartered accountant company, whether you have audited these all the documents while finalizing the audit. They have disowned it. And they asked me to the SDFC statement, they said you contact a broker. So these are the 3 serious allegations are there, my lord. And CID had appointed a chartered accountant to verify the accounts. How he verified thoroughly. After 3 months, he submitted a report. It is full of allegations against the company. He clearly has made agreement that not done properly. BSc violation is there. Then segregation of own funds and client funds not done properly. And both the entities are separate. Anandrati Securities and Anandrati Global Finance, both are separate. But here they have acted as if they are one entity. Many more are there, my lord. It is the entire report is listening. By that, bypassing this report, the IO has filed B report. Then again, I don't know what is the reason known to him. After 15 days, he took it back under section 173(8), stating that I will reinvestigate the matter. Even after 1 year, he did not do anything, my lord. Then I went to the Honorable High Court, requesting for filing charge sheet earlier. Before the Honorable High Court, he accepted. IO accepted within 3 months, I will file a charge sheet. But he, after 6 months, he filed a memo stating that old charge sheet filed, old B report filed may be accepted. Is it not contempt of court, my lord? I have not filed, because before the honorable judge, he has accepted, he will file charge sheet. But finally, he submitted a.
Sir, nobody accepts saying that they will file charge sheet. It is accepted that they will file final report.
But it is there, sir. My lord.
If this court has directed that to file charge sheet, that is erroneous. No court can direct filing of the charge sheet. Final report they will file, whether it is a B report or a charge sheet, it is up to the investigating officer.
Okay.
Yes.
So then I went to, there is no alternative, my lord. I went to the honorable trial court judge.
Protest petition ಹಾಕಿದ್ರಿ, protest petition ಆದ್ಮೇಲೆ cognizance ತಗೊಂಡಿದ್ದಾರೆ. ತಗೊಂಡ್ಮೇಲೆ ಅವ್ರಿಗೆ ಬಂದಿದೆ.
Both the B reports he has rejected. Took the
Rejected and cognizance is taken.
Then he called me for sworn statement.
All-
In 3 sitting, I completed my sworn statement, marking up papers.
So
also
your
done.
submission is that with unauthorizedly amounts have been moved in your account,
Their account, my
Ah,
lord.
in
Their
your
account.
account, and therefore they have committed fraud,
Yes, my lord.
cheating and fraud,
Yes, my lord.
criminal breach of
My
trust.
investment is gone, my profit is gone, and non-existent loan, they have collected 1 crore 37 lakh interest, my lord.
You have filed your objections or only documents?
I have filed all the documents, my
ಅಲ್ಲ
lord.
objections ಏನ್ ಹಾಕಿಲ್ಲಲ್ಲ?
Objection ಅಂದ್ರೆ objection first ಹಾಕಿತ್ತು, my lord.
ಹಾಕಿದ್ದೀರಾ?
First objections ಹಾಕಿದೆ. ನಾನು ಈಗ additional document ಹಾಕಿದ್ದೆ.
objections-
PIP ಆದ್ಮೇಲೆ additional document
Madam.
ಹಾಕಿದೆ.
Objections ಏನು? ನೋಡಿ. Objections copy ಕೊಟ್ಟಿದ್ದಾರಾ ನಿಮ್ಗೆ? Objections copy.
I think they filed an IA for vacating. I'm not sure if they filed a objection.
Vacating style ಎಲ್ಲ ಹಾಕಿದ್ದಾರಾ?
Vacating stay hakidare.
Yes, sir. Anything in reply?
I have.
Yes.
Well, could I just pass the synopsis? I've made it easier. My lords, both the synopsis and the legal contentions are there. Kindly notice the synopsis, my lords, the dates. 28/12/2010, loan against share agreement between respondent number 2 and Anand Rati Global Finance Limited. My lords, that is there at page 125, because one of the contention is company is not made a party in this whole proceeding. The agreement is between him and the company. 125 is that page. Then, my lords, power of attorney 28/12/2010, power of attorney executed by respondent number 2 in favor of Anand Rati
So-
Global Finance Limited,
Yes.
which was opened in accordance with the loan account. Then, my lords, since he was unable to clear the outstanding loan, he is informed that the stocks which is held as security will be liquidated. Now, we send it via emails, my lords. The emails, one is at page 154, other is at page 165. He is informed that we would go against the stocks. Thereafter, my lords, the accumulated loan liability, 1,04,05,222. Now, this is what, my lords, is the liability which is adjusted. Post that, my lords, he would file a suit for injunction. Now, the injunction suit which he files, subsequently, my lords, when that is pending, he would approach SEBI, my lords. Now, SEBI would dismiss his complaint. After the SEBI dismisses his complaint, he gives a present complaint on the basis of which FIR gets registered for offenses under 420 and breach of trust. Meanwhile, the OS suit filed by him is dismissed on the ground that there's an arbitration clause. So the agreement contained an arbitration clause. So, my lords, OS suit gets dismissed. Investigation takes place. B report is filed. After the B report is filed, my lords, a further investigation takes place. Further investigation, again a B report is filed. Now, when this B report is filed, my lords, he would file a protest memo. My lords, on either end, we would require a complaint, either at the first instance, a 2D complaint, followed by a protest memo, or if you have started it off on an FIR, here you require a protest memo which fulfills the conditions of a private complaint. That is not there, my lords. So here at this end, we only have a protest memo. Then, my lords, the impugned order which is passed, rejecting the B report and taking cognizance, that goes against Ravi Kumar's case. Now, my lords, the legal contentions which we had pointed out in the grounds, the 4 legal contentions may be noticed now, my lords. It's there along with the synopsis itself. The first is there's no complaint under section 2D of CRPC for the court to have taken cognizance.
Is not the protest petition the complaint?
No, it isn't, my lords. It is not in the frame. I have 3 judgments which I have, because on one end it should fulfill 2D, my lords. Here we don't have anything fulfilling 2D, and I've pointed out 3 judgments.
Our health. Yes.
Second aspect of it, my lords, order of rejection of B report contrary to Ravi Kumar's case is the second contention, my lords, which we have spelled out. Third, entire dispute is commercial transaction, suit filed, suit dismissed, and then, my lords, even before SEBI, it's a dismissal, B reports filed here. A cloak of criminality is sought to be given to a purely commercial transaction. That's the third contention. And next, my lords, we have pointed out that company is not even made a party. So concept of vicarious liability, his whole agreement is with the company, Sunil Bharti Mittal's case. Now, with these 4 contentions, my lords has the, my lords, judgments, according to judgments, my lords, with the paragraph numbers.
ಎಲ್ಲಿದೆ?
On the first point, my lords.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀರಾ? First point, no complaint under 2D for the court to have taken cognizance. My lords, 3 judgments, the latest of which is Kare, my lords, coordinate benches. In the first judgment there, my lords, if my lords would notice paragraph 2, 3 and 4, where they say it has to be in the form of a complaint, either in the beginning or if you're filing a protest, protest should have all the ingredients of a complaint. So 3 judgments on that aspect where we don't have a complaint here. Then second, my lords, order of rejection of B report, we're falling back on Ravi Kumar's case, my lords. Now the B report, it's not a case where it came under the first, where B report, we're not accepting, sending it for further investigation. No. Here is a case, my lords, B report, protest is considered together and an order is passed. Contrary to Ravi Kumar's case, my lords, it can't be done. Next, my lords, dispute purely civil in nature. My lords, at the time when we prepared this, Usha Chakraborty was the last one that we have referred to.
ಆಮೇಲೆ ತುಂಬಾ ಇದೆ.
Naresh Kumar, my lords, which my lords, Naresh Kumar, Delhi Race Club. These two again, my lords, I think amongst the latest ones, which says a commercial transaction, you can't convert it one. My lords, Naresh Kumar, I'm sure my lords would know 2024, I won't give. Then my lords, vicarious liability, no concept of vicarious liability. Sunil Bharti Mittal, doctrine of alter ego. And finally, my lords, we have just put one judgment on interference at this stage, my lords, in a matter which is purely commercial in nature. This is how we have segregated the judgments.
My lord, I went to Honorable Civil Court because I had a share value of 3 crore 55 lakhs. And company, the non-existent loan was 1 crore 37 lakhs. They abruptly, when I started corresponding with them, abruptly they stopped my trading account, my lord. Then shot me a letter asking, stating that if you don't clear 1 crore 37 within a week's time, we will sell all the shares and recover our amount. But when 3 crore 55 sufficient balance is there, it was not warranted to sell the stocks. Then I went to Honorable Civil Court with 2 prayers, my lord. Allow me to trade. Then kindly direct the petitioners not to sell. So the Honorable Court allowed me to trade. Then they issued the notice to the party. But that is a totally civil case, my lord. I found out a lot of criminal evidences here. Then I filed a criminal case. Civil case is nothing to do with that, with this case, my lord. That's what I would like to say. Company has not been made party. Everywhere Anand Rathi is only there, my lord. Even the trial court judge also has name and all company name is there. So with all these allegations, evidences, I pray to this honorable court to this case is not at all maintainable, my lord. Kindly request and bow my head and request to dismiss the petition, my lord.
Heard, reserved. Judgment reserved.
Public.
Yes. ನಿಮ್ದು ಇನ್ನೊಂದಿತ್ತಲ್ಲ ಯಾವುದು? ಇನ್ನೊಂದಿದೆಯಾ?
ಇನ್ನೊಂದು ಅದು ತಾವು ಜನವರಿ 15 ಕೊಟ್ಟಿದ್ದೀರಾ, my lord. ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 10 ಅದು. ಅವರಿಗೆ HBC ಅವಾಯ್ಡ್ ಮಾಡೋಕೆ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ, ಬಟ್ HBC ಆಗುತ್ತೆ ಟ್ರಯಲ್.
ಆಯ್ತು ಆಗುತ್ತೆ. ಆಯ್ತು.
Thank you.
That doesn't pertain to Anand Rathi.
This is different. Yes. This is on the merit of the matter.
They will have to furnish a report as per by law.
What report?
Further investigation was permitted to go on. Check to produce a production of report. Why I say this is a biased investigation, my lords. Crime number 56, where the allegations were made against the petitioners.
One document which I gave, my lord, it's the names of the purchasers and amount. This is in addition to what I showed last time.
Oh, ಇದು ಇವ್ರ ಅಕೌಂಟ್ ಹೋಗಿರೋದು.
In fact, my lord,
we have filed the affidavit.
My lord, this is how money has traveled to purchase this property.
Lease deed.
This is how money has traveled to purchase this property.
ಬೇರೆ ಏನ್ ರಿಪೋರ್ಟ್ ಹೇಳಿತ್ತು?
Alla, last.
What other report?
This is how the money has traveled to purchase this property. And in fact, my lord, that rent agreement which they have done, we have our own bona fide that the money is not received by those people who are supposed to receive, received by somebody else.
I would, my lords, one submission to show that this is biased investigation. Till today, my lords, accused number 1, 2, 3, and 5 have not been summoned, not been taken bail, not been arrested.
There 1 to 5.
1, 2, 3, and 5.
Why
No, we have arrested one person. Your lordship may,
I have produced
Why
all
are
the
the
sheets,
other
my lords.
accused left off?
we have arrested one person.
Huh.
Your lordship may remember, my lord, trial court released
No,
them
no,
saying
accused,
that
accused number 1.
Accused number 1, 2, 3, and 5.
Why,
Let
sir?
them make a statement.
Why, sir?
In crime number
Why?
56, my lord.
No, why you have not arrested, not they have on bail?
that's what we have arrested.
ಇದನ್ನು CBI ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ ನಾನು. The entire investigation I will hand it over to the CBI if this is the attitude.
Alala, we have arrested. Your lordship may recall, my lord, the trial court released them saying
In a,
that.
in a magnitude of, a scam of magnitude of this nature,
Yes, my lord.
you are still,
No, no.
moving on at
No, your
a
lordship,
snail's pace.
Your lordship may recall, we have arrested one of the accused.
One of the accused.
Alala, because of the coordinate bench stay, my lord.
ಆಯ್ತು, one of the, ಎಲ್ಲರಿಗೂ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಬ್ರು ಮೇಲೂ ಸ್ಟೇ ಐತೆ. Main two
ಆಯ್ತು,
accused have
ಮಿಕ್ಕವ್ರು
stay.
ಯಾರನ್ನ ಬೇಲ್ ತಗೊಂಡಿದ್ದಾರೆ ಬೇರೆಯವರು?
May make that submission.
Why have you not arrested them?
We are now.
What is this?
Alala, your
What is the state doing?
Alala, your lordship may.
I told you, in a scam of this nature, nothing is, I will definitely hand over the entire investigation to CBI now. If this is the attitude of the state in trying to shield the culprits.
No, we are not. We are
What
not trying
else are you doing, sir?
No, they are the main.
ಇದ್ಯಾವ್ದು ವಾಲ್ಮೀಕಿದ ಬೋವಿದ ಇದು? Bovi
Bowie
scam.
Corporation.
Bovi Corporation scam.
Yes, ma'am.
How many crores?
If my lords want to
Also,
kindly see page
This
number
is
48.
also,
100 crores.
initially it was less, but we are calculating now, it crosses 150 crores.
150
Yes,
crores.
yes. Cross
The
100.
culprits are at large still without bail. How? 1.5 ವರ್ಷದಿಂದ.
Many things have happened. I can place all those.
Many things have happened and the main thing has not happened. Why?
No, we have taken action against officers also.
Which officers?
Some office investigation officer have been suspended. in
That to
this
3
case.
officers.
No, that's
my
all
lords.
right. But why are they accused at large without any protection from any court?
17A
Sir,
quashing petition.
17A quashing ಆಗಿದೆ.
Yes.
ಅದು ಬಿಡಿ. ಬೇರೆಯವ್ರದ್ದು.
Alala, because of the stay we could not do.
It's all right. 17A stay ಆದ್ರೆ it is not that their arrest is stayed or investigation is
No,
stayed.
that is
everything
what, my
stayed.
lord, in fact, we have to come to your lordship saying that the trial court has issued a notice against us.
That I vacated that day itself.
But in spite of, anyway, in
No.
spite,
Against which accused was that?
accused number
9.
Accused number?
She is one of the main.
That's all right.
She is an MD.
Accused number 1.
Is,
Accused
One
number
ಮೇಲೆ
1,
ಏನಿತ್ತು? One
2.
ಮೇಲೆ ಯಾವ್ದಾದ್ರು ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಇತ್ತಾ?
there is no protection.
Accused number 2 ಮೇಲೆ ಏನಿತ್ತು?
In this FIR, my lords.
1 minute, sir.
No, there is.
Accused number 2 ಮೇಲೆ ಏನಿತ್ತು?
No, those two things was there. We have cleared that, and we are now investigating. In between this happened, and in between the investigation agency has to be changed because of their handing glove with accused people.
Accused number 1 ಯಾರ್ಯಾರು?
My lords, if my lords are to
1
kindly
minute.
take.
Take me to the accused.
And my
Page-
brother friend only appeared for them and then got a stay.
No problem. ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ?
ಅಲ್ಲ,
Accused number 1 is not before the
Page
court.
number 61, my lords.
ಒಂದು ನಿಮಿಷ. A1.
Saraswati.
A1 is?
Saraswati. A2 is Lakshmi. A3 is Padma.
ಒಂದು ನಿಮಿಷ. A2.
Is Lakshmi.
A3.
Padma. A5 is Annayappa. Till today, my lords, no bail. They have not
A5
even-
ಅಣ್ಣಯ್ಯಪ್ಪ.
Annayappa.
Others have taken bail.
Others have taken bail.
Who are the
Not even they have been summoned till today to the investigation.
I think this is a fit case to hand it over to the CBI.
That is the reason, my lords, all these days.
It is a fit case to be handed over to CBI.
Submitting, my lords, it is
The
a biased
state is moving
investigation.
at a snail's pace, protecting or shielding the accused. There can be no other inference that can be drawn with this. I'm passing an order now. Not
I'll-
handing over to CBI,
No, I'll-
but how are these accused for the last 18 months at large without bail being taken?
I'll-
How are you shielding these accused?
No,
No, how are you shielding this accused?
With these accused people, my lord, then I was under impression.
Whatever it is, sir, accused number 1, 2, 3, and 5. They are not on bail for the last 1.5 years. They're at large, not even summoned for investigation. What sort of investigation
No,
is
that I
this?
have to, that I have to clarify, my lord.
What you have to
Summoned or not
clarify?
summoned, I have to clarify.
Yes, Varkoli madam.
I
The,
believe some of the people are on bail, my lord.
these people are not on bail.
I have produced the order sheet.
That's all right,
Order
no
sheet
problem.
shows
Yes.
No, there, I don't know.
2024.
And that DYSP who is abetted suicide of a particular person is still not arrested. What have you done? We'll hand over everything, sir. This is the way the state is functioning with these scams, sir. There's less said, the better. Yes.
I have produced the order sheet from 11 to 48, my lords, from 2023 to 20.
The petitioners are before this court in calling in question proceedings in crime number 56 of 2023. The crime is registered on what date?
My lords, it is registered on
18/3/2023, man.
18/3/2023. How many accused?
initially it was, my lords,
8 people.
8 people.
Initially against 8 accused, and today are at how many
There are
accused?
13 to 14. my lords.
There are 14 accused. Even according to the learned additional SPP, the unearthing of documents today in this Bowie Corporation has projected a huge scam of 150 crores.
100+ crores.
150 crores and above.
100+ crores.
100 crores and above. Therefore, it is an alleged scam of certain magnitude. In the said crime, it is alleged by the petitioner, alleged by the petitioners who are petitioners in these cases who are accused number?
7, 8, my lords. Now,
Accused number 7,
7 and 8.
7 and 8, that the main culprits, accused number 1, 2, 3, and 5, are not even summoned for investigation for the last 20 months. They have not secured bail from the hands of any court for the last 20 months. And today, they are neither called for investigation nor taken into custody, as is done in everybody else's case. Therefore, the state appears to be shielding the accused 1, 2, 3, and 5, who are at large, neither appearing for investigation as they have not been summoned, neither arrested, as, notwithstanding the fact that they have not secured bail from the competent court even today. Therefore,
Clarify that, my lord, whether they taken bail.
Therefore, it is a fit case as to why the entire investigation should not be handed over to an independent agency, as the state appears to be acting with a snail's pace in a alleged scam of such huge magnitude. The state shall, by the next date, produce all the records of A1, A2, A3, A5, their investigation, their participation in the investigation, or any bail secured by them, failing which this court would be constrained to pass necessary orders. List on 6th in the fresh matters list. Yes.
So the earlier protection.
Interim
given-
order, the protective orders subsisting in the case at hand shall continue till the next date of hearing. Yes.
Further hearing.
I have produced the order
Of
sheet.
course, further, less the matter is further hearing.
That fresh and
In the for further hearing.
My lords,
Further hearing.
one sentence, my lords.
Uh.
I have produced the order sheets starting from the day 1 till 8/8/2024, which does not show any bail taken by those accused.
One kade bail ತಗೊಂಡಿಲ್ಲ ಅದಕ್ಕೆ, which is vindicated by a perusal of the order sheet maintained by the maintained before the concerned court. Yes, next.
Kindly pass on my letter. Kindly pass it.
Here is engaged.
Engaged in it.
ಏನಿದು?
This is the case, my lord, where they made an allegation against the ACP saying that he demanded, he's taken a checks and other things. He has to file an affidavit.
That Chandan.
Yes, ma'am. Now, I place the investigation so far done, my lord, in this case. There's one request, my lord. Your lordship has stated. There are some CCTV images which we have to recover, which shows that the petitioner who accompanied the victim to the bank and withdraw the amount of those things.
Entry ಮಾಡಿದೆ.
Cooperate, will let him come then. Yes, let the senior come. Next.
There are another connected matters there, my lord. Depending on the example number 4, that was not tagged.
Paravala.
Despite of the court order.
First, we are dealing with other cases. Let us. Yes.
So in this matter, my lord.
Paravala, sir. Wait, sir. Yes.
No, sir, 105, I will take steps to R3 and 4 minutes.
What is this, sir?
No, this is also, let's say, DCP Bangalore Northeast. Instead of, minutes, protecting the landowners, he shields the land grabbers and he passes an order under section old 107 of CRPC. He's made as a party in person. Yes, I made him party as a person also.
Let it come after vacation. Yes.
Interim.
Let's start, release the matter from the status of being part heard. List after vacation, interim order subsisting would continue to the next state of hearing. 106.
106 also, Mr. Lordship may kindly pass over. Senior counsel.
ಎಲ್ಲಿ ಇವರು ವಕಾಲತ್ ಹಾಕಿಸ್ತೀನಿ ಅಂತ ಅಂದ್ರೆ 2 ವಾರ
He has
time.
appeared.
We represent for R2 man, Sachin BS.
R2.
ಇವತ್ತು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
Counsel so and so submits that he has entered appearance for the second respondent registry to print the name of so and so as appearing for the second respondent.
We'll file objections.
List the matter on 16th for further hearing. The further hearing ideyalla. List the matter on 16th. Objections, if any, by the second respondent by then. Interim order subsisting shall continue till the next date of hearing. Next. Heggade sir idira already 4:30 ಅಂತ ಪರವಾಗಿಲ್ಲ ತಗೊಳ್ಳೋಣ ತಗೋಬೋದಾ
ತಗೋಬಹುದು.
ಸರಿ ಸ್ಟೇಟ್ ಮಾತ್ರ ಅಲ್ವಾ
ಹೌದು ಅಷ್ಟೇ ಪ್ಲೀಸ್
My lord, sorry to inform the honorable court, yesterday, despite this all court's directions, they did not open. They did not. They're present.
I have asked him, he called me yesterday, he was present in the court yesterday. I asked him yesterday, he said, he only called me. I said, please open it, let them inspect it, you inspect it. And then record it and then tomorrow we'll hear. But he has his own understanding. Your lordship.
ಯಾಕೆ ಸರ್ ಓಪನ್ ಮಾಡಿಲ್ಲ
Sir, submission, sir.
ಯಾಕೆ ಓಪನ್ ಮಾಡಿಲ್ಲ
My lord, ಅದು
ನೀವಿದ್ರೆ ಇಲ್ಲಿ ಕೇಳಿಸ್ಲಿಲ್ವಾ
ಕೇಳಿಸ್ತು.
ಯಾಕೆ ಓಪನ್ ಮಾಡಿಲ್ಲ why did you not obey the orders of the court
Sir, submission, my lord.
Yes.
Order sheet ಅಲ್ಲಿ ಒಂದು ಬಂದ್ರೆ ಮಾಡಿಸ್ತೀನಿ sir.
ಆರ್ಡರ್ ಶೀಟ್ ಯಾಕೆ ಕೇಳಿಸ್ಲಿಲ್ವಾ ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದು ಅಂತ
ಕೇಳಿಸ್ತು.
ಮತ್ತೆ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ ಹೇಳ್ದಂಗೆ ಆರ್ಡರ್ ಶೀಟ್ ಬರ್ಲಿ ಅಂತ ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್ ನಾನ್ಸೆನ್ಸ್
ಮಾಡಿಸ್ತೀನಿ sir.
ಯಾವಾಗ
ನಾಳೆನೇ ಮಾಡಿಸ್ತೀನಿ sir.
ಈಗ ಎಲ್ಲಿದೆ ಇದು
Your lordship, it is in court.
ವೇರ್ ಇಸ್ ಇಟ್
Kushal Nagara.
I will direct departmental inquiry to be initiated against you. You are behaving too much.
May I propose one thing, since he is, let the last police officer to take the hard disk with the Maser. We'll send it to FSL and get the report. We don't have to.
No. How can he say he is not going to obey the orders of the court despite being present yesterday?
And if he called me. and I
Order
told him-
ಕೇಳಿಸ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ
ಕೇಳಿಸ್ತು.
ಅವ್ರು ಹೇಳಿದ್ರೋ ಇಲ್ವಾ ನಿಮ್ಗೆ
ಮಾಡಿಸ್ತೀನಿ sir.
ಕಂಟೆಂಪ್ಟ್ ಕೋರ್ಟ್ ಕಳಿಸ್ತೀನಿ ಈಗ
ಮಾಡಿಸ್ತೀನಿ.
ಯು ಆರ್ ಅ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್
Yes, sir.
ವಿ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಆಲ್ ದಟ್ ಟು ಬಿ ಎಂಟರ್ಡ್ ಇನ್ ಟು ಯುವರ್ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಯಾವ ಕೇಡ್ರಲ್ಲಿ ಇದ್ದೀರಾ
Class 1.
Doctor.
Doctor,
ಡಾಕ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಪ್ರಮೋಷನಲ್ ಪೋಸ್ಟ್ ಏನು
joint director.
ಅದು ಹೋಗುತ್ತೆ
They deliberate, my lords.
This
They
is
in fact
ridiculous.
deliberate.
First of all, you don't know the law, how to register a complaint, how to conduct a search. That itself is enough to initiate departmental inquiry against you, and you are disobeying the orders of the court that is granted yesterday in your presence.
In fact, if he had asked me yesterday, think give me in writing, I would have sent a letter. He did not ask.
No,
for
he was
yesterday.
here.
He was here. I told him. And today morning he comes and says there is no order, therefore I will not open.
Oh my God.
Yes, sir.
ಮಾಡಿಸ್ತೀನಿ sir.
ಯಾವಾಗ
ನಾಳೆನೇ ಮಾಡಿಸ್ತೀನಿ.
ನಾಳೆ ಬೆಳಿಗ್ಗೆ 10:00 ಮಾಡ್ಬೇಕು Yes.
May I submit one aspect, my lords? Now kindly see how it happens on page
All
number
right.
29.
Let him do it tomorrow.
No,
right?
my lords, I
That,
have strong objection to his conduct, my lords. This
That,
cannot be
that
gone.
we'll see
for this
later, sir.
purpose, my lords.
First let it be
Your lords,
open.
21
Sir,
5
one minute.
Please,
Don't
please.
come in the way of the implementation of the order that I've already passed.
He, then, that's true,
Tomorrow,
my lords.
tomorrow it will be done. Or the, what's your name?
Dr. Anand.
Doctor?
Anand.
Anand.
Dr. Anand, who filed or registered the complaint, was present before the court on 17/12/2024, and in his presence, the following order is passed, directing him to a particular action as observed in the order. The said doctor is again present today without complying the order dated 17/12/2024 on the specious plea that the order was not available to him. It was, as observed here in above, it is passed in his presence, and he has wantonly disobeyed the order of the court. Therefore, it is a case where a departmental inquiry is to be instituted against the said doctor, not only for this reason, but for registering complaint contrary to law, despite the knowledge of how it's to be passed. Less said, the better about the conduct of this doctor while registering the complaint. Be that
Not registering the complaint
No, no,
at the time of conducting a.
less said, the better about the doctor at the time of conduct of the search, as the news is circulated on WhatsApp about the search, and the search
On 21
happens,
5.
and search happens at a later point in time. Therefore, the order dated 17/12/2024 shall stand complied by 12 p.m. tomorrow. In the event it is not, this court would unleash the coercive arm of law against the doctor.
May I also make one humble request, my lords? Now, as far as the allegation, entire allegation, even as per this is, my lords, that in the computer system, it is not there, is what they say, my lords. The document, the F form is there. My lords, number 21 5 in the.
If less said, the better about them. The same applies to you.
My lord, from
Because you have also not kept anything in order.
everything is on
No,
order. I
allowed
have produced
to know.
yesterday.
Naale
My lord, what
ತೆಗಿತಾರಲ್ಲ,
they say is in the computer
what's the problem in getting the
not
documents
opened
out?
since 21 5, my lords.
It's all right,
No,
yes. I think ತೆಗಿತಾರೆ ನಾಳೆ.
Please, my lord.
Tomorrow, yes.
And my lords, to be handed over to me, they let them take the printouts, everything, my lords, all the data, etc., my lords. And then, my lords, I should be able to, my lords, permitted to do my evocation, my lords, without violating the law, my lords. From 21 5 onwards, my lords.
No, wait. Revocation of your evocation will be later. Yes. List the matter on 6th in the, for further hearing. Yes. Further hearing ಇದೆ ಅಲ್ವಾ?
May bow down and submit one aspect, my lords. I know my limitation, but only thing is, my lords, from 20.
You want to move the vacation bench?
No. Yes. Only this, my lords. I want, my lords, protection for me, my lords, to carry on the operations, my lords, only with strictly in accordance with the law, my lords.
We'll permit you everything.
Please, my
Let
lords.
the inspection, the inspection of the opening of the premises and the inspection conducted shall be written down as a report and placed before the court on the next date of hearing.
And then, my lords,
shall be videographed, and a report of that shall be placed before this court on the next date.
please. And my lords, that's the premises, my lords, may kindly be handed over. They're keeping it in lock. My license is not cancelled. No show cause notice issued, my lords.
On that day,
Please,
whole
please.
hog I will give you.
My lords have held, my lords, that show cause notice.
I am aware, sir. See, he may have violated the law in initiating. Prima facie, you have also violated the law in getting scans done without any record.
Record ಇದೆ. ಅವ್ರು ಹೇಳಿದ್ದು
ಅದಕ್ಕೆ
computer ಅಲ್ಲಿ ಇಲ್ಲ
ಬರ್ಲಿ,
ಅಂತ
ಅದೆಲ್ಲ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿ.
As per the records, it's.
ಅದೇ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿ.
This might have kindly.
Computer alla, even book allu,
My lord,
register also do
now-
not have the record.
See, your register and the computer should tally.
Please, may I
ಅದು
only make
report
this fair,
ಬರ್ಲಿ.
my lords, to balance this, my lords, because I have been.
I have directed it to be videographed.
That's why,
Yes.
after that, my lords, let my premises be handed over to me, my lords, that they cannot
will-
withhold
you
the premises, my lords.
You will get
Continuously.
everything on this.
6 ತಿಂಗಳಾಯ್ತು ಅಂತ ಅಷ್ಟೇ.
6 ತಿಂಗಳಾಗಿದೆ, ಇನ್ನು 16 ದಿವಸ ಏನಾಗಲ್ಲ.
ಹಾ.
6th, ಎಸ್.
Submission, my lord. ಅಲ್ಲಿ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಒಂದು ಪಾರ್ಟ್ ಅಲ್ಲಿ ಸ್ಕ್ಯಾನಿಂಗ್ ಸೆಂಟರ್ ರೂಮ್ ಇದೆ ಸರ್, ಮೈ ಲಾರ್ಡ್. ಇನ್ನೊಂದು ಪಾರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಎಕ್ಸ್ರೇ ಯೂನಿಟ್ ಪ್ಲಾಂಟ್ ಎಲ್ಲ ಇದೆ, ಮೈ ಲಾರ್ಡ್. ಇದು ಅವ್ರು ಏನು ಡೇ ಟು ಡೇ ಅವ್ರದ್ದು ಇದು
ನೀವು
ಮಾಡಕ್ಕೆ
ಅದನ್ನ
ಅವ್ರಿಗೇನು-
ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ತಂದು ಕೋರ್ಟ್ ಕೊಡಿ.
ಆಯ್ತು.
ಮತ್ತೆ ಇಫ್ ಯು ವೈಲೇಟ್ ದಿ ಆರ್ಡರ್ಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಯೂಸಿಂಗ್ ಯುವರ್ ಓನ್ ಇಂಟೆಲಿಜೆನ್ಸ್, ಇಟ್ ವಿಲ್ ಬಿ ಎ ಪ್ರಾಬ್ಲಮ್. ಎಸ್, ಎಸ್. ಲಿಸ್ಟ್ ಆನ್ 6th.
ಒಂದಕ್ಕೆ ನಾಳೆ ಈ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಿ ಪೂರ್ತಿ ಅವ್ರ presence ಅಲ್ಲಿ ಮತ್ತೆ
ಓದೈತಾ ಲಿಸ್ಟ್? ಕರೆದ್ಬಿಡಿ
Please. My lord, with kind permission, the past over matter 86, my
ಹಾ,
lord,
ಅದೊಂದು
also
ಶ್ರೀದೇವಿ ಸೇಮ್
where there is no. ಇದು also. ಇದು 34. List.
ಸೀಲ್ ನಂಬರ್ 34 ಅಲ್ಲ?
34.
ಲಿಸ್ಟ್ ಲಿಸ್ಟ್ 2. ಲಿಸ್ಟ್ 2 ಕರೆಕ್ಟ್.
Please, my lord. Where, my lord, whether there is an authorization.
ಅದು ಯಾರು
Please,
ಆಫ್ಟರ್
question.
ವೆಕೇಶನ್ ಹಾಕಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅಲ್ವಾ?
ಇಲ್ಲ sir. Your lord's wanted to
ಎಂಟ್ರಿ
see whether there is
ಅಂದ್ರೆ
a-
ಅದಕ್ಕೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕಿ.
Please, my lord. My lord, there is no proper authorization to file the complaint, my lord. The complaint has already been filed. Your lordship had directed.
ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ ರೂಲ್ಸ್ ದಟ್ ದೋಸ್ ಆರ್ಡರ್ಸ್ ಅದು 6th ಗೆ ಹಾಕ್ತೀನಿ. ಈಗ ಏನ್ ಅಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್
Criminal
ಆಗಿದೆ?
case is filed that your lordship may kindly
ಅದ್ರಲ್ಲಿ-
stall the criminal procedure, that's all. Your lordship have directed to open it, my lord, earlier.
ಯು ಆರ್ ರನ್ನಿಂಗ್.
I am running.
Myself permitted.
Yes, yes.
Yes, list on 6th. Further proceedings shall remain state till the next date.
Please.
Yes.
And in fact, in both these cases, in advance, I'm submitting, my lords, to my learned friend also. Submission is, my lords. As far as that authorization is concerned, my lords, in what form it should be, your lords may kindly laid on.
That will-
It is not there, not at all there.
That wills. ಅವ್ರೊಂದು ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಆಥರೈಸೇಷನ್ ಕೊಡಿ ಅಂತ ಅವ್ರು 2 years ಇಂದ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರು ಅಡಾಕ್ ಬೇಸಿಸ್ ಮೇಲೆ ಕೊಡೋದು.
And one word, my lord, that authorization only, my lord, law provides, it shall be in his absence only, my lords. It cannot be in other cases. 18A provides in his absence. Now, it cannot be say, I am giving the authorization to somebody else, my lords.
Wills. ಅವತ್ತು 6th.
In both cases, that
Okay.
question is there, my lords. In both these cases, my lords. Please, I'm great.
Further hearing. Yes.
Further hearing for this.
Yes.
Most good.
230 more matters. Fresh matter still number 1, Puneet C.
Second FIR, please, my lord. First FIR.
First FIR ಯಾವುದು ಸರ್?
First FIR is at page annexure E, your lordship has stayed. For 323, 324, 447, civil suit is pending.
ಒಂದು ನಿಮಿಷ ಸರ್, ಒಂದು ನಿಮಿಷ. ಸೆಕೆಂಡ್ FIR ಇದು ಪ್ರೆಸೆಂಟ್
Second FIR is present,
ಪೇಜ್
19.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
Charge sheet ಆಗಿದೆ.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ತಾ
Charge
ಇದ್ದೀರಿ
ಗೆ
ಇಲ್ಲಿವರೆಗೆ?
ಶನಿವಾರ charge.
ಅಲ್ಲ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ಸೆಕೆಂಡ್ FIR
But it was filed on 6th November.
9/11/23.
The dates are
Dates are different. Offense same.
First one, your lordship has
The
stayed.
petitioner is before this court. Calling in question crime number 423 of 2023, registered for offense punishable under section 323, 324, 354, 447, 5404 and 506, read with 34 of the IPC. The complainant had registered a complaint earlier in crime number 351 of 2023 for the very same offenses, but it was from 26, the date of cause of action was on 26/9/2023. Projecting a different date of cause of action, the crime for the same offense as observed herein above is registered twice over. Therefore, twice over. The reason appears to be an interim order of stay granted in crime number 351 of 2023. ಯಾವ್ದು ಫಸ್ಟ್ ಆಗಿದ್ದು?
First ಆಗಿದ್ದು 23.
ಇದು 24 ಇದು?
28/9/2023.
ಇದು 23 ನೇ?
ಇದು 23.
ಹೌದಾ?
ಅಲ್ಲ ನಾನು
Don't so. The difference between the two crimes is a gap of 60 days for the same offense. Therefore, there shall be an interim order of stay of further proceedings in the subject crime till the next date of hearing. 1 HCGP 2 emergent notice. Thank you.
Number 2, Vijay Shekhar.
Vijay Shekhar. ಕೊಡಿ. Withdrawal ಇದೆ. Yes, 1 HCGP 2 emergent notice. There shall, the petitioner is the owner of a particular vehicle who hires a driver and a driver who hires a cleaner. The driver and the cleaner, while traveling in the vehicle, meet a vehicle. The driver and the cleaner who were on board of the vehicle meets with an accident. Wait, sir. Meets with an, you are searching your case or you're searching your name?
I couldn't hear that.
Couldn't hear your name.
Yes.
It's all right. Wait. So and so. You are the driver or the owner? So and so. The petitioner is the owner of the vehicle who has been dragged into these proceedings, despite despite the fact that the vehicle was driven by someone else. Therefore, till the appearance of the complainant, there shall be an interim order of stay of further proceedings qua the petitioner. It is made clear that the interim order subsisting in the case at hand will not come in the way of the claimant's claim, if any, before the concerned court. ಈಗ ನೇಮ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ, ಕೇಸ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ?
Number 3.
Yes. Nishit. Where is Nishit?
Not well, my lords.
What happened? Not coming? Is all right?
Lords, 498, my lords. The husband, mother-in-law and sister-in-law, my lords. Lords, may kindly see page number 37 of the petition, my lords. That was the settlement agreement for which.
Page?
37, my lords.
Huh.
For mutual divorce, my lords.
Where is it? This is not signed?
No, my lords.
Why?
My lords, the conditions were being drafted, my lords. There was slight miscommunication with the procedure as to how they want to move on, my lord. That is there in page number 48 to 76. The WhatsApp
You
conversation.
settle with the wife. Others I will stay now.
Please.
The petitioners are husband, mother-in-law, amale?
Sister-in-law.
Mother-in-law and other-in-law. Yes, the 1 HCGP 2 emergent notice. A perusal at the summary of the charge sheet agidiyalla? At the summary of the charge sheet would
My lords,
not.
FIR.
FIR ಅಷ್ಟೇನಾ? A perusal at the complaint registered by the second respondent complainant, wife of accused number 1, the first petitioner, would not indicate any offense against the other members of the family. The learned counsel would also submit that talks of settlement between the husband and the wife were in progress and are in progress. In that light, I deem it appropriate to grant stay of all investigation qua the petitioners, first petitioner ಬಿಟ್ಟು ಯಾರಿದ್ದಾರೆ ಎಲ್ಲರೂ ಕೊಟ್ಬಿಡಿ ಮಾಡಿ. Failing which it would run foul of the judgment of the apex court in the case of Payal Sharma versus so and so 2024 SCC online SC, page 3473. Yes.
Number 4.
Therefore, there shall be an interim order of stay, qua all others except one. Petition number 1. Next.
Bill number 4. Sunil
Yes,
Kumar
Sunil
H.
Kumar.
Please. Office code.
Copy ilva?
Office code, sorry. Colleagues have said to the office mistakenly.
Why? You don't know the procedure?
I've told them, Lord, sorry.
What is this? Then will not grant the interim order. This is not correct. Yes, sir.
My apologies.
Yes.
The offense under 406, 420. But now is similar 406, 420
ಬೆಳಿಗ್ಗೆ
ಬಿಟ್ಟು
ಏನೋ check
138 ಕೂಡ initiate ಮಾಡಿದ್ದಾರೆ.
So
That is also running. Lord, I'll give my own copy.
yes, the petitioners are before this court calling in question source. The fulcrum of the list revolves around cheating. The cheating is for the reason that the petitioners had issued certain checks and the checks have been dishonored. The checks which were issued in the year on 1/1/2016 is sought to be projected as a crime on 13/6/2022, 6 years thereafter. The learned counsel for the petitioner submits that on the very same cause of action, the respondent complainant has also instituted proceedings invoking proceedings for offense punishable under section 138 of the Negotiable Instruments Act. With the dual proceedings instituted by the complainant as also the delay in registering the subject crime, there shall be an interim order of stay of further proceedings, quay the petitioner still the next date of hearing. 1 additional SPP, 2 emergent notice.
Correct.
Number 5.
Next.
No, this is a complaint filed by my ex-employer, my lord, stating that I have not given them back the
ಅಷ್ಟೊಂದು
loan.
ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀರಾ ಎಲ್ಲ ಪೇಜ್ಗೂ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
For reference, my lord.
Every page is important.
Illa, what is important I mark, my lord. What
But
my
every
lords may
page
pose a
appears to be
question.
important.
What my lords may pose a question, my lord, with that. Ex-employer files it against me, my lord. He's
Yes.
done this. This is the same modus operandi. Other employees have also gone, approached this honorable court, my lord. Coordinate bench has already stayed the matter.
Page.
Annexure, my lord, page 165, annexure K.
Lavanya madam. Idu page 165,
Please.
tag along with that same order.
Please. Please, because in this, it's a
ಇನ್ನೇನ್
CC. ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ FIR stage ಅಲ್ಲಿ ಇದು CC ಇದೆ.
ಇದು ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ CC ಅಂತ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಟ್ಟು CC ಅಂತ ಹಾಕಿ. Yes.
Please, Oblesh.
The offense under
Number 2,
384,
my
my
lords.
lords, reporting for settlement.
My lords,
Petitioners are here, petition is here.
Kindly pass over, my lord. The respondent number 2, he was present all the while from afternoon. He just went on a call, my lords. I'm just trying to reach him. I'm not.
What kind of call?
Kindly
There was
pass
a
it
call
on.
from his office, my lords.
All right, sir. Yes. Pass over.
Kindly pass. Oblesh.
Oblesh, my lords.
Till number 6, Puneet, say.
498A in-laws, madam.
In-laws, only in-laws?
Only in-laws, but
Settlement ಇದು 5 ಅದು 6.
They made a wrong submission.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ 6 ಪಾಸ್ ಅವ್ರು ಕೇಳಿದ್ ಯಾರೀಗ? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್?
Serial number 6, my lord.
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ?
My lord, 230 list, my lords.
6 230 ಲಿಸ್ಟ್ ಇಸ್ ಪುನೀತ್.
Oh, my lords. Sorry, my lords.
ಯಾರ್ದೋ ಪಾಸ್ ಅವ್ರು ಕೇಳ್ಬಿಟ್ರು. Yes. The petitioners are before this court calling in question proceedings in CC
not in CC 10730 of 22.
10730 of 22 registered for offense punishable under section 498A and 3 and 4 of the Dowry Prohibition Act. A perusal at the summary of the charge sheet as obtaining in column number 17 would indicate all offenses, grievances against the husband accused number 1 who is not before the court, as the complaint or the charge sheet travels from 2/3/2012 to 17/9/2021 and the allegations as observed herein above is against the husband. Finding no ingredients of section 498A, I deem it appropriate to stay further proceedings where these petitioners, failing which it would run foul of the judgment of the apex court in the case of Dara Lakshmi Narayana versus so and so 2024 SCC online SC page 3682. Therefore, there shall be an interim order of stay for the proceedings. Yes, next. ಮೇಲೆ ನೋಟಿಸ್ ಹೇಳಿದ್ನಲ್ಲ 1 HCGP ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಮೇಲೆ ಹಾಕೊಂಡ್ಬಿಡಿ ಮೇಡಮ್.
My lord, petitioners obtained anticipated bail, my lord. Thereafter, my lord, without giving notice to the petitioners, page 25, my lord, have cancelled the bail.
Already cancelled.
Page
25,
my lord. And now they are appeared, they have obtained regular bail also, my lord, they are appearing before the court.
25.
Yes, my lord. 20.
No notice is given?
No notice. And now obtained regular bail, my lord, they are appeared. Case is posted for year before charge.
Is the anticipatory bail?
Yes.
Will state. Regular bail ತಗೊಂಡಿದ್ದಾರೆ, but anyway, this is not, should not stay on them.
Stay ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಅರೆಸ್ಟ್ ಮಾಡಿ.
ಇದು ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ಇದು ಆರ್ಡರ್ ಅಷ್ಟೇ ಸ್ಟೇ ಕೇಳ್ತಾರೆ.
ಆರ್ಡರ್ ಸ್ಟೇ ಇನ್ನೇನಿಲ್ಲ. Not proceedings. The petitioner is before this court calling in question an order dated, ಯಾವ date ಇದು?
9/3/23.
29/3?
9/3/23.
9th March 2023, which cancels the anticipatory bail granted to this petitioner by an order in the year 2022. The learned counsel submits that no notice was issued to the petitioner as is necessary in law prior to passage of the order of cancellation of bail. He would further submit regular bail is subsequently granted and the petitioners have not violated the conditions stipulated in the regular bail. In the light of the order of cancellation of bail being passed without hearing the petitioner, the said order shall remain stayed. Yes.
Number 8, Deep Kumar.
Arises of 138 proceedings, my lord, criminal appeals. The district judge passes an order allowing a 311 application. Based on that, a conviction is done. She has got no power of revision, but she orders in a revision petition. That order is at page.
Emergent notice to the respondent petitioner to serve on the counsel who represents the respondent in the appeal proceedings. Till such time, the impugned order shall remain stayed. Yes.
Nine.
Serve on so and so. List on 16 January. Till
Oh,
such
respondents
time.
form.
Yes, next.
Kindly pass over, my lords.
ಯಾವುದು?
9, my lords.
ಆಕಾಶ್ ಪಿ ಶೆಟ್ಟಿ.
Reporting for settlement, my lords.
ಆಯ್ತು ಸರಿ, ಪಾಸ್ ಓವರ್. ನೀವು ಯಾವ್ಯಾವ್ದೋ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತೀರಾ, ಅದಕ್ಕೆ ಇದು ಕರೆಕ್ಟಾ? ಎಸ್. ಸುನಿಲ್ ಕುಮಾರ್. ಬೆಳಗ್ಗೆದು, ಓಕೆ, ಸೇಮ್ ಆರ್ಡರ್ ಬೆಳಗ್ಗೆದು. ಅದು NVJ ಕೊಟ್ಟು.
11.
ಕೊಡಿ.
AG Baloli.
Hello. I challenge the proceedings of FIR. This is the second crime registered and against me. And previously, your lordship already crime number 180 of 2023 is registered by this petition. He has given a complaint by the petitioner, and there is a civil dispute. And the OS number 2.
ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಸರ್?
See, I have challenged the charge sheet in CC number 5684.
What is the allegation?
Allegation, your lordship, there is a civil.
Attempt to murder go civil dispute go ಏನ್ ಸಂಬಂಧ?
That's what, my lord.
That's what.
I'll come to point.
Come on.
Please, my lord, what has happened is, see, because these petitioners, they filed a suit, they filed a suit for partition. So I have produced the document wherein the stay was granted. And during subsistence of the stay, and actually they are trying to interfere my property.
Correct.
I given the complaint, and the police have taken and they have undertaken, and page number, your lordship, they are not to interfere that. Thereafter, your lordship, so they have actually again they are trying to interfere. We lodged a complaint, and the police has registered the case in crime number 180 of 23 and registered 354 wherein. But on the same day, again they have the opponent being their opponent, though they have undertaken before the station, and they have given the complaint. In pursuance of that, they have registered crime 181 for 307. This is a subsequent case. Both the charge sheet I have produced, and both the case proceedings also.
It is a case of 307, sir.
This is what, my lord. See, either my lord, idrali 307, because why they have registered, because already complaint we have given. They came in page number 38, my kindly peruse, your lordship.
Yes.
The same complainant, they have came and they given a statement.
Oh, sir.
Page number 38, my lord. Page number 38, wherein they gave in this Venkatagiriya and this Lakshmamma Gopal, these being the complainant in the case, they have given the statement before the police stating that they will not come to their
they'll not come to their, interfering in the property. They have given the statement. Thereafter, also there is a registered crime is registered 180. It's given me. They have registered crime 143, 147, 148, 324, 354, 504 against them. On the same day, night, 9:30, they have taken this complaint for the same incident. They have made it 307. And in the both the cases, I have produced the charge sheet. See, this is the case which I have challenged now is the subsequent case. And there is a civil dispute and interim order was subsisting against them. We are in enjoying and they have came and they have given the statement before the police also. And there is a two miscellaneous cases registered. Thereafter a charge sheet.
Let the complainant come. One additional SPP, two emergent notice.
My lord, literally, because what is happened is
307, I'm not going to stay.
I'm producing that. I'll just read out the contents. See, because there is a counter. This is subsequent case, my lord.
You have.
On the same day.
1 minute, sir. You have registered a crime.
Please.
Against them.
Yes, that was 7 o'clock. It was registered against the CC and all. And 9 o'clock they given the complaint.
So what?
For the same incident.
So what?
No, prior to that.
One of it must be true.
Well, prior to that.
One of it must be true. According to you, the incident has happened.
My lord, what is happened? There is a civil dispute.
Civil
Order was subsisting.
Civil
All
dispute
proceedings
is
are
not
there.
a license for attempt to murder, assault, grievous assault. ಇದು ಯಾವುದಕ್ಕೂ license ಅಲ್ಲ ಅದು.
Prior to that, 3 crimes are registered against them.
Maybe.
But all those things also, because there is a 3 cases are there. Intentionally, these respondent police have they made this.
Not in a case of attempt to murder. Yes.
I can understand, my lord, but if you
You can understand then after vacation. Yes.
If we gone through the petition, the complaint. See, complaint is, I'll just read out the complaint, my lord. It is completely, totally, it is a civil in dispute, completely.
Attempt to murder is civil in dispute.
That's the facts of the case itself. Is there is a case there was running. There was an interim order against them. They came and they given a statement.
See, all this is applicable to an offense under 447, 427, 406, 420. Not for 324, 326 or 307.
Again, you also kindly peruse the page number 138. They have given one more complaint for the same offense. They 447 they registered.
ಅದು ಪರವಾಗಿಲ್ಲ. ಅಷ್ಟೇ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೆ. 307 ಕೇಳಿದ್ ತಪ್ಪು ಮಾಡಿದಿರ.
ಅದರಲ್ಲಿ ಏಕಂದ್ರೆ
ಈಗ ಆಯ್ತಲ್ಲ.
Respondent, my lord.
Attempt to murder, I am not going to stay, sir. Yes.
Because both the charge sheets I have produced, there is an interim order there is a civil dispute. And this is subsequent case.
You're repeating 10 times will not get an interim order. 307, I am not granting an interim order, period. Yes.
Now this case is committed to session court, my lord.
So what? Yes.
So
ಆಯ್ತು.
Number 12.
by perusing the complaint, it's very
ಅಯ್ಯೋ,
clear.
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಸರ್. After vacations. Yes.
Copy for the petitioner, my lord. 498, my lord, mother-in-law.
ಒಬ್ರೇನಾ?
ಇನ್ನೊಂದು petition ಅಲ್ಲಿ husband ಇದೆ. In this, my lord,
ಹಸ್ಬೆಂಡ್ ಯಾಕೆ ಹಾಕದ್ರಿ?
both are omnibus allegations. Now the
ಅಲ್ಲ,
complaint,
ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಆಮ್ನಿಬಸ್ ಇದ್ರೇನಂತೆ?
ಅಲ್ಲ, victim is no more, my lord. 2020.
Complaint is no more.
Complainant is the father of the victim. That's the daughter, his own daughter.
ಏನಾಯ್ತು? What happened? 304 B-ನಾ?
ಇಲ್ಲ. She just passed away due to medical illness.
ಹಾ.
Kindly come to page number 69 for a moment, my lord. She was suffering from a rare disease, EUPD, some depressive disorder she had. So I have produced a medical document which is much prior to the marriage itself. So she passed away due to her medical condition, my lord. Now there is an omnibus allegation made by the father stating that her daughter was going through certain depression. She also tried to consume poison. Thereafter, my lord, and only allegation against me is that an additional dowry of 5 lakhs was made during the time in the matrimonial house. So this is against both the mother as well as the husband. This is the only allegation against me.
Yes.
Before this affair.
ಇಲ್ಲ. Yes. Heard sounds in the petitioner first ಎರಡು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್ 12 and 13. These petitions are by the mother-in-law and the husband of husband, but accused number 1 and 2 alleged of offense punishable under section 498A and 323. It transpires that the complainant is no more no more as she was suffering from EUPD, emotionally unstable
person.
personality disorder. ಇಂಥದ್ದು ಇದೆಯಾ?
My lord, even I've come across maybe.
So many disorders. And this I have heard, borderline personality
But-
disorder, that I have
yes.
heard. This is the ಕೇಳಿರಲಿಲ್ಲ. All right, so and so. And borderline personality disorder, BPD, due to which it transpires that the complainant dies. And the petitioners are now continued, the proceedings against these petitioners are continued for an offense punishable under section 498A. In the light of what is aforesaid, there shall be an interim order of stay of further proceedings qua these petitioners till the disposal of the petition.
Great.
No, ಈಗ complainant, who is pursuing it? Father.
The father, my lord, they're not coming before the trial court as well. 4 years has transpired.
Charge ಆಗಿದೆ.
State ನೋಡ್ಕೊಂತಾರೆ.
Much up.
14, Devaraja.
Petition number, accused number 4 and 5.
Offense.
Offense in the FIR stage, I have filed 307 alleged against accused number 1 to 3. Against me, there is no absolutely no allegations against me. Only I have
Copy ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದೀವಿ. But this
Yes, sir.
petitioner came to
Page number 11, my lord.
Page number?
11.
only with the right ಕುಮ್ಮಕ್ಕು ಅಂತ ಅಷ್ಟೇ, ಅಷ್ಟು ಬಿಟ್ರೆ ಏನಿಲ್ಲ. I was not even present, my lord, in the
Page
vicinity.
number 11 is petition.
Yes.
ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Not be correct.
Huh?
I think they have mixed they skipped one page, maybe 24, page number 24,
24
maybe.
ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಏನು?
The charge sheet.
Complaint page number 61
ಎಲ್ಲಿದೆ ಸರ್? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಇದೆ.
ಅದು ಎಲ್ಲಿದೆ?
in page 50, my lord. 50, column number 70.
ಇದೆಯಾ ಇಲ್ವಾ ಅಲ್ಲಿ? ಅಡಿಷನಲ್ SPP ಕೊಡಿ.
ಕೊಡಿ.
ನಿಮ್ಮ ಕಾಪಿ ಕೊಡಿ.
ಕೊಡಿ.
ಇದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ?
ಇದೆ.
ಹಾ ಸರಿ. ಎಸ್ ಸರ್. ಯುವರ್ ಅಕ್ಯೂಸ್ ನಂಬರ್
4 and 5. My lord, I had entered into an agreement with my vendor to purchase the property without possession. Now they are alleging, my lord, thereafter, my lord, the property came to be sold to some accused number 6 and 7. And I cannot claim the possession of the property. Still they would allege
4 and 5.
4 and 5.
Yes.
The charge
Second
sheet
last
would say
paragraph.
120B with the one word kumakninda.
Yes. We'll list it on move the vacation bench. Liberty to move the vacation bench. Yes.
My lord, Trimato, my lord, the first stage, my lord.
ಟೊಮೆಟೊ ಕೊಟ್ಟ ಮೇಲೆ ಯಾರು ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ ಅಂತಾರ?
No, one typed copy, my lord, 61, my ink page 61, my lord. Ink page 61.
No,
last
it
one.
is not that no allegations are there against.
It is no allegation.
There are.
But I can, my lord, again, but at this time of the FIR stage, my lord, I felt the
ಅವಾಗೇನ್ ಸ್ಟೇ ಇತ್ತಾ?
ಇಲ್ಲ ಸ್ಟೇ ಇರ್ಲಿಲ್ಲ. my lord, your lordship inclined to stay and then said you file ಮಾಡಿ ಇದ್ರು ಅಂತ. Yes, file ಮಾಡಿ.
Inclined to grant stay.
Yes, my lord.
All right, then
With responsibility.
we'll list it tomorrow. Tomorrow in the fresh matters list. ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಜಗದೀಶ್. I'll
Please.
just go through it. Yes, next.
Please.
15, Dinesh Kumar Rao.
Compromise your lordship. Offense under 384, 504, 506.
Offense?
Excuse number 3.
Offense.
384, 504, 506.
384.
Extortion. ಅಂದ್ರೆ
384.
M sand ಅನ್ನು ಇವರು ಟ್ರ್ಯಾಕ್ಟರ್ ಅಲ್ಲಿ A1 parties are also present.
Filing affidavit in this one.
ವಕಾಲತ್ತು.
The petitioners.
Petitioner.
Petitioner is before this court calling in question proceedings in special CC 43 of 2023. For the following offenses. The offenses alleged against the petitioner, during the pendency of the subject petition, the parties to the list have entered into a settlement and have filed an application seeking compounding of the offense. The application reads as follows. In the light of, though the offense is the one punishable under section 384 of the IPC, I deem it appropriate to accept the application seeking compounding and obliterate the crime against the petitioner for the aforesaid reason, disposed, quashed. Yes, next.
Order sheet. 16. Kash Emmett.
And for the petitioner, Your Lordship. Lordship, this is the case of 7A, wherein the petitioner was working as a
Charge sheet ಆಗಿದೆಯಾ?
Hagide, Your Lordship.
Charge sheet ಆಗಿದ್ರೆ tag ಮಾಡ್ತೀನಿ. The concerned court
Lordship.
shall defer its proceedings.
Framing of charges ಇದೆ, Your Lordship.
ಹೇಳಿದ concerned court shall defer its proceedings. Next. Tag ಮಾಡಿ madam. Further ಈಗ. Yes. BB Patil is, sorry, madam ಗೊತ್ತಿದ್ದಾರೆ. The learned counsel BB Patil is directed to accept notice for the Lokayukta. The petitioner shall serve upon the counsel, shall serve requisite set of papers upon the counsel for the respondent. Emergent notice, complainant ilwala, ಯಾರಿದೆ? Second respondent ಯಾರು?
He is the landowner of the,
7A.
please, Your Lordship.
ಹಂಗಾರೆ ಕಂಪ್ಲೇಂಟ್ ಇರ್ತಾರೆ. Emergent notice to the second respondent returnable by 16th January. Next. List on 16th.
Pleasure.
17. Arun Govind.
For the petitioner, my lord. Since of my ex-husband, my lord, continue to haunt
ನಾನು
me.
ಕೇಳ್ದೆ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಬ್ಲಮ್
Ex-husband.
ಬೆಳಗ್ಗೆ ಅಂತ.
Ex-husband.
ಇಲ್ಲ ಅಂತಂದ್ರು. Yes.
403, 405 and 420. My lord, all the allegations are against my ex-husband. My lord, the petition for divorce that I filed before the family court was only on that ground. that
ಎಲ್ಲೋ
he has-
ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ನಲ್ಲ
ಇಲ್ಲ, ಅದು ಬೇರೆ.
ಬೇರೆನಾ?
And now I have remarried. Now the trial court says, my lord, before I travel out of the country, every time I must seek permission, which was not the condition in the bail. Absolutely zero allegations against me. All the allegations are against my ex-husband. But I'm being made to suffer, my lord, criminal process.
I heard the learned counsel Arun Govindaraj appearing for the petitioner. One, emergent notice to the respondent. In DB proceedings, sir.
PCR.
PCR, emergent notice to the respondent. The petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. There shall be an interim order of stay of further proceedings before the concerned court, quay the petitioner till the next date of hearing.
I've also sought for permission to travel because the court.
ಒಂದೊಂದಾಗಿ ಅಲ್ಲಿ ಕೇಳಿ. Before the concerned court. Yes. ಎಲ್ಲ ಒಂದರಲ್ಲೇ ಕೇಳ್ಬಿಟ್ಟು. Yes.
18. Hearing on I-18.
Modification of bail condition number 1, my lord.
ಏನ್ modification?
My lord, the deposit of 25% of fine amount, my lord.
ಅದು ಬೆಳಗ್ಗೆ ಹಸ್ಮಂತ್ ಪಾಷಾ ಅವರು ಮೂವ್ ಮಾಡಿದ್ರು. ಅದು ಯಾವತ್ತು ಹಾಕಿದೆ?
It is 15th, my lord.
ಅದು ಸೇಮ್ ಆರ್ಡರ್ ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. NVJ ಕೊಡಿ. 2 weeks ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದೀನಿ, ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ. ನಿಮಗೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
It's not able to arrange the amount.
What not able to arrange?
The company.
Yes.
Admission 19. Ramesh GK.
Yes. ಏನಿದೆ? ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ರಿ ನೋಡೋಣ, ಬಂದ್ರೆ ನೋಡೋಣ. ಮೇಡಮ್
For extension of interim.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅದೇ ನಾವು ಇಂಟ್ರಿಮ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದೆ ನೋಡಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
8 weeks ಅಂತ. September.
ಯಾವತ್ತು ಕೊಟ್ಟಿದೆ?
24/9/20.
The interim order granted on 24/9/2024 shall stand extended till the next date of hearing. Yes, next.
B group seal number 20.
That the petition was due of rupees 10 lakhs to the respondent. The check was withheld for the reason that he had not paid GST. Now the remaining amount, what GST we will pay.
Settlement.
Settlement.
The petitioner is 138 proceedings, sir.
138.
138. The petitioner is before this court seeking the following prayer. During the pendency of the petition, the parties to the list have arrived at a settlement and have filed an application seeking compounding of the offense. The affidavit appended to the application seeking compounding reads as follows. The said application is supported by affidavit of both the complainant and the petition and the accused. In the light of the offense being one punishable under 138 of the Negotiable Instruments Act, and the parties having settled the issue, I deem it appropriate to accept the application, close the crime against the petitioner for the aforesaid reasons, disposed, quashed.
It is.
Alone center, line haki madam. The learned counsel of the petition hands over a demand draft to the respondent of
2,90,000.
of 2,90,000.
92,900.
2,92,900 in full and final settlement. In full and final settlement, the same is acknowledged by the counsel representing the respondent. Amale allowed, disposed, quashed.
In terms of the compromise petition and birth.
In terms of the compromise.
Correct. Quashed in terms of the compromise. This. Ninth haki. What was not recalled there? ಅದು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಕಂಪನಿದು ಮಾಡಿದ್ವಲ್ಲ, ಅದಕ್ಕೇನು ಬೇಕಾಗಿರಲಿಲ್ಲ, ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಇಲ್ಲ, ಇದು ಕಂಪನಿ ಅಲ್ವಾ? ಇಲ್ಲ, ಇದರಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಇದೆ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್, ಅದರಲ್ಲಿ ಇರಲಿಲ್ಲ, ಅದು ಬರೀ ಕಂಪನಿ. ಎಸ್
21.
Petitioner, my lord, for a compromise, my lord, it is connected with 94 months.
Connected with
94 in the second list.
ಆಯ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು?
Council is there, my lord. Came from there only.
84 and
498. 94 and
serial number ಹೇಳಿ ಸರ್.
Second list, serial number 94, my lord. This in respect of in-law is concerned, my lord. So far as complaint is concerned.
ಸೀರಿಯಲ್ ನಂಬರ್ ಕೇಳಿದೆ, ಬೇರೆ ಕೇಳಿ.
94, my lord.
94 and this
21.
21 ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 94 ಫಸ್ಟ್ ಲಿಸ್ಟ್.
Second
The
list.
petitioners are before this court calling in questions so and so. During the pendency of the petition, the parties to the list have settled the dispute amongst themselves and have, by drawing up certain terms of settlement, in the light of the settlement arrived at between the parties, and the offense being the one punishable under section 498A, inter-alia, I deem it appropriate to accept the settlement and close the proceedings against the petitioners for the aforesaid reasons. Disposed, quashed. Eli settlement elide.
Yes, my lordship. I am filing my wakalat loan.
Adu separate order sheet on madi. Learned counsel so and so enters appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. Next.
Order sheet signatures.
Settlement ilidya. Okay. ಮೇಡಮ್ ಪೂರ್ತಿ ಹಾಕಕ್ ಹೋಗ್ಬೇಡಿ, ಫ್ಲಾಗ್ ಅಲ್ಲಿ ಹಾಕಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 3 ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ, ಅಷ್ಟು ಮಾತ್ರ ಸಾಕು. ಎಸ್. Settlement.
Parties are present, my lords.
89 ಜೊತೆಗೆ 89 and 6.
9, my lord. Serial number 9.
89 and 9.
9, my lords.
ಬರೀ 9. ಸರಿ. Offense ಏನು?
384, my lords.
Yes, Jagdish.
Both the parties are present.
Serial number 9. Madam, same drill. ಅದರಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇರುತ್ತೆ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ಗೆ, ಅದನ್ನ ಕೋಟ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ. ಎಸ್. ಡಿಸ್ಪೋಸ್ಡ್. ಅವ್ರೆ 4:15 ಹೇಳಿದ್ರೆ 5 ಗಂಟೆಗೆ ಮೇಡಮ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರ? ಕರೆದ್ಬಿಡಿ.
That's serial number 89.
89.
All the 4 cases, my lord, is already settled. Filing an wakalat on behalf of respondent number 2 is concerned, my lord, in all the.
ನಿಮ್ಮ ಫೈಲ್ ಅಲ್ಲಿ ಮೇಡಮ್? ಯಾ.
89.
ಎಸ್. ಅಫೆನ್ಸ್ ಏನು? 498 ಏನಾ?
All the four,
ಕೇಸ್ ಇದೆಯಾ?
ನಾಲ್ಕರಲ್ಲೂ ಇದೆ.
Receipt ready, madam.
The petitioners are with 498A format. ಆಗತ್ತಾ ಹೇಳ್ಬೇಕು? 498A format ಮಾಡ್ತೀರಾ? ಎಲ್ಲ ವೆಕೇಶನ್ ಬೆಂಚ್, ಎಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ವೆಕೇಶನ್ ಬೆಂಚ್ ಎಲ್ಲ ಅಂದ್ರೆ ವೆಕೇಶನಲ್ ಮಾಡ್ಕೊಂಡು ಕುಡಿತು. ಕಾಪಿ ಎಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
DD also it is.
ಅಲ್ಲೊಂದು ಲೈನ್ ಬರೀರಿ. The learned counsel for the petitioner has handed over a demand draft of
5 lakhs.
of 5 lakhs to the respondent. The counsel for the respondent acknowledges the same as so and so cost. ನಾಲ್ಕು ಸೆಟಲ್ಡಾ?
All the 4 cases.
ಅಲ್ಲಿ ಹರ್ಡ್ ಸೊ ಅಂಡ್ ಸೊ ಮೇಲ್ಗಡೆ ಹಾಕ್ಬಿಡಿ ಎಲ್ಲ. Yes, next.
91, past over 91. After vacation.
After vacation. ಇನ್ನೂ ಇದೆಯಾ?
30 more. Yes, Rajshekar.
Four not 6 and 420. The first petitioner was also the director of this compliant company. But this case has a checkered career. In fact, I was a compliant in the earlier complaint.
Why 230 ಮೂವ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ?
I'm sorry, madam.
230 ಮೂವ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ? ಅರ್ಜೆನ್ಸಿ.
Pulled by the council and record that they're attempting to seize and confiscate our properties and all that.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದು.
Properties and ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. Otherwise we would not have.
Yes.
ಆಮೇಲೆ ಇದರಲ್ಲಿ may I request you lordships to kindly turn to page 43 for a second, man. ಅಷ್ಟೇ just complaint ಅವರೇ ಹೇಳ್ತಾರೆ ಏನು ಅಂತ. ಅಫೆನ್ಸ್ ಆಗುತ್ತೆ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಅಷ್ಟೇ. 43. The present complaint is being filed for cheating by personation, breach of trust, etc. Proposed accused. It is pertinent to note that the conduct of the proposed accused also breaches various policies of the company, including but not limited to avoiding conflicts of interest and not indulging in bribery or illegal gratification of any kind. Paragraph 4. I am filing this present complaint upon the perusal of the aforementioned events. Even proposed accused has committed several grave serious offences which caused monetary loss, etc.
This is in 2017, 24.
ಇವತ್ತಲ್ಲ ಅದು.
2017.
7 years back. ಅದು ಕಿಕ್ ಬ್ಯಾಕ್ಸ್ ತಗೊಂಡ್ರು ಅಂತ ಅಷ್ಟೇ, ಅಷ್ಟು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನೇನಿಲ್ಲ. Kindly have a look at para 5 minute. Kick backs were received by the accused.
Accused number 1 and 2.
Yes, husband and wife. And husband has nothing to do with this.
Husband had nothing to do with the wife.
Husband.
With this.
Husband is no way connected to this institution. ಅವ್ರದ್ದು ಸೇರಿಸ್ಬಿಡೋದು ಅಷ್ಟೇ ಆಗ್ಲಿ. ಅಂಡ್ ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ ಮೋಟಿವ್ ಒಂದ್ ನಿಮಿಷ ತೋರಿಸ್ತೇನೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ದಿಸ್ ಮಿಲಾಟ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಟು ಪೇಜ್ 302. ಇದು ಮೋಟಿವ್. ಅಂಡ್ ಇದು ಕಂಪ್ಲೇಂಟು ವಿಜುವಲ್ ಬ್ಲೋಯರ್. He gives the petitioner a complaint. On the basis of what is said by the visual blower, this complaint is filed. Kindly turn to page 302 minute per second, only 1 minute, not more than 1 minute.
Yes, sir.
ಏನು ಅಂತಂದ್ರೆ now we are responsible for this ಅಂತ.
Yes, Jagdish.
Page number 44 ಅಲ್ಲಿ para 7 and 8. The tune of 38 crores has been siphoned off.
That is your allegation. ಇಂಟರ್ನಲ್ ಆಡಿಟ್ ಆಗ್ಬೇಕು, ಎಕ್ಸ್ಟರ್ನಲ್ ಆಡಿಟ್ ಆಗ್ಬೇಕು. 7 years ಆಡಿಟೇ ಮಾಡಿಲ್ವಾ ನೀವು? ಈಗ ಬರ್ತೀರಾ? Go to page 34, madam. KL. You are never interested in giving any complaint. You could not see any default. You could not see any action.
What's the impending urgency?
My lord, every day we are being secured before the police station. They are threatening of seizure of our bank accounts and all that. ಇವತ್ತಲ್ಲ ಇದಾಗಿರೋದು 7 years back ಇದು ಇವತ್ತು.
All right. Heard the learned senior counsel, C. V. Nagesh appearing for the petitioner. The learned additional SPP is directed to accept notice for the respondent. The learned counsel for the learned senior counsel takes this court through the complaint with particular reference to certain paragraphs which would.
Sorry for the interruption. ಇಲ್ಲಿದೆ visual blower complaint.
ಅದು ಹೇಳ್ತೇನೆ.
Page 34.
With particular reference to certain paragraphs where allegations of kickback received by the petitioners, allegedly received by the petitioners is projected. And the complaint is not by any person aggrieved, but a whistleblower who blows the whistle of such kickback, though for an offense, so and so.
The whistleblower informs the complainant.
Oh, with a complaint.
Based on that
Whistleblower.
With a complaint. On
blows
the basis of that, they would file a
blows
complaint.
the whistle of corruption to the complainant, and the complainant has then registered the complaint. The incidents
406
incidents range from 2017 to 2024. The matter would require certain consideration. List the matter on 6th January in the fresh matters list. Till such time, the respondents are restrained from precipitating the matter or taking any coercive steps.
And cooperate with the investigation.
Huh?
Let them cooperate.
Coercive steps. Ashtu sir.
We'll do it.
Yes. The petitioners, however, shall cooperate. Bail ತಗೊಂಡಿಲ್ಲ sir. The petitioners shall, however, cooperate with the investigation. And in the garb of investigation, no, ಹಿಂಗ್ ಬರ್ದ್ಬಿಡಿ madam. Petitioners shall cooperate with the investigation, and in the garb of investigation, no coercive steps shall be taken against the petitioners. Yes. Next.
Number 2, withdrawal memo.
In terms of the memo.
Bill number 3. Resha Karthikeyan, ready?
Petitioner. Second FIR, your worship was pleased to grant an interim order, but in respect of the co-accused, is yet not yet to be uploaded. WP 3362 of 24. Not the first
One HC, tag the petition along with
WP 3362 of 2024.
so and so. There shall be an interim order of stay as obtaining in the companion petition.
Please.
Yes, next. 1 HCGP, 2 additional SPP, 2 emergent notice.
Please.
Yes. Madam, ಎಲ್ಲದರಲ್ಲೂ office objections to be complied with by the next date.
Please.
Next.
4, Vivek Palla.
For the petitioner.
Purely civil dispute. Purely a civil dispute.
Purely civil dispute.
JDA between the petitioner and the complainant, my lord.
The petitioners are before this court calling in question registration.
Private complaint has been registered under.
Registration of refer ಆಗಿದೆಯಾ? So calling in question the registration of a crime in crime number 283 of 2024, which is registered on reference by the learned magistrate in PCR 4388 of 2024. A perusal at the complaint would indicate that a breach of a joint development agreement is sought to be dressed with a color of crime. Permitting further proceedings against these petitioners would run foul of the judgment of the apex court in the case of Vijay Kumar Ghai versus so-and-so 2022 7 SCC page 124. Therefore, there shall be an interim order of stay of further proceedings quay the petitioners till the next date of hearing. Further investigation quay the petitioners to the next date of hearing. Next. Sampreet.
There's already an order of stay in the co-accused writ petition, my lord.
Page
134 and 135.
Tag page 134. Tag along with that same order.
It was there today at.
Heard learned senior counsel ಅಂತ ಮಾಡಿ.
It was there today at serial number 41, the connected matter, but I think.
ಅದು hand delivery ಕೇಳಿದ್ರೆ ಅದೇನಾ ಇದು?
ಇಲ್ಲ.
Yes, so 41 ಜೊತೆ tag ಮಾಡಿ.
Tag
ಮಾಡಿ same order.
There's an interest.
Yes, next.
Voting settlement, last time.
307. And after vacation, password, yes. Jyoti Sharma.
Number 7, Jyoti Sharma. For settlement.
For settlement. Password, yes. Yes, I told Ravi Shankar sir.
One 104.
So what I'm asking is, let us collect the CCTV image, my lord, which where the transactions have
Collect
taken
it.
place. And those,
Let them collect. I will not. Collect the CCTV, everything will be,
yes.
everything will come to light. Yes. The learned.
Including the CCTVs of the police station itself, my lords. Because
Everything.
what we have stated is the checks.
Station, Prasanna Kumar sir idare idarli.
ಹೌದೌದು.
Oh, yes.
Second respond.
Collect ಮಾಡ್ಲಿ ಅದೇನ್ ತೊಂದ್ರೆ.
All CCTVs.
Yes.
The petitioners, the learned, heard the learned senior counsel, D.R. Ravi Shankar appearing for the petitioner, and the learned additional SPP and counsel P. Prasanna Kumar representing the respondent. This court on 3/12/2024 had passed the following order. In furtherance to the said order, following order, and on 17/12/2024, the following order. The issue revolves around certain dispute that has happened with regard to issuance of check or forcibly taking the check from the hands of the petitioners in the police station. Therefore, I deem it appropriate to direct the respondent state to secure the CCTV footage.
And the bank details.
Bank,
Bank transactions details.
one ನಿಮಿಷ. CCTV footage of the police station. ಇನ್ಯಾವ್ದು ಬೇಕು?
ಅಲ್ಲಲ್ಲ, CCTV police station at the bank where
ಒಂದು ನಿಮಿಷ. CCTV footage of the police station and that of the bank along with the transaction details of the bank by the next date of hearing.
Of the complainant.
Of both of you.
all
Yes.
of
Of all the parties to the list. ನಿಮ್ದು ತಗೊಂಡ್ಬಿಟ್ಟಾರ ಆಮೇಲೆ.
ಅದಕ್ಕೆ
ಜಗದೀಶ್
ಅಲ್ಲ ನಮಗ್ ತಗೊಂಡ್ರೆ ತೊಂದ್ರೆ ಇಲ್ಲ, ರವಿಶಂಕರ್ ಅವ್ರು ತಗೊಂಡ್ರೆ ತೊಂದ್ರೆ.
ಅದು ಕರೆಕ್ಟ್. ಇದು ದಿಸ್ ಇಸ್ ಕರೆಕ್ಟ್. ಅದು ಆಮೇಲೆ ಶಾಕ್ ಅಲ್ಲಿ ಏನೋ ಆಗ್ಬಿಡುತ್ತೆ. ಹೀಗೂ ಉಂಟೆ ಅಂತ ಅದನ್ನ ಹೇಳೋದು. ಎಸ್ ಸರ್.
Bank account details put. Please.
ಪೆಟಿಷನ್
Number 4 in the crime.
FR ನಂಬರ್ನ ಟ್ಯಾಗ್ ಮಾಡೋ ಪದ್ಧತಿ ಬಂದಿಲ್ಲ ಸರ್ ಇನ್ನು.
There is a direct by this court of the last period.
FR ನಂಬರ್ ಟ್ಯಾಗ್ ಮಾಡಕ್ ಹೇಳಿದೀನಿ ಸರ್.
With understanding that they will comply.
ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಟ್ಯಾಗ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ಅದೊಂದು ಶುರು ಮಾಡಿದ್ರೆ ಇನ್ ಆಲ್ FR ಲಿಸ್ಟ್ ಅಂತ ಒಂದು ಸಪರೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಇನ್ FR ಲಿಸ್ಟ್.
ನೆಕ್ಸ್ಟ್ ಫೈಲ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆನೆ ಎಂಟ್ರಿ ಮಾಡೋದು.
ಹೌದು ಕರೆಕ್ಟ್. ಇನ್ನೇನ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಒಂದು ಕೇಸ್.
I remember, my lords, of course, Honorable Mr. Justice Tilahari was there. That's when we had entered the bar. So I had an occasion where I had gone to move the memo. And he asked me what the matter is about. I started telling him, said, do you have the file? I said, all right, give me the file. As I could understand at that time, it was not even filed. So he took the file and then saw the file and said, all right, chalo, entry order de diya tumhe. So file ಆಗಿರಲಿಲ್ಲ, entry order ಆಗೋಗ್ಬಿಟ್ಟಿತ್ತು ನಮಗೆ.
ಅದೇ ಹಂಗಾಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ.
Lordship also has granted where the
ಫೈಲ್ ಇಸ್ಕೊಂಡ್ ಮಾಡಿದೀನಿ ನಾನು. ಬಿಕಾಸ್ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇದೆ ಅಂದ್ಮೇಲೆ ಐ ಶುಡ್ ನಾಟ್ ಬಿ ಮೇಕಿಂಗ್ ದಮ್ ವೇಟ್ ಅಂತ ಅಷ್ಟೇನೆ ಮಾಡೋದು. ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಅದೇನು ಅವ್ರ ಫೈಲ್ ಇಲ್ದೇ ಇರೋದು ನಮ್ಮ ಫೈಲ್ ಇರುತ್ತೆ ಸೇಮ್ ತಾನೆ ಅಂತ.
Great.
After vacation.
Interim order, my lords. Otherwise, the interim order shall.
Interim order will continue. Interim order.
subject to this matter.
ಅಲ್ಲ, subject to the aforesaid, the interim order granted on interim order granted on 3/12/2024 shall continue. ಯಾವ್ದಿದು? FR ನಂಬರ್ ಬಾಲಕೃಷ್ಣ ಅವ್ರದ್ದು ನಿಮ್ದೊಂದು ಇದೆಯಾ?
ಇನ್ನೊಂದು
ಹಾ ಹೇಳಿ.
ಏನಿಲ್ಲ
ಇನ್ನು
ಅದು.
ಬರ್ತಾ ಇದೆ ಅಂತೆ ಕೊಡಿ.
ಆಯ್ತು. It's offense under 9B2 of the Explosives Act.
ತೊಗೊಳ್ಳಿ. Yes, in the meantime.
Please.
ಎಕ್ಸ್ಪ್ಲೋಸಿವ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಯಾವತ್ತೂ ಫಾಲೋ ಮಾಡಲ್ಲ ಪ್ರೊಸೀಜರ್. ಎಸ್, ಅದಕ್ಕೆ ಅದು ಫೈಲು ನೋಡಲಿಲ್ಲ.
ಆಯ್ತು.
ಇಟ್ ಇಸ್ ಡೀಮ್ಡ್ ದಟ್ ಯು ವಿಲ್ ನಾಟ್ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್.
ಅದೇನ್ ಬೇಕು ಅಂತ ಮಾಡ್ತಾರೆ.
ಅದರಲ್ಲಿ ಮೇಡಮ್ ಅಡಿಷನಲ್ SPP is directed to accept notice for the respondent. There shall be an interim, heard the learned senior counsel ಅಂತ ಹೇಳಿ. There shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing, list on 8 January.
Please, Milord.
Yes. In ಯಾವ್ದು ಪಾರ್ಟ್ ಹೇಳಿಲ್ಲ? ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಪಾಸ್ವರ್ಡ್? ಇದೊಂದು ಇತ್ತಲ್ಲ ಮೇಡಮ್, ಇನ್ನು ಪಾರ್ಟ್ ಇರೋದು ಯಾವುದು? 2:30ಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರ ಅದು ಬಿಟ್ಟು ನೆನ್ನೆದ್ ಬಿಟ್ಟು ಇನ್ಯಾವುದು? ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಯಾವ್ದು? ಎಲ್ಲ ಮುಗೀತು, ಅದು ಗೊತ್ತಾಯ್ತು. ಅದು ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್
List number 1. Further hearing at 4 PM, 41.
ಪ್ರವೀಣ್ ಗೌಡ್ರು ಇದ್ದಾರಾ?
Lord,
ಹಾ,
humble submission is requires some time. Majorly, it's more than a fact, it's a question of law. They have said, especially on the ground 26, 27, 34, where they have said with respect to the sanction. So I should get well prepared and
well prepared. You're a formidable opponent. So you have to
last
keep-
week, I received this entire petition, my lord.
ಆಯ್ತು.
So I also should take some instructions.
Yes, Sangat, let him have
Date may be
time.
fixed. However, they have been the interim order in there.
ಗೊತ್ತಾಯ್ತು. Yes, it's a detailed entry.
I'm sorry about it.
Another copy of citations on my friend.
Ah,
So on the
ಕೊಟ್ಬಿಡಿ.
next date, he may prepare
Yes,
attached submission.
the learned counsel Praveen Gowda, representing the first respondent, who is to answer the prayer that is sought in the petition, seeks 2 weeks' time
Please.
to file statement of objections and get prepared in the matter. The learned counsel for the petitioner Angad Kamath has handed over the memo of citations to the respondent counsel. Therefore, next hearing al mugisbodna.
Please, ma'am.
There, list this matter on, we'll take it on 16th.
That works.
Yes, list the matter on 16th for further hearing at 2:30 PM.
Okay.
Yes.
Grateful.
Yes.
That's all.
Interim order may be.
Interim order stands extended till the next date. Praveen Godre, ready ag banbidi. Some legal issues projected.
Please, my lord, just going through it with
Yes,
respect to the sanction.
My interim order projects everything,
Please.
captures everything rather.
Please.
ಯಾವ್ದು madam?
Number 30, no, second.
30. ಯಾವ್ದು ಕರೀರಿ?
Second is 30 minutes.
30.
30.
Happy for the respond number.
Shrim,
Strip matter.
yes, yes, sir.
Lord, sir. I draw the attention of this honorable court to the complaint, my lord, sir, which has been filed. The complaint itself categorically states that, my lord, sir, the procedure of business practice that had been adopted by the complainant as well as the petitioner in this case was that a order used to be placed, order was delivered, GRN used to be delivered to the petitioner as well as the other party, and the amount used to be paid by the respondent to the petitioner, and later it would be recovered from the ultimate customer, my lords. This was the practice. Now the GRNs have been issued. What is mentioned in the complaint is that, my lords, this GRN itself was not appropriately issued, and it was issued at the instance of an officer of the company who had to pay me. This is the ground on which, my lords, a complaint came to be filed. On the very same ground, my lords, in the month of June, again, before the Visakhapatnam court, police, my
You
lords.
said you will seek
I saw,
instructions.
my lord, this complaint that has been filed is by my end customer against his employee and them to say that there is collusion
Same
going on
offense.
there. I am not
Same
even a
offense.
party to it.
I don't know what the issue over there is, but I'm not a party to those proceedings.
Same offense, my lords. Same offense. For the same transaction.
You're a complainant,
You are a complainant. Allah. Complainant is one Nekanti who says that on the basis of whom they are claiming, my lords. Now, the question here is that, my lords.
The question here is, where is the shrimp?
Shrimp has been delivered, my lords, to my
Delivered.
instructions. Shrimp has been delivered, therefore GRN
Delivered
has
and
been issued.
eaten also.
No, my lords, shrimp has been delivered, therefore GRN has been issued, my lords. Subsequent to the issuance of GRN only, my payment was released. Not before. And it is a continuous transaction to be noted, my lord. Since from January 2023 itself, this transaction has been in vogue. And there have been so many consignments, my lords, without any dispute, my lords, it has gone through. And this consignment, my lords, which was delivered in the month of May, the payment was made in the month of January. FIR comes to be registered in the month of, after a delay of 6 months from the date of payment, my lords. Now, it is a purely civil transaction, even if you have viewed otherwise, my lords. If they have a claim over me saying that I have not delivered the shrimps appropriately, my lords, the GRNs have been issued, it would speak to the other way round, that I have delivered it. Therefore, the GRNs have been issued. And it is also admitted fact that GRNs has not been issued by a third party, my lords. It has been admittedly issued by the officer of the end customer being Nekanti. Any claim would be there, my lords, that would be against the company called Nekanti, but not me. And under 177, my lords, it categorically
Against
states.
that company, you have not registered any crime.
No, they don't do it.
Country or something.
No, my lord, we have not. The complaint that we have filed today is against the employee as well as the supplier. Now, I cannot make my end customer prove a negative. I can't ask him to come and say, show me how you've not received the goods. The email that they're relying on.
They one sentence ಕೇಳಿ.
Then, my lord, sir. Section 177 categorically of CRPC states that offense has to be registered where it has happened. Now, my lords, this offense, admittedly, even as per the complaint as well as the FIR, has happened at Visakhapatnam, my lords. It has got no jurisdiction and not even a scrap piece of transaction has taken place at Bangalore. They register a case against me.
All.
And try to strong arm.
Yes, madam.
My lord, the document.
First thing is, everything has happened Vizag.
Please.
And you have registered a crime here.
Please.
You justify how you registered a crime here.
My lord, for this.
The company is in Bangalore.
Please, my lord.
The company is in Bangalore.
We are in Bangalore, my lord. The money has gone from our account to their account in Visakhapatnam, 10 crores. Now the
10 crores.
10 crores. Now what they're relying on is an email that has been sent by the employee of our end customer. The end customer, when we made a demand, there was nothing forthcoming. We
Now
issued a
you supply shrimp through that customer, through him to the end customer.
Yes, that is the
Now
arrangement,
you
my
have
lord.
supplied it to him.
No, my lord, the transaction, how it is we have an arrangement with the petitioner. We place a purchase order on them based on the request made by our end customer. The petitioner directly supplies the shrimp to our end customer. They confirm receipt via email. Once that receipt is given to us, we release the funds over here. What has happened in this particular transaction? We've admittedly, yes, we've had repeated transactions since the beginning of January. This particular transaction, when the email was sent to us saying that, yes, we've received the goods from that employee, we released 10 crores to them. Thereafter, when we raised our invoice on our end customer to receive payment after we paid them, the managing director informed us that there was no such goods received. Now, when we contacted them to say, show us the receipt, this is 10 crores worth of shrimp, my lord. It has to have reached them some way. Consignment orders, trucks, anything. Give us that document, we will go after end customer for payment. Till now, even before this honorable court, there is nothing to show that this product has been delivered except the email by the employee, who the very next day has said at the behest of the petitioner, I was forced to issue this GRN. So today we are out of pocket 10 crores. We don't know where these goods are. We are stuck before this.
One more point to be noted here, my lord, sir. That even as per the complaint, they themselves admit that the confirmation of the transaction happens by issuance of GRN, and that is the only transaction. I draw the attention of this honorable court to paragraph number 5 of the complaint, my lords, page number 27. They say that to fulfill the contract with Nekanti, Ninja placed various orders to supply shrimp to accused, who was required to deliver the same to Nekanti. In turn, accused number 2 issued GRNs to the Ninja Cart confirming receipt of the shrimp on behalf of Nekanti. Thereafter, Ninja Cart raised its invoices to Nekanti, and these invoices were cleared by Nekanti from time to time. This is all matters.
All right. Heard the learned counsel appearing for the petitioner and the counsel representing the
Respondent number 3.
Your name or?
My name.
Sanjana.
Sanjana.
So and so. The issue in the list is quote unquote, where is this shrimp? It is neither delivered nor digested. Judgment reserved. Yes. Next.
One additional point here, my lords, is that except this DRN, as per the business transaction, there was no other document to be maintained. by the parties.
For my convenience, I have said that. Don't worry.
GRN says that it has been delivered.
Our only submission to this point is, my lord, that while an email has come forward to say they have received.
Reserve
the-
why, Salaman?
Please,
Reserve why?
And I was just confirming, he had made a point, so I just wanted to
Don't-
clarify.
Yes.
Please.
ಉಳಿದಿರೋದೇನ 5 o'clock sharp. ಯಾವ್ದು DSG ಎಲ್ಲಿದ್ದಾರೆ? 53 ಶಾಂತಿ ಭೂಷಣ್ ಇದ್ರಲ್ಲ ಅಲ್ಲಿ. ಶಾಂತಿ ಭೂಷಣ್ ಕರೀರಿ, ಇಲ್ಲೇ ಇದ್ದಾರೆ. ರಮಣಿ ಮೇಡಮ್, ಈ ಮ್ಯಾಟ್ರ್ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಒಂದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ತಗೊಂತೇನೆ, ನೀವು ಹೊರಡ್ತೀರಿ. ಪಕ್ಕದ ಕೋರ್ಟ್ಲಿದಾರ? ಆನ್ ಇಸ್ ಲೆಗ್ಸ್?
ಬರ್ತೀನಿ ಅಂತ ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಇರ್ತೀನಿ, ಫೋನ್ ಮಾಡಿ ಅಂತ ಕಾಲ್ ಮಾಡ್ತೀನಿ, ಕಲಿ ಕಾಲ್ ಮಾಡಿ.
ಎಸ್ ಸಂದೀಪ್ ಪಾಟ್ ಸೀನಿಯರ್ ಇದಾರ? ಇದಾರ ಅಂತ ತಗೊಂತೀನಿ ಆಮೇಲೆ ತಗೊಂತೀನಿ.
ಕೊಡಮ್ಮ.
ಫೈಲ್ ಕೊಡಿ.
ಕೇಳ್ತಾರ. ಶುರು ಮಾಡಿ ಫಸ್ಟ್
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಸ್.
ಪ್ಲೀಸ್. Ready.
Yes.
But yesterday, your lordship wanted me to examine whether 161 statements recorded by the investigator could be made use of by the accused when he invokes the jurisdiction of the court under 482 seeking quashing of the charge, the FIR and the order of issuance of process. But in the Supreme Court, my lord, is speaking through Honorable Justice, say in one sentence, statement under section 161 cannot be looked into is the observation. But earlier judgments and later judgments subsequent to that 2020, my lord, I have been able to lay my hands upon it. Straight away, I can invite my lord's kind attention to more than one judgment on the point. Before I take your lordship to those judgments, my lord, let me submit your lordship one thing. Please do not mistake me that I am going to the fundamentals. Please do not mistake me.
No, that's all right. So what?
Lord, your lordship is certainly aware of all these things.
Sir,
But,
no, sir, that's not there. Sometimes we may also fumble on fundamentals. Yes.
My lord, the court would take cognizance under section 190. It leaves no doubt. Your lordship has ruled in several cases. If it is a private complaint, my lord, it would be under 190, 1A. Well, if it is a police report under 190, 1B. If it is on any other information which the court would get, it would be under 190, 1C. Well, now in this present case, we are only concerned with the court taking cognizance of an offence under section 190, 1B because it is on the basis of a police report it has been given. Well, may I just request your lordship to just refresh my lord's memory. Have a look at under section 2R of this. In fact, your lordship has referred to it in the umpteen number of cases. Well, have a look at section 2R first.
Yes.
Well, what is police report?
Yeah.
Well, 190, 1B refers to the court taking cognizance on a police report.
Yes.
Have a look at police report as defined under section 2R of the CRPC. Police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173.
Yes.
It is on the basis of this report, my lord, the trial court would take cognizance of the offence, whatever may be the offence. We are
Yes.
not on that issue now. Well, now may I request your lordship to kindly go to 173 subclause 2. Have a look at 173 subclause 2. Well, 173 subclause 2 would say every investigation under this chapter shall be completed without unnecessary delay. Subclause 1A, the investigation, we are not concerned with that, 376 and all that. Now subclause 2. As soon as it is completed, the report of police officer and completion of investigation. This is a police report that is defined under section 2R, 173 subclause 2. As soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government stating, number 1, the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case, whether the offence appears to have been committed and if so, by whom, whether the accused has been arrested, whether he has been released on his bond, whether he has been forwarded in custody, whether they report medical examination, etc. But the police report as mandated under section 173(2) should contain all these things, including the statements of witnesses who are acquainted with the facts of the case. Well, it is on the basis of the police report that is found under section 173(2) of the code, the magistrate would take cognizance. So for the purpose of taking cognizance, indeed, the magistrate is bound to advert to the evidence which the investigator had collected, which are enumerated under section 173(2) of the CRPC, without which he could not have taken cognizance of the offence at all. 161 statement or the statement that is recorded under section 161, statement that is recorded under section 164, would form part of the police report as defined under 2R for the purpose of taking cognizance of the offence would be my first respectful submission. But without which he can't look into it at all. Without which he can't make out whether an offence has been made out or not. Well, then kindly imagine the situation, Miller. He files a charge sheet. Well, a charge sheet contains the statements of witnesses, be it under 161, be it under 164, in addition to other documents you should be collecting. But in order to seek the benefit of an order of discharge, or the prosecution to seek the benefit of an order directing framing of charges against the accused, but he has got to advert to the police report and the record of the case, be it under section 227 or under section 239. 239 refers to the cases traveled by a magistrate, and 227 refers to the cases traveled by the Court of Sessions. What needs to be seen for the purpose of either framing of charges or for the purpose of passing an order of discharge, my lord, is the record of the case, which includes all these things, a police report. My lord, this 161 forms part of the police report, but the magistrate could look into it for the purpose of proceeding to frame a charge or passing an order of discharge. If the Sessions Court is entitled to look into it, can we say or can we contend, can the prosecution contend that this honorable court in exercise of its jurisdiction under 482 cannot look into the police report, which includes the statements of witnesses recorded under section 161 of the CRPC? Well, it is only on the basis of the statements of witnesses recorded, it would become possible for the investigator to formulate an opinion with regard to the commission of the offense or not, so that the accused is sent before the court to take his trial in the case. Well, and now, may I invite my lord's kind attention to the judgment of the Supreme Court in 1983 Supreme Court cases 152 paragraph. Our ಕೊಟ್ಟಿದ್ದೀರಾ copy? Professor, have you received the copy? ಕೊಡಿ ಅವ್ರು ಕೊಡಿ. One copy. May I request your lordship to kindly turn to paragraph 5, which your lordship would find at page 195. This was under Essential Commodities Act.
Ink page 195.
Ink page 195. Well, it commences at 192. Kindly go to ink page 195, paragraph 5. My lord, since this is an important legal issue,
Yes.
which my lord wanted some clarification, that is why, my lord, I am dealing with it at length. Section 10A of the Act provides that notwithstanding anything contained in the Code of Criminal Procedure 1973, every offense punishable under the Act shall be cognizable, which would imply that an officer in charge of a police station, on receipt of the information of such cognizable offense, may, without the order of a magistrate, investigate into the offense according to the procedure prescribed in Chapter 12 of the Code. On completion of investigation, it commences from section 154, 155, 156, and all that. On completion of the investigation, the police officer shall submit a report to the magistrate empowered to take cognizance of the offense on a police report. The report has to be in the prescribed form, and the details to be mentioned in the report are specified in section 173(2). While submitting this report in connection with the offense to which section 170 of the code applies, meaning thereby that a case in which such investigating officer has found sufficient evidence for a trial to be held by the court, it is incumbent upon such officer to forward to the magistrate, along with his report, A, all documents or relevant extracts thereof, and with the prosecution proposes to relay, other than those already sent to the magistrate during investigation, and B, mark this, my lord, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as the witnesses. My lord, this police report, the statements of the witnesses you would have recorded during the course of the investigation forms part of the police report. Now, may I request your lordship to kindly turn to paragraph 9 at ink page 198. My lord gets it?
Yes.
Section 173(2)(1) provides that on completion of the investigation, the police officer investigating a cognizable offense shall submit a report in the form prescribed by the state government, stating therein the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case. That is the statements of witnesses under 161. Whether any offense appears to have been committed, and if so, by whom, whether the accused has been arrested, whether he has been released on his bond, and if so, whether with what sureties, whether he has been forwarded in custody under section 170, subsection 5, section 173, makes it obligatory or relevant extract thereof, and with the prosecution proposes to delay and, mark this, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as witnesses at the trial. Well, this forms part of the report of the investigator as found under section 191B as well as under section 173 to be made. Now kindly read the next paragraph, my lord. Section 173(2) thus provides what the report in the prescribed form should contain. In this case, the report did contain the name of the accused and the nature of the offense. In fact, section 170 provides that if upon an investigation under chapter 12, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground to proceed against the accused, such officer shall forward the accused in custody to a magistrate empowered to take cognizance of the offense upon a police report. If the accused is on bail, that fact will be notified in the final report submitted under section 173(2). Therefore, the statutory requirement of the report under section 173(2) would be complied with if the various details therein prescribed are included in the report. This report is an intimation to the magistrate that upon investigation into a cognizable offense, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offense and necessary information is being sent to the court. In fact, the report under section 179(2) purports to be an opinion of the investigating officer that as far as he is concerned, he has been able to procure sufficient evidence for trial of the accused by the court. And when he states in the report that not only the names of the accused, but names of witnesses, the nature of offense, and a request that the case be tried, there is compliance with section 173(2). The report as envisaged by section 173(2) has to be accompanied as required with subsection 5 by all the documents and statements of witnesses therein mentioned. The result of the opinion which he formulates is the one that your lordship would find in column number 17 of the pro forma charge sheet. That opinion, my lord, is based on the evidence which he would have collected during the course of the investigation of the crime. For this court to find out whether the opinion which he has given as found in column number 17 of the pro forma charge sheet, is it correct? Is it wrong? Is it right? Is it acceptable or not? What needs to be seen is the evidence which he has collected. But that would be my submission. Well, now let us go to the next sentence, my lord. One cannot divorce the details which the report must contain as required by subsection 5 from its accomplishments which are required to be submitted under subsection 5. The whole of it is submitted as a report to the court. Well, I think the rest of the things we can skip. This would be my first submission. Well, now may I request your lordship to kindly turn to the case in 1954, volume 2, Supreme Court cases 934, which your lordship would get at ink page 211. May I request your lordship to kindly turn to paragraph 8, my lord, at page 227. My lord gets it?
Yes.
Thus, under the code, investigation consists generally of the following steps: proceeding to the spot, ascertainment of facts and circumstances of the case, discovery and arrest of the suspected offender, collection of evidence relating to the commission of the offense, which may consist of the examination of various persons, including the accused, and the reduction of their statements into writing if the officer thinks fit. Well, that is the only thing that is relevant for the purpose of this case. Well, therefore, my respectful submission to your lordship is a combined reading of the provisions of section 2R, 173 subclause 2, and the law laid down by the apex court in more than one judgment, my lord, would give us an indication that the statements the investigator during the course of the investigation of the crime should collect evidence. He would be collecting evidence by recording the statements of witnesses who are acquainted with the facts of the case. And those statements that are recorded, be it under 161 or under 164 of the CRPC, would form part of the record of the case in as much as it becomes part of the final report which he would be filing. And the opinion which he would be arriving at is based on the evidence which he would have collected. And that is the one that is found under column number 17. And that opinion is put into test. But your lordship would be examining whether that opinion is right or wrong on the basis of the evidence which he had collected. Therefore, my lord, I am required to invite my lord's kind attention to the evidence which the investigator has collected, since I had sought for the quashing of the charge sheet in this case. Yes. What do you Cyber Gutta? Wayne's case, my lord.
Conclusion can be ensured.
That's what I submitted. Yes, no, Pera? Well, ultimately, I'm sorry.
Yes, sir.
Well, ultimately, my lord, your lordship could certainly eschew the opinion of the investigator in the event that the investigator has come to a wrong conclusion or a wrong opinion after examining the evidence which he has collected. Well, that is what the Supreme Court has said in Bain's case. Well, your lordship may kindly turn to page 202, ink page 202. This is in 1980, volume 4, Supreme Court cases, 631. May I request your lordship to kindly turn to ink page 200, paragraph 6. It is seen from the provisions to which we have referred to in the preceding paragraph that on receipt of a complaint, the magistrate has several courses open to him. He may take cognizance of the offence and proceed to record the statement. So the complainant and the witnesses present under section 200. Thereafter, in his opinion, if in his opinion, there is no sufficient ground for proceeding, he may dismiss the complaint under section 203. If in his opinions there is sufficient ground for proceeding, he may issue process under section 204. However, if he thinks fit, he may postpone the issuance of process and either inquire into the case himself or direct an investigation to be made by a police officer or such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. He may then issue process if in his opinion there is sufficient ground for proceeding or dismiss the complaint. If there is no sufficient ground for proceeding, on the other hand, in the first instance, on receipt of a complaint, the magistrate may, instead of taking cognizance of the offence, order an investigation under 156(3). The police will then investigate and submit a report under section 173(1). On receiving the police report, the magistrate may take cognizance of the offence under section 191(b) and straightaway issue process. This he may do irrespective of the view expressed by the police in the report, whether an offence has been made out or not. The police report under section 173 will contain the facts discovered or unearthed by the police and the conclusions drawn by the police therefrom. The magistrate is not bound by the conclusions drawn by the police, and he may decide to issue process even if the police recommend that there is no sufficient ground for proceeding further. The magistrate, after receiving the police report, may, without issuing process or dropping the proceedings, decide to take cognizance of the offence on the basis of the complaint originally submitted. So it is not incumbent for the court, my lord, to accept the opinion which the investigator would have expressed in column number 17, which in his wisdom is based upon the evidence which he would have collected. May I now request your lordship to kindly go to paragraph 7. In Abhinandan Jha's case, what the Supreme Court has said, your lordship would get it. Paragraph 7. In Abhinandan Jha, the question arose whether a magistrate 173(1) had been submitted to the effect that no case had been made out against the accused could direct the police to file a charge sheet on his disagreeing with the report submitted by the police. This court held that the magistrate had no jurisdiction to direct the police to submit a charge sheet. It was open to the magistrate to agree or disagree with the police report. We agreed with the report that there was no case made out for issuing process to the accused. He might accept the report and close the proceedings. If he came to the conclusion that further investigation was necessary, he might make an order to that effect under section 156 subclause 3. If ultimately the magistrate was of the opinion that the facts set out in the police report constituted an offense, he could take cognizance of the offense, notwithstanding the contrary opinion of the police expressed in the report. He can certainly, I would rather say, reject the opinion which came to be expressed and take cognizance of the offense. Therefore, my respectful submission to your lordship is the police report is the one that is submitted under 173(2) of the CRPC. That report should contain, my lord, the statements of witnesses recorded under section 161 or under section 164. But it is indeed for the, not only for the purpose of taking cognizance of the offense, but also for the purpose of issuance of process against the accused, as well as for the purpose of consideration of the request of the accused for an order of discharge or the request of the prosecution to proceed to frame a charge if the magistrate is indeed required to examine the record of the case, the evidence collected by the investigator, but the prosecution cannot contend before your lordship that the statements recorded by the investigator under 161 cannot be adverted to, would be my respectful submission. Well, may now invite your lordship's kind attention to the first judgment to the Supreme Court, and then I shall take your lordship to the latest judgment of the Supreme Court, which is subsequent to 2020. Well, the first judgment of the Supreme Court on this point is that is in 2013, Rajiv Thapar's case. I'm sorry. Rajiv Thapar's case. May I request your lordship to kindly turn to paragraph 29. Kindly go to paragraph 29. Yes. This Rajiv Thapar is in 2013, volume 3, Supreme Court cases 330. Kindly go to paragraph 29 and onwards. Kindly permit me to take your lordship first to paragraph 29. Yes. Well, this was under 482. Yes, sir. That is after the charge sheet. Quashing of the charge sheet. Yes. The issue being examined in the instant case is the jurisdiction of the High Court under section 482 of CRPC. Yes. Page 250. Yes. I'm sorry. The issue being examined in the instant case is the jurisdiction of the High Court under section 482 CRPC. If it chooses to quash the initiation of the prosecution against an accused at the stage of issuing process or at the stage of committal or even at the stage of framing of charges. These are all stages before the commencement of the actual trial. The same parameters would naturally be available for later stages as well. The power vested in the High Court under section 482 of CRPC at the stages referred to here and above would have far-reaching consequences, and as much as it would negate the prosecution/complainant's case without allowing the prosecution complainant to lead evidence. Such a determination must always be rendered with caution, care, and circumspection. To invoke its inherent jurisdiction under section 482 CRPC, the High Court has to fully satisfy that the material produced by the accused is such that would lead to the conclusion that his/their defense is based on sound, reasonable, and indubitable facts. The material produced is such as would rule out and displace the assertions contained in the charges leveled against the accused. and the material produced is such as would clearly reject and overrule the veracity of the allegations contained in the acquisitions leveled by the prosecution/complainant. It should be sufficient to rule out, reject, and discard the acquisitions leveled by the prosecution complainant without the necessity of recording any evidence. For this, the material relied upon by the defense should not have been refuted, or alternatively cannot be justifiably be refuted, being material of sterling and impeccable quality. The material relied upon by the accused should be such as would persuade a reasonable person to dismiss and condemn the actual basis of the acquisitions as false. In such a situation, the judicial conscience of the High Court would persuade it to exercise its power under Section 482 of the CRPC to quash such criminal proceedings, for that would prevent abuse of process of the court and secure the ends of justice. But the material on which I am placing reliance is the one which the investigator himself has collected. It is not that I am producing some other evidence. Based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of the prayer for quashment raised by the accused by invoking the power vested in the High Court under Section 482. Well, step 1, whether the material relied upon by the accused is sound, reasonable, and indubitable, that is, the material is of sterling and impeccable quality. Step 2, whether the material relied upon by the accused would rule out the assertions contained in the charges leveled against the accused, that is, the material is sufficient to reject and overrule the factual assertions contained in the complaint, that is, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the acquisitions as false. Step 3, whether the material relied upon by the accused has not been refuted by the prosecution/complainant, because they can't refute it. That is the evidence of the material which they have collected during the course of the investigation of the crime. It is their material and it is not my material actually. And the material is such that it can't be justifiably refuted by the prosecution. Step 4, whether proceeding with the trial would result in an abuse of process of court and would not serve the ends of justice. If the answer to all these steps is in the affirmative, the judicial conscience of the High Court should persuade it to quash such criminal proceedings in exercise of the power vested in it under Section 482 of the CRPC. Such exercise of power, besides doing justice to the accused, would save precious court time, which would otherwise be wasted in holding such a trial, as well as proceedings arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. But at this judgment, the law laid down by the Supreme Court in this Rajiv Thapar's case came to be followed in the subsequent judgment of the Supreme Court. Well, at that your lordship would get, in the case of Haji Iqbal, this is in 2023, and subsequent to this 2020. 2023, SEC Online, SC 946, Haji Iqbal alias Bala. Well, may I request your lordship to kindly turn to page 287 of my compilation. Kindly go to para 8 and 50. I'm sorry.
We will continue, right? We have the consent to continue.
Well, it will take some time.
No, that's all right. If you have the consent to continue of all the parties, I will continue. Otherwise, sometimes what is happening in the court and
For the day, my lord, if my lord
no
permits,
problem. I have no problem.
I will stop.
Even if it is 6:30, I have no problem.
ನಾವು ಬೆಳಗ್ಗೆಯಿಂದ
But ಅದು ಪರವಾಗಿಲ್ಲ. ಇಲ್ಲಿ ನಮ್ದು ಬಿಟ್ಬಿಡಿ. ಆಮೇಲೆ undue interest ತೋರಿಸಿದ್ರೆ after 4:45
Your lordship may have it on some other day.
No, consent ಇದ್ರೆ I will continue.
ನಾನು ಆಗೋದಿಲ್ಲ. ಇನ್ನು ಸಿಕ್ಕಾಪಟ್ಟೆ it takes a lot of time, my lord.
ನೀವು ಹೇಳಿ.
Because my lord has raised an important and serious legal issue.
No problem, but you continue.
Then I have to take your lordship to the facts. Because yesterday, abruptly I stopped it because of your lordship wanted some clarification on the legal issue.
No, I have no problem to sit even up to 9 o'clock, provided you have no problem and all of you have consent to it.
Your lordship may have it on some other day.
No, continue ಮಾಡಿ. ಹಂಗೇನಿಲ್ಲ. I'm not saying I will stop.
No, I am requesting your lordship.
tomorrow it should not be said that I have
No, no,
sat
I am
beyond
request-
court hours. and
I am
taken
requesting your
this matter,
lordship to,
shown undue interest to this, not all that. That is why.
ನಾಳೆ ಮಾಡುವ?
ನಾಳೆ ಬೆಂಚ್ ಇದೆ, I doubt.
Immediately after vacation.
ನಾಳೆ ಬೆಂಚ್ ಇದೆ.
ಗೊತ್ತು.
I don't know.
ನೋಡಿದನು. Immediately after vacation. Any day that suits my lawyer friends, your lordship's convenience and my lawyer friend's convenience. It takes some time, my lord. In fact, my lawyer friend, Mr. Balan, also wants about 1 hour's time. And, alva, the special prosecutor also wanted about 40. ಅದಕ್ಕೋಸ್ಕರ
They consider only the state. not
ನಾನು ಹೇಳಿದೆ ಸರ್,
the team.
ಕೊಡಿ ಅಂತ ಕೊಡಿಸ್ತೀನಿ
ಕೊಡೋದೇ
ಸರ್.
ಇಲ್ಲ ಅವ್ರು.
ನಾನು ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ ಸರ್. ವೈ ತಗೊಳ್ಳಿ ಸರ್, ಅಂದೇ ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ ಸರ್.
ಇಲ್ಲ ಕೊಡೋದಿಲ್ಲ, ಕೇಳಿದ್ರೇನು ಕೊಡಲ್ಲ ಅವ್ರು.
ಕೊಡ್ತೀವಿ ಬಿಡಿ ಸರ್, ಡೋಂಟ್ ವರಿ ಸರ್. That is not quarrel and small. You take it from me, I will give you.
Sure.
Your
And we
lordship,
will have it on the 6th,
Ah,
reopening day.
please, please,
Because tomorrow bench ಇದೆ, I don't know about single sitting.
please. Let-
Heard the learned senior counsel, Shri C.V. Nagesh, appearing for the petitioner. The matter was in fact heard yesterday at length and is continued today. Again, the parties are heard at length. The learned senior counsel C.V. Nagesh submits that he would require another, how much time?
Minimum 1 hour.
Would require another 60 minutes to minimum 60 minutes to complete his
So Balan
submission.
also wants.
The learned.
Only 1 hour, ತಮ್ದು 1 more hour.
Learned counsel, Balan appear, sorry, B. Balan, alla?
Yes, Bala.
Yes, Balan appear, Balana, Balakrishnan.
Full name Bala.
Full name ನಾವು ಪ್ರೀತಿಯಾಗಿ ಕರೆಯೋದು ಬಾಲನ್ ಅಂತ. Because, we are
Balakrishnan
practicing in the
seeks,
magistrate court together.
Also, would
Joseph
also
office
submit,
ಅಲ್ಲಿ ಇದ್ದಾಗ.
madam,
ಅಲ್ವೇ?
would also submit that he would require an hour's time. The special public prosecutor also would, he would require 1 hour.
All depends.
Would also require 60 minutes to refute the submissions of the learned senior counsel, C.V. Nagesh. Due to paucity of time and the ensuing winter vacation, the matter is directed to be listed on 6th January 2024 at 2:30 p.m.
25.
No, it's 2025
ಹೊಸ ವರ್ಷಕ್ಕೆ ಬಂದ್ಬಿಡ್ತೀವಿ.
at 2:30 p.m.
Please.
Interim order of any kind subsisting as on today shall continue till the next date of hearing in the light of the fact that the matter is being heard at large. Yes.
Please.
Reopening day ಬದಲು next day.
It's 7th, no problem.
7.
7th at 2:30 p.m.
ಯಾವತ್ತು ಅನುಕೂಲ ಆಗುತ್ತೋ ಅವತ್ತು.
Yes,
2:30.
2:30.
Please, oblige, deeply obliged.
ಅವ್ರು ತಗೊಂಡ್ಬಿಡಿ ಮೇಡಮ್. ವೀರಭದ್ರ ನಿಮ್ದು ಯಾವ್ದು?
ಇಲ್ಲ, ರಾಜಗೋಪಾಲ್ ಆಫೀಸ್.
ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಬೆಳಗ್ಗೆ ರಾಜಗೋಪಾಲ್ ಆಫೀಸ್ ನಾವು ಮೂವ್ ಮಾಡಿ
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ಯಾರ್ದು ನೀವು ಬಂದಿದ್ಯಾ ಮೇಡಮ್?
ಬಂದಿದೆ. 35,003.
ನೋಡಿಸ್ಬಿಟ್ಟು ನಾನು.
This is an offense under section 66, 66C, 60CD of the IT Act, and also 408, 419, 420, 465, 468, 471, and
ಯಾಕೆ ಈಗ ಅರ್ಜೆಂಟು?
ಈಗ ಅರೆಸ್ಟ್ ಥ್ರೆಟ್ ಇದೆ.
ಥ್ರೆಟ್ ಏನಿದೆ? 2021 ಚಾರ್ಜ್ ಶೀಟ್.
ಮಂಡೇನ ಚಾರ್ಜ್ ಹಾಕು.
Charge will be framed. 1 additional SPP, 2 emergent notice. PDO complaint.
ಹೌದು.
2
ಇನ್ಫಾರ್ಮೇಶನ್, ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಫಾರ್ಮೇಶನ್.
2 emergent notice. The concern list the matter on 10th January in the fresh matters list. The concerned court shall defer its act of framing of charges till the next date.
ಮಚ್ಚು.
Heard counsel Veerabhadraya. ಬರ್ಕೊಂಡಿಲ್ಲ, ನಾನೇ ಹೇಳ್ತೀನಿ, ಚಂಬರ್ಲಿ ಹೇಳ್ತೀನಿ.
Office objections may be overruled, my lord.
Party in person ಇದೆ. Yes. Office objections over. ಯಾಕೆ overruled?
Only the prayer part.
ಆಯ್ತು, overruled.
Please.
6 objections ಇದೆ ವೀರಭದ್ರನವ್ರು. ಸುಮ್ನೆ 5 ಮುಖಾರಲ್ಲಿ overruled ಅಂದ್ಬಿಟ್ಟು. Office objections be complied with by the next date.
Humble submission, my lord. My lord, I have filed this criminal petition 13613 of 2020.
For what purpose?
My lord, mainly I require interim maintenance, my lord.
Interim maintenance.
Interim maintenance application, last time there was direction given by this honorable court, which was rejected by the lower court.
Madam, that should be challenged in GMFC, madam, not here. Last time also I told you, you should go before the correct court. I have no jurisdiction to say so. It is not, see, officers raised objection with the maintainability. It won't come before me. You can't choose the court. It has to go before the court which has jurisdiction. I will post it tomorrow itself, you go before that court.
My lord, domestic violence also go.
All maintenance case there only, madam.
Okay.
Which is,
My
this is
lord-
maintenance, right?
No, this is domestic violence case.
Domestic violence case.
Violence case, my lord.
1 minute, madam, let me see.
So, the rejected orders, certified copies I have filed here, my lord. It is page number 85 to 111, my lord.
Yes, what meant, 1 minute, 1 minute. Yes, madam, what maintenance? ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅನ್ಬೇಡಿ, correct?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇತ್ತು. The property was in the name of the husband. She insisted that half of it should be transferred to her. It was transferred in her name. Afterwards, when he was about to go, he is a diploma holder. ಏನೋ ಒಂದ್ ಕೆಲಸ ಸಿಕ್ತು, ಜಪಾನ್ಗೆ ಹೋಗ್ತಾ ಇದ್ರು. ಸ್ಪೆಷಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ತಗೊಂಡು she has sold it for 1,20 lakhs in those days and purchased an apartment in her name, and rest of the amount also she has kept it to herself. He has nothing now.
All right.
And a child
Where is
there.
the order? There is any order of the court for maintenance?
My lord,
What did you do with the money that you sold the
my
property?
lord, whatever they are telling is lies, my lord.
Lies?
Because I'll show you the agreement, my lord. Agreement which is executed by the respondent with me, my lord. Page number 559 to 564.
559.
564, my lord, because typed copy I have filed in page number 564, my lord.
Maintainability in respect of office 13. Yen maintainability madam idu 134. Last time, which court directed you to, which court directed maintenance to be paid to you?
Kerala court, my lord.
Kerala court.
Kerala magistrate court, but.
If Kerala court has directed, how can
No,
I
and
direct
my lord, humble submission.
implementation of that order?
Yes, I have not pressed that memo because we relocated here, my lord. I will also tell the reason why he forced us to relocate here, my lord.
Now,
So-
no, madam, which is the case pending before which court where you have sought maintenance?
The domestic violence case pending before MMTC 2, my lord. That is also
where
called as
MMTC 2 court, what has it done with?
judicial first class magistrate.
That's all right. Which is that, what order has been passed by that court?
That page number 85 to 111, my lord.
Against that
85 to?
appeal lies, my lord. Domestic Violence Act, appeal lies.
What order, madam? Madam, you have to approach the revisional court by challenging that order which rejects the order of maintenance. You should go to the sessions court and then file an appeal in that, then come to the revisional court here. I have no jurisdiction. That's the
My
whole
lord,
problem.
because already directions has been given by this
No,
honorable
madam,
court.
what happens is I have myself held that against orders rejecting or granting maintenance, I have no jurisdiction. In the sense, the appeal should be filed under section 29. Only then, that is the office objection with regard to maintainability.
Because last time,
I will permit you to file appeal before the revisional court. After that, you can come here.
my lord, because in this order, the lower court judge is also challenging that there is no domestic violence exist, there is no cruelty. That I wanted to come and show before this honorable court, because my lord, the earlier order which is passed by another court, that is a Kerala court, a family court, that order, the judge himself has stated that the respondent has violated the settlement agreement, my lord. Because when I go with the 2-3 courts matter, the sessions court may not be in a condition to take up that, my lord, because the court which has a jurisdiction over 2-3 courts will be in a better position, my lord, to hear the matter and to give an order, my lord. Right now, I am only pressing on interim maintenance because.
We'll do one thing. This, we'll post it on Tuesday.
After vacation, my lord. I'm going out of station.
My lord, I am in a very need of interim maintenance, my lord. A small child is also.
I know,
7.
madam, but without hearing them, it is difficult.
My lord, kindly hear the matter.
No,
Only
which
the
I
maintenance.
cannot for the first time grant here. Where is the order of rejection of maintenance?
Yes, my lord.
Which is that,
Page
madam?
number 111, my lord. Page number 109 to 111.
What is the reason for not granting
It
maintenance?
is mentioned that subject to she has been 111
it's
section
here.
8
Wait.
the last phase of the 8 I will read, my lord.
1 minute, madam.
Petitioner was ill-treated and subject.
1 minute, 1 minute. ಏನು order ಇದು? It gives no reason. Madam, gives no
Actually,
reason at all.
Rajanish versus Neha, they have to file the assets and liabilities.
Let them file.
She is not
It
giving
is
the
already
bank
filed.
statement.
It is already filed, my
The
lord. It
full
is here.
bank
Certificate.
statements has to be filed by
If
her.
this is the order, this cannot sustain even for a minute.
She
There
has
is no reason at all.
125
My lord,
also
and
she has
I have
filed, that's
also
why.
his asset and liability affidavit, my asset and liability affidavit is
Now,
being
madam,
filed here,
1
my lord.
minute. I will direct the court, I will set aside this order, direct the court to reconsider your application for maintenance within 2 weeks. That is all the order can be passed here. Otherwise, no other
After
order can be
vacation,
passed.
my lord.
My
I won't
lord,
be in station after vacation, any day after vacation.
Any day after vacation. Illalla, I am setting aside this order and sending it back. There is no reason in this.
my lord,
But
and
I cannot directly grant here unless all the nuances of such grant are filed before the court. All right.
my lord, and another grievance, this honorable court has directed the court, all the IAs to be disposed within 5 weeks, my lord. Now 2 months are over, my lord. My so many
also-
IAs are pending, my lord.
That also,
My petition is pending.
I will direct that also to be done. All right.
My lord, and one more, I have filed a memo in this, this petition, my lord, to connect and club all the matters existing between the parties, page number 49, my lord. In that, one is.
Madam, I can't direct connection of domestic violence case with 125 or MC. Those courts have to consider those cases.
I submit only
My
one
lord,
thing.
all these cases.
4 cases have been clubbed because she had moved before Justice Sanjay Gowda for transfer. And that honorable court passed an order to club all the 4 cases. But domestic violence case was not transferred. Then they said, if you want, you get it transferred. She
Well,
has not
My
filed.
lord, it's a different issue she is talking. I am talking about the cases which is pending about Court Hall 18 in High Court, my lord. There are around 6 cases. In that 3 are disposed, 3 are still pending, my lord. Those cases, humble submission to connect and club, my lord.
Oh, that can be
We'll,
done. madam.
we'll send it back. Yes.
My lord, memo, I have written all the case numbers. Kindly connect and club all the matters, my lord. Today only,
Today only you want?
No. Today I have serial number 70 and 71. Those IAs I have filed in the disposed matters, which the case she has filed in that also disposed one. I wanted to club, my lord.
I
And
withdrew
for
the
one more humble submission, my lord, before this honorable court, that she page number 64 to 74, my lord. She has filed one petition, my lord, that is criminal petition of 4780, which is disposed by this honorable court, my lord. In that she concealed one case filed by them, my
If
lord.
you give me 5 minutes, I will pass the order. Right? Yes. Anyway, madam is back. Wapas kar sidra. The petitioner in person is knocking at the doors of this court, seeking quashment of several orders passed. In effect, the order dated 31/10/2024 is what is under challenge. The petitioner is the wife of the first respondent. One respondent, huh?
No,
You.
4.
You have given 3 residences,
Yes.
all right, of the respondent. She is seeking maintenance at the hands of the husband. an application is filed in criminal miscellaneous 99 of 2024, where the petitioner had invoked the provisions of section 125 of the CRPC seeking domestic violence.
Domestic violence.
Where the petitioner had invoked the provisions of section 12 of the Domestic Violence Act and had filed certain applications seeking interim maintenance under section 20 of the said act. The concerned court on 30/10/2024 passes the following order, page 109 to 111. The petitioner is at the doors of this court challenging the said order on the score that the concerned court has not directed maintenance to be paid to the petitioner and her child, which is born from the wedlock of the first petitioner and the respondent. The learned counsel appearing for the respondent would, however, dispute the position that the petitioner is wanting any maintenance and also contends that the petitioner has not filed the statement of assets and liabilities as is required by the apex court in the case of Rajneesh versus Neha. The petitioner would dispute the position to contend that all the affidavits are filed before the court. Therefore, there is a dispute with regard to the filing of the assets and liabilities statement by both the petitioner and her husband. Be that as it is, a perusal at the order dated 30/10/2024 does not indicate it takes into consideration all the submissions made by the petitioner in the application seeking maintenance, nor considers the objections of the husband, nor considers the objections filed by the husband to the application seeking interim maintenance. But the order is passed, which on the face of it bears no application of mind. Therefore, the order is unsustainable and the application of the petitioner requires reconsideration at the hands of the concerned court in Criminal Miscellaneous 99 of 2024. I am not remitting the matter, I am not directing the petitioner to approach the appellate court in under section 29 of the Act for the sole reason that the present order bears no application of mind. Before the concerned court, I direct that the petitioner and the respondent, husband, shall file their respective assets and liabilities statement up to date, even if it has been filed up to a certain date earlier. The concerned court shall take note of the assets and liabilities statement and determine the maintenance that is to be granted to the wife and the child, the present petitioner, petitioner number 1 and the second petitioner. In the light of what is being sought is award of maintenance, the concerned court shall endeavor to conclude the proceedings now remitted to it within an outer limit of 8 weeks, if not earlier. The learned counsel for the petitioner submits that there is an order passed by the coordinate bench of this court to club all the petitions.
Only 4 matters.
Club 4 petitions.
Total 6, my lord.
Total 6.
Yes.
Don't ask Kerala's clubbing.
No, here only I'm telling. 3 are disposed already. 3
How
are
can
pending.
disposed matters be clubbed?
My lord, I have filed IA because
For what?
She's asking for clubbing all the matters before your lordship. I did
No.
not.
That can't be done. The coordinate bench, the learned counsel for the respondent submits that the order to club all the cases between the husband and the wife is already passed by this court, which are 4 in number. Therefore,
For family court, at third additional family court.
Which are 4 in number pending before the third additional
Family court.
family court. Where this is there, I can't do that. Yes, so and so. In that light, since there is already an order to club all the cases and hear them together, I deem it appropriate. The deem it appropriate, direct the concerned court.
My lord, one more humble submission. Another 5 IAS also, the lower court has passed orders, which is also is a grievance for me. One, I have asked for an examination of impotency test. Even that is been rejected on the ground, page number 91, my
What?
lord.
Impotency test.
Yes, because she is simply coming and telling in the court, I cannot pray for nullity because child is there. The child is through donor sperm IVF treatment, my lord.
Oh.
And simply
Child
they're
is
harassing
through
me, my lord. This is
sperm
under
and
mental
donor.
cruelty, my lord. And
Both
I
is
have read a
donor.
lot of law, my lord. There is no provisions actually for this donor sperm IVF treatment and the pain a woman has been undergoing. I am humbly submission before the honorable court to pass at least a law.
I will direct the court to consider all the applications that are filed.
Even
by-
which has been rejected, my lord, because
What is rejected?
yeah, IA for impotency test is also rejected, my lord, and I have filed another IA which is for stay of proceeding. Anyway, they don't have jurisdiction. I think that is fine, my lord. And another one I have asked for rescission schooling of the minor chairman, because now I am the sole caretaker of the child, and I have IVF treatment complications. I have a lump in the breast and all that. I need to undergo surgery. So where I will keep the child? If the child should be put into a proper residential schooling, I can go and take medical help, my lord. 2 years my surgeries are pending, my lord, and I require money for the treatment also, my lord. And whatever they are telling is that they have actually alienated a joint property worth 4 crores, and Binami properties are purchased in his brother's name worth 6 crores right now, my lord. And I have also filed one suit in the civil court on after they disposed all my applications, my lord. First, I have not even one rupee I have taken from them, my lord.
ಅದಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ತಿರೋದೆಲ್ಲ ಬರ್ಕೊಂಡ್ರು. Yes.
So all my IAs been disposed, and my lord, the reason for rejecting, I have sought multiple release which is not permissible under Karnataka civil rules of practice is written. It is a criminal suit, my lord.
Criminal suit.
Yes.
Yes, madam.
And I have asked for
But-
protection and prohibition. In that also, let me read the order, my lord.
No, don't worry. I will direct the court to consider whatever you have asked. Yes.
If everything is rejected, from where I will get the relief, my lord. That is why I am humbly before
In
this
the next
honorable
court, GMFC. Yes.
in domestic violence case also.
After vacation.
My
No,
lord,
I will now direct. If you don't get the relief after vacation, you can come.
in
Not
GMSC.
to this court, to another court.
Okay.
Then you will go and tell that court saying that this court in court all 17 told me to come here.
My lord, I told like that. I think you
That
are
is
saying
what
that we-
He has
the
already told.
Learned judge was asking, why did you send the petitioner here?
Justice Nagaprasanna,
Ah.
sir, has passed orders without issuing notice. Why these courts are issuing notice to the other side?
But I have never asked to see.
That's all.
What
So
she told.
bad.
She's defaming me, my lord.
No, don't worry.
Defaming, I am.
Don't worry about.
I never
Gold
use the
medalist.
word of somebody, my lord.
It's a
It is not
gold
my habit.
medalist in
Don't
MSc
worry, madam.
nursing.
Even if you have used, don't worry. Yes.
Nobody can defame her.
And my
She's a
lord,
gold
whenever I
medalist.
come to the high court,
Why
somebody is
are you
taking
getting-
videos and putting it in
Don't
the
get
YouTube, my
into
lord.
the shoes of the husband. Leave it.
And no,
Yes.
I don't even talk.
Ah,
at all.
yes.
My lord, whenever I argue a case, somebody is putting it in the YouTube, giving me some cashy headings
Cashy?
for that. Yes, my
Ah.
lord. And they are defaming me through that also, my lord. When I went to give a police case, they are not even giving me a receipt.
No, don't worry about it. Now I have passed an order. Then it is further directed. The learned counsel for the petitioner at this juncture submits that there are various applications pending before the concerned court which are yet to be considered and necessary orders will be passed. If that be so, the concerned court shall also consider all those applications which are pending as on today before the concerned court in accordance with law, without any further delay, within the time limit that is stipulated for passage of the order that is now remitted to the hands of the concerned court, ordered accordingly.
My lord, other than IA number 1, the maintenance, other all the application which
I
is
have told madam, all applications that are pending today will be
no,
considered.
which is rejected also, my lord.
Rejected, you have to challenge that before GMFC.
GMFC.
Okay. ಅಯ್ಯೋ ಅಲ್ಲೋಗಿ ಅದನ್ನೇ ಹೇಳ್ತೀರಿ JMFC ಕಳಿಸ್ತಾರೆ. ಎಸ್.
My lord, one more thing, they have filed one more case after dismissal of their one case, my lord. That I want to bring the notice of this court, my lord. My lord,
ಎಸ್. Yes, tell me, madam.
the criminal petition 10951 of 24, they have filed. 3 months back, this honorable court, a similar petition has been disposed, my lord. Again, they have filed.
So what? They will file.
And they have also concealed the property case which they have filed against me in the city civil court. They want to send both me and the child into the street, my lord.
I've directed the court to pass orders within 8 weeks. If they don't pass the order, JMFC court, you can go. All right?
Okay.
I've disposed this petition now.
And the petition which is filed by them, that is 10951 of 24.
That will come after vacation.
My lord,
There is no stay in that. That will come after vacation.
that is why I want that petition to be connected with this
You
petition.
have disposed this, madam. How can I connect it now?
This has been disposed.
Yes. This is disposed. I have directed the court where you have filed the applications to pass orders within 8 weeks.
My lord, if like last direction also was not completely followed, that is why I came this time.
No. This direction has to be followed.
If it is not followed, what can I do?
Come back.
Here only.
No. The other court. Yes.
GMFs.
Yes, ma'am.
Much obliged.
Yes. Thank you. ಶಶಿಧರ್, ನೀವು ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕಾ? ಬನ್ನಿ. ಫ್ಲೈಟ್ ಎಷ್ಟೊತ್ತಿಗೆ?
ನಾಳೆಗಿದೆ ಸ್ವಾಮಿ.
ನಾಳೆಗೆ?
ಅಲ್ಲ, ಇವತ್ತು ನಾನ್ ಕೂಡ ಊರಿಗೆ ಹೋಗ್ಬೇಕಾಯ್ತು. ಐ ಆಮ್ ಫ್ರಮ್ ನಾರ್ತ್ ಕರ್ನಾಟಕ.
ನೀವು ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕಾ?
ಐ ಹ್ಯಾವ್ ಟು ಗೋ ಟು ಮೈ ನೇಟಿವ್.
ನಿಮ್ ಫ್ಲೈಟ್ ಎಷ್ಟೊತ್ತಿಗೆ?
ಫ್ಲೈಟ್ ಇಲ್ಲ ಸರ್, ಐ ಹ್ಯಾವ್ ಟು ಗೋ ಬೈ ಬಸ್ ಮಿಲಾಡ್.
ಸರಿ. ಈಗ ನಿಮಗೆ ಟ್ರಾವೆಲ್ ಪರ್ಮಿಷನ್ ನಿಮಗ್ ಬೇಕಾ?
ಪಾರ್ಟಿ ಬೇಡ ಸ್ವಾಮಿ, ನನಗೇನ್ ಬೇಕಾಗಿಲ್ಲ. ನನ್ನ ಕ್ಲೈಂಟ್ಗೆ ಪೆಟಿಷನ್ return ticket on 14th January.
Yes, Shanti Bhushan.
I am not made a party.
You're not made a party, but ನಾನೇ ಅವರು ಶಾಂತಿ ಭೂಷಣ್ ಹಿಂಗಂದ್ರು. ಶಾಂತಿ ಭೂಷಣ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ಡು ಯು ಮೀನ್ ಅಂತ ಅದಕ್ಕೆ ಕರೆಸ್ತಾರೆ.
ಅಲ್ಲ, ಗೊತ್ತು ಸ್ವಾಮಿ, ಬಟ್ ಅವ್ರು ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ ಯಾಕೆ ಅಂತ ನನಗೆ.
ಯಾಕೆ ಅಂದ್ರೆ ಎಲ್ಲ ಸೊಲ್ಯೂಷನ್ಗೂ ಅವ್ರು ಬೇಕು ಅದಕ್ಕೆ. Whenever it is passport travel, he will bring about an immediate solution. That's why I get him.
Since he's got the return ticket, my lord.
Return ticket also.
Actually, he did not get the
Not
return
enclosed
ticket.
along
Now
with
he's
that,
got the return ticket.
The petition
Lordship, I put him on conditions.
ಕೊಟ್ಟಿಲ್ಲ, enclosed.
ನಾಳೆ ರಿಲೀಸ್ ಮಾಡಿ. ಬಟ್ ಯಾವಾಗ ಆಗುತ್ತೆ ಮಾಡಿ? ಫ್ಲೈಟ್ ನಾಳೆ ತಾನೆ? ನಿಮ್ ಪಾಡಿಗೆ ನೀವು ಊರಿಗೆ ಹೋಗಿ. ಅವ್ರು ಬೆಳಗ್ಗೆ ರಿಲೀಸ್ ಆಗುತ್ತೆ, ಈಗ ಆಗಲ್ಲ.
ಆರ್ಡರ್ ಇಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಆರ್ಡರ್ ಆದ್ರೆ ಆಗ್ಲೇ.
ಅಟ್ಲೀಸ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲ, ಆರ್ಡ್ರೇ.
My lord, some condition may be imposed.
What condition? They should be trunk song?
United States ಗೆ ಹೋದ್ರೆ ಮತ್ತೆ
United States ಹೋದ್ರೆ ಬರೋದೇ ಇಲ್ಲ.
I am producing the
ಜಾಬ್ ಅಂತ ಹೋಗ್ತಾರೆ, ಒಳ್ಳೆ ಜಾಬ್, ಒಳ್ಳೆ ಸ್ಯಾಲರಿ ಸಿಕ್ಕರೆ ಅಲ್ಲೇ.
ಯಾರು ಕೊಡ್ತಾರೆ ಜಾಬ್ ಅಲ್ಲಿ? ಇರೋರಿಗೆ ಕೆಲಸ ಇಲ್ಲ ಅಲ್ಲಿ, ಇವ್ರೇನ್ ಜಾಬ್ ತಗೊಂಡ್ರು?
ಅಲ್ಲಲ್ಲ, ಅವರು ಜಾಬ್ ಡೀಟೇಲ್ಸ್.
Employment in US is not as easy as it used to be.
ಅಲ್ಲ, ಅವರು ಅಪ್ರಿವೇಟ್ಲಿ ಜಾಬ್ ಗಾಗಿ ಹೋಗ್ತಾ ಇದೀನಿ ಅಂತ ಹೇಳ್ತಿರೋದು.
ಸರ್ಚ್ ಇದೆ,
ಜಾಬ್ ಸರ್ಚಿಂಗ್ ಇಲ್ಲಿಂದಾನೆ ಸರ್ಚ್ ಮಾಡಿ. ಇಲ್ಲಿಂದಾನೆ ಸರ್ಚ್ ಮಾಡಿ.
One of his friend is working there. Condition may be imposed. Within 14th, I already return tickets. We will come back. Condition may be imposed. Within 14th, I will.
What is the offense?
384, my lord. Already case against A2 is quashed, my lord. Case against A2 is quashed by the lordship, my lord.
My lord.
For what reason you want to go? Searching for a job ಅಂದ್ರೆ online you can search.
ಅಲ್ಲ, ಒಂದು ಪ್ರಾಜೆಕ್ಟ್ ಇದೆ.
ಈ ಕೆಲಸನೇ ಇಲ್ಲ, ಯಾವ ಪ್ರಾಜೆಕ್ಟ್ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಬೇರೆ ಒಂದು ಪರ್ಸನಲ್ ಪ್ರಾಜೆಕ್ಟ್ ಇದೆ.
Personal project in United States?
Yes. With some
does not inspire confidence.
January 14th you return, my lord. January 14th you return, my lord. Subject to condition.
Affidavit of itinerary affidavit ಎಲ್ಲಿ?
Produced already.
ಅಲ್ಲ, itinerary ಎಲ್ಲಿ? ನೀವು ಹೋಗೋದು ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಎಲ್ಲಿರ್ತೀರಾ, ಯಾವಾಗ ಬರ್ತೀರಾ? ಅದಕ್ಕೆ ಶಾಂತಿ ಭೂಷಣ್ ಸರ್ ಕೇಳಿದ್ ನಾನು. ಅವ್ರಿಗಾದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತು, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಏನ್ ಬೇಕು. ಫಸ್ಟ್ ಟೈಮ್ ಟ್ರಾವೆಲ್ ಮಾಡಿದಿರ? ಫಸ್ಟ್ ಟೈಮ್
ನಾನು ಈ ತರ ಮಾಡಿದ್ ಫಸ್ಟ್ ಟೈಮ್.
ಈ ತರ ಮಾಡಿದ್ ಫಸ್ಟ್ ಟೈಮ್.
14th you return, my lord.
ಇಲ್ಲ
We'll undertake, madam.
ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್. ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ನಾಳೆ ಬೆಳಿಗ್ಗೆ 10:30 ಮೂವ್ ಮಾಡಿ, ಆಯ್ತಾ? 2:30 ತಗೊಂತೀನಿ. ಬೈ ದೆನ್ ಯು ಮೇಕ್ ಹಿಮ್ ಅ ಪಾರ್ಟಿ, ಕಾಪಿ ಒಂದು ಕೊಟ್ಬಿಡಿ. ನಾಳೆ ದೆನ್ ಅನ್ಹಿಂಡರ್ಡ್ ಟ್ರಾವೆಲ್ ಅವ್ರ ಅಫಿಡವಿಟ್ ಐಟನರಿ ಎಲ್ಲ ಹಾಕ್ಲಿ ವಿತ್ ರಿಟರ್ನ್ ಟಿಕೆಟ್. ನೀವು ನಿಮ್ ಟಿಕೆಟ್ ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
Let him change the affidavit at least.
ಏನೇನೋ ಬರುತ್ತೆ.
It's a, that requesting that this honorable court may kindly hear
ನಾನು
the
actually
petition.
possible
today.
petition actually
Let him
already
change.
case against AOT was.
ಕೆಲಸ ಮಾಡಿ
That's why I.
ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ವಾ ಮಾಡ್ತಿರೋದು, ಅವ್ರಿಗೆ ಕೇಳಿ ಯಾವ ತರ ಮಾಡ್ಬೇಕು ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ನಾಳೆ 10:30 ಮೂವ್ ಮಾಡಿ. ಬಿಕಾಸ್ ಇವಾಗ ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಲಿಸ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಆಲ್ ರೈಟ್, ಅದಕ್ಕೆ ನಾಳೆ 10:30
Tomorrow I have to go to my, that's why.
ಯು ಹ್ಯಾವ್ ಟು ಗೋ.
I have to go to my native.
ನಿಮ್ ಕೊಲೀಗ್ ಯಾರಿದ್ರೆ ಹೇಳಿ.
But ಎಲ್ಲ vacation ಅಂತ ಹೋಗ್ಬಿಟ್ಟು.
ಯು ಆರ್ ಇಂಡಿಪೆಂಡೆಂಟ್.
I am the only person.
ಓನ್ಲಿ ಪರ್ಸನ್.
Everybody have government.
ಯು ಆರ್ ದಿ ಓನ್ಲಿ ಪರ್ಸನ್ ಗೋಯಿಂಗ್ ಟು ಓನ್ಲಿ ಪ್ಲೇಸ್. ಏನಾಗಲ್ಲ.
My senior colleague already went to Singapore, my lord.
ಸಿಂಗಾಪುರ್.
Yes, my lord.
ಓಕೆ, ಆಲ್ ರೈಟ್. ನೀವು ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಹೋಗಿ, ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ ನಾಳೆ ಅನ್ಲೆಸ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಇನ್ ಆರ್ಡರ್, ಐ ಕಾಂಟ್ ಡೂ ಇಟ್ಸ್. ಅಂಡ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ಗೆ ಸುಮ್ಮನೆ ಹೋಗ್ತೀನಿ ಅಂತ ಇದ್ದೀರಿ ನೀವು.
ಇಲ್ಲ.
ಪರ್ಸನಲ್ ಪ್ರಾಜೆಕ್ಟ್. ಯಾವ ಪ್ರಾಜೆಕ್ಟ್? ಕೆಲಸನೇ ಇಲ್ಲ ಅಂದ್ರಿ, ಫಸ್ಟ್ ಕೆಲಸ ಹುಡುಕಕ್ಕೆ
ಜಾಬ್ ಹುಡುಕ್ತೀನಿ sir.
ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ ಅಲ್ಲಿ. ಇಲ್ಲಿಂದಾನೇ ಹುಡುಕಿ.
ಅಲ್ಲಿ already.
ಅಲ್ಲ ಜಾಬ್ ಹಂಗ್
14th I will return back.
Not there.
ಅನ್ಲೆಸ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಆನ್ ಎ ಜಾಲಿ ರೈಡ್.
ಏನು sir? ಏನು visa ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನು visa ಕೊಟ್ಟಿದ್ದಾರೆ? They've given tourist visa.
ನೋ ಸರ್.
Better.
I return by 14th, my lord. I'll file affidavit. I'll get.
ನಾಳೆ
After vacation, better he
Well,
doesn't go there.
ಎಲ್ಲಿವರೆಗಿದೆ
travel date, madam.
ವೀಸಾ? ಎಲ್ಲಿವರೆಗಿದೆ?
Visa 34 to 34 minutes, but I'm going.
10 years ವೀಸಾ ಇದೆ ಅಲ್ವಾ?
Yes, my lord.
ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಹೋಗ್ಬೋದು.
ಅಲ್ಲ already flight ticket ಬೇಕಾದ್ರೆ ನಾಳೆ ಕ್ಯಾನ್ಸಲ್
ಮಾಡಿ.
ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್.
ಕ್ರೈಮ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲ ಮಾಡಿ ಅಮೌಂಟ್ ಬಿಲ್.
ನನಗೂ ಆರ್ಡರ್ ಮಾಡಿ.
ಅಲ್ಲ ಅಮೌಂಟ್ ಆಗಲ್ಲ, ಅಮೌಂಟ್ ವಾಪಸ್ ಬರಲ್ಲ.
ಎಸ್ ಎಸ್.
ಅಲ್ಲ ಆಲ್ರೆಡಿ
ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30 ಮೂವ್ ಮಾಡಿ. ಎಸ್. ನಾವು ಒಂದಷ್ಟು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದೇವೆ.
ನಾಳೆ 2:30 ಬೇಡ, 7ನೇ ತಾರೀಕು
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡು.